30 and we are now going to start. So I'd like to introduce you to our two speakers for this Focus India of this morning. Amal Kumar Ganguri, Senior Advocate, Supreme Court of India in New Delhi. Not only a very senior advocate, but a great friend. We have known one another for many years now through the UIA, and Amal is the president of the UIA India chapter, which for us is very important. Also a former member of the executive committee of the UIA and a present member of the governing board, and former vice president of the Asian Society of International Law and executive president of the International Society of International Law of India. So a great expert of international law and an excellent arbitrator in international and domestic arbitration. We then have our colleague and friend Rupinder Singh Suri. Good morning, Rupinder. Wonderful. Thank you.
Good morning, sir.
For being here. Former president of the Supreme Court Bar Association and former president of the Supreme Court Advocate on Record Association. And at present, which is most important for us, since this is a UIA Italy chapter course, this is a 200-hour course, national representative of India for the UIA since the year 2019. So you are the person in charge of India for UIA Paris, and senior advocate advising central and state governments and in the public sector. And also I noted in your CV, Italian companies operating business developments in India. I think this is very interesting. And you've been advising the Italian Trade Commission in respect of operations in India, and a mediator and also an arbitrator. So absolutely wonderful curriculum. So I'm leaving the floor to you. I know that you're going to be speaking, taking turns. We have, and thank you, we have a very important PowerPoint presentation, and I understand that Manuele, thank you, Manuele, is going to put these slides whenever you decide we need them. Well, Rupinder and Amal, the floor is yours. Thank you. Thank you very much.
Thank you. Thank you, Carlo. It was so kind of you for the kind words and the introduction. We have been very good friends and we remain so. And it was thanks for your invitation to us to join in this great program, which you are organizing not only on behalf of the Italian bar, but also you are a great asset of the UIA. And you have held many, many important positions at the UIA, and you continue to serve UIA with your unstinted support. And thank you so much for organizing this program and for inviting us. It would be our pleasure to participate in this program. And if we can be of some help, we would be happy to contribute whatever we can. Now, Emmanuel, I would suggest that if you can, put up the slides one by one. So if we start, the first thing is up to the next page. I thought I would first like to give you a background about the legal framework in India, because that's the most fundamental aspect which you would like to know before we go into the nitty-gritties and the details of how to do business and what. So to start with, our fundamental document in the country, that the most vital document, which is the next page, the Constitution of India. Now, as you know, India became independent in 15th of August 1947, And with the passing of the India Independence Act by the British Parliament, two dominions, according to them, were created. One was Dominion of India and other was Dominion of Pakistan. India did not accept the Dominion status. The Indian constituted the new country, a Constituent Assembly. And finally, the Constituent Assembly adopted the Indian Constitution on November 26, 1949. And on that very day, a large number of provisions of the Constitution came into force, like citizenship, elections, provisional parliament, some temporary provisions, etc. The remaining provisions of the Constitution came into force with effect from 26th of January 1950. That is the time when the entire Constitution came into force. India became a sovereign democratic republic with the adoption of this Constitution. And Indian Constitution is founded basically on a federal principle. But unlike the American Constitution, which is the model federal constitution, we differ from the American model. We are federation in the sense that India consists of a central government, a center of power, parliament, and also the various states. The states have their own legislative body. And between the federal government, there is the central government, and parliament along with this, the lawmaking body, and the state on the other. Their relationship is governed by the Constitution. So we call it quasi-federal for the reason, if you go by the American standard, it is not an ideal federal constitution in the sense that the American Constitution, because of the history of that country, there the states came together to form the federation. And therefore the states gave that much power to the federation as they wanted to, while retaining the residual power with themselves. Indian history is not like that. The Indian states didn't come together to form the federation. India was under subjugation, as you know, for the British rule for a long time. And the territories which were under the administrative control of then British government called the British India Territory. So apart from the British India Territory, there were large number of Indian states. They were independent rulers. They had their independent laws. They have their independent customs. But they became part of India and they remain part of India on vital matters like defense, foreign policy, etc., etc. Now, with the Declaration of Independence, technically the suzerainty of the British government that seized even over these new states who were otherwise rulers by themselves, independent rulers. So they had the option to continue as they were, as independent rulers, or to join in the Indian Union. In fact, they debated and discussed among themselves, and eventually they all came together to form what we have now today, an integrated India, ruled by rule of law and the Constitution of India. So that is how our Constitution is today. Constitution adopts the parliamentary form of government, and along with the parliamentary form of government, the supremacy of the parliament is also recognized in the Constitution. The representatives of the members of the parliament and the state legislative assemblies, they are chosen based on the universal adult franchise. That's the fundamental feature of our Constitution. Next slide, you will get what the preamble to the Indian Constitution declares to be the objectives of the Indian Constitution. And here you are. The preamble declares that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to its all citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. This was the constitution which was adopted by the Constituent Assembly on the 26th day of November 1949 and given unto the people of India. So that is the core objective that the Constitution seeks to achieve. Now, all of you know that the United Nations post the Great War, the Second War, adopted the Universal Declaration of Human Rights and also recommended every single nation to adopt and implement those rights because the United Nations considered those to be fundamental to the existence of human life on this earth. India, since it formulated the constitution, it had the advantage of the declarations made before, shortly before. So it adopted a large number of those declarations and they were incorporated into a chapter that is part 3 of the constitution, which contains the fundamental rights. And next slide, you will get to know briefly how the constitution recognizes these fundamental rights, what kind of these rights are. So I've categorized them into 2. If you look at on the left-hand side column, all these rights are available to citizens and aliens alike. So everyone who happens to be in India, whether he's a citizen or an alien, would enjoy these fundamental rights. The only exception is an enemy alien. Now see these rights which are conferred. Article 14, equality before the law and equal protection of law. Most fundamental aspect of rule of law. Then Article 20, protection in respect of conviction for offenders. So this rule against double jeopardy is one of them, which is incorporated. Article 21 is again most vital, fundamental right. Protection of life and personal liberty. And the Supreme Court of India has, by interpretation, expanded the scope of life and personal liberty to bring in large number of aspects, including right to education, has been held to be part of life. Right to live with dignity is part of life. So it is not just the animal existence, is the question of protection of life, but with all these, right against non-interference. Then they are also reflected in other provisions. Article 22, protection against arrest and detention. You cannot do it except by an authority of law, etc. Article 23, prohibition of traffic in human beings and forced labor. Article 24, prohibition of employment of children. Article 25, freedom of conscience and free profession, practice, propagation of religion. Article 26, freedom to manage religious affairs. Article 27, freedom from promotion in religion. Article 28, freedom from attending the religious instructions or worship in certain educational institutions. Then you have certain rights which are enjoyed by the citizens, which are peculiar to them because of because they have to have certain rights vis-a-vis the state, and these rights are like Article 15, prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. 16, equality of opportunity in matters of public employment. So if the state is the employing anyone, then state is prohibited from denying this equality of opportunity. Article 19 gives a large number of freedoms to the citizens. The freedoms are freedom of speech and expression, freedom to assemble peaceably and without arms, to freedom to form associations or unions, freedom to move throughout the territory of India, freedom to reside and settle in any part of the territory of India, and freedom to practice any profession or to carry on any occupation, trade, or business. Article 29, protection of language, script, and culture and minorities. As you know, India is a vast country and we have very many languages spoken in our country. In different regions speaks different languages. Even within the region, there are different languages are spoken. All these are protected by the constitutional guarantees. Then Article 32 is one of the most significant provisions in the Indian Constitution. And it declares that the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. That is how the Supreme Court is known, the custodian of fundamental rights. Because anyone, even an alien whose rights are violated, if somebody is denied equality of opportunity or equal protection of laws, or his life or personal liberty is being affected by any illegal action of anyone, for that matter, he or she has a right to move directly to the Supreme Court for enforcement of those rights. This is one of the very, very salutary provisions in the Indian Constitution. And that's why the Supreme Court is called the guardian of the fundamental rights of the citizens and non-citizens. Go to the next slide, please, Manuel. Now, Constitution accepts and adopts the principle of separation of powers. There are three pillars of the Constitution. The legislative pillar, the legislature. Legislature has the power to make laws. It consists of the parliament at the central level and the states assemblies or the legislative assemblies and the councils at the state level. Then you have the executive government. These members of legislatures are all elected members. Then you have a non-elected governmental being. This is the executive government. They have the power to make policy decisions and implement the law. Now, how it works is the Prime Minister of India, along with his cabinet, they head the executive, but they remain answerable to the legislature, that is the parliament. So since the parliament is supreme, parliament has the power to regulate the activities of the executive, because the executive government exists as long as they enjoy the confidence of the people, of the legislature, the parliament. So the executive government should always ensure that they have the majority in parliament and they have the support of the parliament for every single action that they take. Because the executive action is not considered to be proper by parliament, it is possible for the parliament to negate such action and overrule and bring in some other, whatever the parliament thinks is appropriate. Then the third pillar of the Constitution, which is vital pillar, called the judicial pillar, Indian judiciary. The judiciary is responsible for adjudicating disputes, not just between citizens and citizens, citizens and non-citizens, individuals and individuals, but also the power to decide legality and validity of the laws and executive actions. So the laws made by parliament and the state legislature are amenable to judicial review and scrutiny by the judiciary. And it is open to the judiciary to declare a law if it offends the constitutional mandate that it is non-est or illegal or not valid. The judiciary has the power to declare a law to be illegal and not enforceable and not valid. Of course, judiciary has the power to interpret the laws. That is one aspect on which the Indian Constitution and our judicial system differed from the British, who of course now have a changed scenario. Earlier, Britain didn't have a written constitution. We of course have the longest written constitution in the world. We have 295 articles in the constitution. Britain had no written constitution until recently, but they have of late realized that they need to have a written constitution because Great Britain had also to adopt for themselves, what they give to the whole world, so many constitutions like a federal constitution. So the English constitution now is a federal constitution. They have the three independent units under the federation, England, Wales, and Scotland. And so it's really interesting to see how they are experiencing now, the British government, the British court, the Supreme Court of United Kingdom now, because after they have segregated from the EU, Supreme Court has become the final court of authority. Otherwise, they were subjected to the European jurisdictions on certain matters, at least. But anyway, they now have to follow a similar kind of mode that we have for all these years followed, and we have done it with great success. The significant features of judiciary, one more thing I want to tell you, that though the appointment procedure contemplates an appointment by the President of India, and obviously the President of India would mean on the aid and advice of the Council of Ministers, the judiciary has remained independent, because once the appointment is made, they are free, they are under no one's subjugation at all. They are not answerable to anybody, except their own conscience and their duties under the Constitution and the oath that they take as judges to perform their duty judicially, faithfully, etc. So that's one thing. And then, in order to secure their independence, the Constitution provides a very stringent provisions for removal of a judge. Now, if some politicians gather together and they find there's a judge who is inconvenient, they just simply cannot get rid of him by removing him from the office. So removal of a judge of the High Court or of the Supreme Court is a bit cumbersome procedure. It requires a certain number of initial signatures by the members of the parliament to initiate that proceedings. Then that procedure should go through the parliament. One should approve it. Then there will be a committee. The committee will go into the charge. There are certain charges on which you can decide, which have to be acts of misdemeanor. And then there's a special committee which would be of former judges and sitting judges. They would, on inquiry, find a report. The report will go to the parliament. That will be debated, and only thereafter the question of removal. So it's a very cumbersome and long-term procedure. It's not so easy. So that also secures the independence of the judges. Judges are not at the mercy of any government of the time that may be. That, and Indian independence of the Indian judiciary is quite often acknowledged and spoken to all over the world. And we take a lot of pride that we have such great institutions functioning under a democratic setup of our constitution governed by the rule of law. Let's go to the next slide, please. The broad hierarchy is this, that the highest court of the land, I won't call it apex because it's not the tip of a triangle, but it is the highest court of the land, the Supreme Court of India. It exercises jurisdiction which is of original jurisdiction, writ jurisdiction, appellate jurisdiction, as well as one very important advisory jurisdiction. Now it is open to Parliament to seek opinion or advice from the Supreme Court on a given matter if it involves a complicated constitutional issue. So even before enacting a law, the Parliament can, when it is proposing to enact a law, can seek advisory opinion of the Supreme Court. Supreme Court is not obliged to give an advisory opinion unless it feels also that the question which is referred to it is a true constitutional and legal questions. And it is necessary for the court to render its opinion in the larger public interest. Quite often it can happen that a political question, so to say, can be dressed up in a manner that looks like a legal issue, and one may take the courage of going to the court and say, okay, I'll take the decision from the Supreme Court, and preempt a political fallout of what the government is trying to do at a point of time. Supreme Court may decline if the issue really involves a political issue, because Supreme Court does not decide political questions. So it has the discretion to give its opinion, advice or not. But generally, it gives on legal issues, and Supreme Court is generally consulted only in very complicated circumstances. There have been quite a few occasions where the court has given its advisory opinion. As a lawyer, there's a very interesting scenario, and both Mr. Suri and I, we were now in a case where we are trying to suggest as to what is the scope of this advisory jurisdiction. See, the advisory jurisdiction, because it is advisory, the advice is not binding. Even in the government or the parliament who has sought that advice. Now, if that is the position of the status of the advice, it remains an advice. Does it have a precedence value? Can this advisory opinion of the court be invoked in an interstate dispute in a list between parties where the state may be involved as a party, individuals may be involved as parties, states may be involved as parties, this government, central government, state government may be at loggerheads, they may be, against each other. Can this advisory opinion be held to be binding in a list in any case? So that's a debate which is yet to be finally concluded. By and large, the view is that since it is advisory, it should remain as an advisory. It somewhat lacks that efficacy of a binding precedent. But what is important is, that's why I asked you this, gave you this question, next bullet point. A law declared by the Supreme Court is binding on all courts throughout the territory of India. And not just court, it binds everybody else. Because the Constitution declares that the law declared by the Supreme Court is the law of the land. And if that is the law of the land, then the executive government, legislature, as well as citizens, all are bound by such declaration of law. And it is also enjoys, being a court of record, the power to punish anyone who commits a contempt of the court. So that is inherent power that the court enjoys, because it's a court of record. Then at the state level, we have the highest court in the states are the high courts. They are called respective high courts of a particular state. Like, for example, if you talk about Punjab, High Court of Punjab, if we're talking about, Mumbai, but so it's a High Court of Mumbai, which is Maharashtra state governs. At present, we have 25 of such high courts. Some high courts are now, are common to two, like Punjab and Haryana. They are the neighboring states. They have a common high court. So the high court is named as High Court of Punjab and Haryana. Likewise, there are a few other high courts also which are common. We have another concept of, apart from the parliament state, we have another concept of what is called union territory. The union territories are those territories which are administered by the central government and for which there may be a legislative body or may not be a legislature. Like, for example, Delhi is a union territory. Pondicherry is a union territory. Now, these union territories are therefore have what is called a lieutenant governor, who is the administrator of, responsible for administration of that part of the territory, and who acts under the pleasure of the President of India, which means it will be the government of India. But there are many union territories which have legislative bodies, and they are given the power to make laws like any other state. For example, Delhi has a legislature, they make law. Pondicherry also has a legislature, they make law as well. But they are not, don't have the efficacy of that of a state. So they don't have all the powers that the other state governments enjoy. They have somewhat less subject-wise. That will come immediately, you will understand why I say so. Now, territorial jurisdiction of the courts, high courts, is coterminous with the territory of respective states. So the high court's jurisdiction is confined to that. But there is one interesting feature. If supposing in a litigation before one high court A, part of the cause of action arises in a state which is beyond the territory of the state in which High Court A is located, then that High Court A would have power to entertain that cause of action, grant relief, even against a government which is not part of its own territory. That means against a neighboring government, if the part of the cause of action has arisen from out of the neighboring state. There's a little complex scenario, but it happens. It has the power. I'm only giving you the width of the power. Then they also have original jurisdiction, writ, appellate, and most significant now is supervisory. Under the high courts, there are a large number of subordinate courts and tribunals. They function. Now, high courts have supervisory jurisdiction on district and subordinate courts and their tribunals under Article 227 of the Constitution. This is to keep all the subordinate courts within the bounds of law. The High Court's jurisdiction supervision is with a view to ensure that all subordinate courts remain within the bounds of law and they do not flout. So if there is in exercise of a jurisdiction, or if a court has no jurisdiction, but it chooses to exercise jurisdiction, the High Court can, in exercise of its supervisory power, interfere and nullify that order by saying that you have no jurisdiction, so don't interfere. So you don't have to go through the hierarchy of first decision on merits, then going up in appeal and further appeal, etc. It could be short-circuited directly by appealing to the High Court that, look, you have supervisory power. This subordinate court has exceeded its power and jurisdiction. There is no such thing. High Court can correct that. Let's go to the next slide. This will give you the in a graphic picture of how the hierarchy of the courts are. As you see, at the highest is Supreme Court, below the High Court. Now, High Court exercises jurisdiction on all the subordinate courts. We have classified two metropolitan courts, which are all in the metropolitan city, but they are the similar kind of court like what you have in all the other other areas other than metropolis. So other urban areas and rural areas. You have district and session court first. Below that, there are two. One is civil side and the criminal side. Civil side, you have district judge, subordinate court, principal, junior, subordinate court. Right at the bottom is municip. In the criminal court, you have sessions court, judicial magistrate, and judicial magistrate second class. Then metropolitan, similar distribution. But one very interesting feature which I want to bring to your notice is, today we have under various statutory enactments, laws, which creates large number of adjudicatory bodies called tribunals. All these tribunals also come under the supervisory jurisdiction of the High Court. So we have mentioned here some of the names of these tribunals by their initials. So we'll go to the next slide. You will get the details of it. Yes. Tribunals, I'm giving an overview. First, the National Company Law Tribunal, NCLT. When you say quasi-judicial body means, it's a body which consists of judges and non-judges. But they exercise judicial powers of the state, because judicial power is vested in such body to adjudicate upon. But the most important distinction is, you have though people who do not have a background of law as a member of such body, along with judicial members, they have nothing to do with the government. These are all independent bodies. They are not under subjugation of the government. They are all independent judicial, quasi-judicial bodies, exercises their powers and functions in accordance with the law, subject to supervisory jurisdiction of the High Courts, and subject to any appeal from their orders as may be provided under the law under which they are created. The government's administrative control, they do not control their decision-making power at all. They're insulated from, you can say, the executive influence in that manner. Then you have the appellate tribunal, National Company Law Appellate Tribunal. This NCLT is generally headed by a retired High Court judge. NCLAT, Appellate Court, is headed by a sitting or a former judge of the Supreme Court of India. And as you know, today they exercise large number of very vast powers. They not only decide issues arising out of company law and all corporate affairs, but also a most important subject today, that is the law relating to insolvency. So issues like insolvency proceedings, etc., are now regulated and controlled by these authorities, NCLT and NCLAT. And we have what is called the we have Insolvency and Bankruptcy Code adopted in India, which is equal to any other countries' laws of insolvency laws, and we adopt all those provisions which are well known all over the world in every single country. And when I come to that, I will mention some of those features. Then we have what is called a National Greens Tribunal. Now, the environment law is a matter of grave concern for the country. So we have the executive government, Ministry of Environment and Forests. They are responsible for the executive actions and maintenance of the statute. But this is a specialized tribunal headed by a former Supreme Court judge, and experts in environmental sciences are appointed to man this National Greens Tribunal. And they decide all cases relating to environment protection and violation of environmental laws. And this is also this is original jurisdiction exercise, and only an appeal from this would lie to the Supreme Court. So it is a very, very well structured tribunal that is functioning today. Then we have what is called Income Tax Appellate Tribunal. That's also a quasi-judicial body. This decides cases of all direct taxes, and on questions of fact, whatever this tribunal decides, they are taken as final. Appeal, etc., lies to the High Court from the decisions of this ITAT on substantial questions of it. Can we proceed to the next slide? Yes. Then we have Competition Commission of India, CCI. As you know, the antitrust laws have such vital significance in every nation, because if you have to have a level playing field for all the businesses and also to afford protection to the consumers from being exploitations, you need to have, and we had, though it's a new act called Competition Commission of India, its precursor was an old antitrust law we had, but its title was something else. We called it the Monopolies and Restrictive Trade Practices Act 1972. So that law had stood the test of time. That law made two clear divisions. One was controlling the monopolistic trade of the businesses, and it restricted large number of activities. Subject to scrutiny only, they were allowed to expand beyond settlements. And the other part was the restrictive trade practices, which is what is all known as antitrust laws. But now we have the new version of it in the form of Competition Act of 2002. And this commission, CCI, is the first adjudicatory body. It's a quasi-judicial body. It's an independent of the government. It first decides, and then an appeal from the competition goes to National Company Law Appellate Tribunal. So this NCLAT, the Appellate Tribunal, decides very many subjects coming from different pockets. So we now have the Appellate Tribunal from the Competition Commission's order to go to the NCLAT. Then Securities Exchange Board of India, SEBI. Now this is a very important statute. They are the regulators of the security markets in India. Today, as you know, we will see it later. Indian capital market is in bonds, and there's a huge participation from the international world to the Indian capital market, is apart from FDIs. So the FDI is a capital market is a very sensitive market and a very large market. So the regulators for the capital of the capital market are the SEBI, Security and Exchange Board of India, and they found a large number of regulations they are formulated, and those are the ones which are guiding factors. We'll see some case study also. Then we have an appellate authority which specializes in securities, therefore this is called Securities Appellate Tribunal, SAT, SAT. It is again a statutory body established under the same Security of Exchange Act of 1992, and it disposes of appeal from the order of SEBI. Then the insurance sector, Mr. Suri will take you through the development in the insurance sector. This was until recently, the insurance sector was not fully open. It was capped up to 49%, but currently the government has opened up hugely. That Mr. Suri will tell you how much and how they've done it. So for the insurance business, there is a regulator, and that regulator is Insurance and Regulatory Development Authority of India. The task is basically to see that there are no aberrations in the set of principles which are we should govern in fairness in offering insurance policies, their enforcement, etc. And the appeals from this goes to the appellate authority under the Security Rules Act, and this is the side. Then you have another specialized tribunal, which is called the Customs Excise Service Tax Appellate Tribunal, although excise is no longer a separate subject now, which I will explain to you later. It's called SISTAT. So they basically decide all cases arising out of adjudicatory proceedings from the Customs Act and Service Tax Act, etc. This is the appellate forum. SISTAT is an appellate forum. It's a specialized judicial body, and appeals from this goes to the Supreme Court. Then telecom. Telecom sector is another very important sector in India, which is now open for to international competitions and investment. Suri will give you the packages. Telecom Dispute Settlement and Appellate Tribunal called TDSAT is again again a statutory body which regulates the telecom sector, but not in the sense of the policies of the government. So they do not do that. For that, the Telecom Regulatory Authority of India exists. So the tribunal decides the disputes with regard to issues that have arisen from out of the telecom regulatory authorities' decisions from time to time. Let's go to the next slide, please. Yeah. Then electricity. Now, this is also, as the infrastructure is going bigger and bigger in India, and India has become a large consumer of power sector. So electricity is now also privatized. To a large extent, large number of private players are here. And even if there are other agencies, Indian agencies who are into the infrastructure of generating power, the construction of power projects, etc., we have very large participation from all over the world. Of very many countries, they're coming and participating to build the power, plants in India. And this is one of the most booming and demanding sector. So to decide the issues of arising out of, they say, fixation of tariff, for example, that there is state level commissions under the Electricity Act, but they're free to decide. Then if there is a dispute, they go to the commission decides the tariff, and it's a quasi-judicial body. It remains valid for some time. Then if there are challenges to the decision taken by the commission, that goes to the appellate tribunal for electricity. This is also very significant appellate body. Then comes the most important, the GST appellate tribunal. This is one of the latest incorporation of the new tribunal under our legal system, because our GST system we introduced only in 2017. I'll give you the feature which comes a little later when you go to GST. So this is the tribunal, appellate tribunal, which decides appeals from the decisions taken by the GST board. Then you have Central Administrative Tribunal, CAT. See, there are a lot of cases which are generated on administrative side of the government. These are disputes basically between government employees and the government, between the employees of two sets of employees of the government, their seniority, their recruitment, their retirement, their other conditions of service, their packages, blah, blah. So those are the kinds of issues which are decided administrative matters. So they go to a centralized tribunal called Central Administrative Tribunal. Then you have a very significant statutory tribunal called the National Human Rights Commission, NHRC. This is also headed by a former, Chief Justice of India. Always they have been by a protocol, and they are created under the Protection of Human Rights Act, and they are the watchdog at the central level to ensure that there are no violations of the human rights, and if there be any, they take cognizance and proceed with appropriate actions, including investigations, etc., and how what measures to be taken to ameliorate the circumstances. Go to the next slide, please. As I told you, the federal structure is something like this between the division of powers between the central level and the state level. So you have at the central level, the legislature is the parliament, which consists of two houses. One is the Lok Sabha, there's the lower house, and Rajya Sabha is the upper house. Lok Sabha, the lower house members are elected directly by direct vote from the people. So direct election. Rajya Sabha is an indirect election. The state legislative assemblies, they elect the members of the Rajya Sabha. So that is how, this is to ensure a proper representation in parliament for every single state, depending on the kind of population ratio that they have in their own state, that gets reflected in the upper house of the Rajya Sabha. Then you have the executive government. The President of India heads, he is the head of the executive. Underneath him is below him is the Vice President. And of course, the Prime Minister heads the government and the Council of Ministers along with them. They have to enjoy the confidence of the parliament, and they remain in power as long as they enjoy. We have an office called the Attorney General for India. It's not an elected office. It is not a political office. But why I mentioned about Attorney General, that he is a person who, under the Constitution, is called upon to advise the government at any stage, including the parliament. So a person who is not a member, like the president is not a member of the parliament, but the president has the right to provoke the parliament, to call for an order, and to address the parliament. So the only other person who, being a not member of parliament yet, who has been given a right under the Constitution to address the parliament is the Attorney General for India. Likewise, you come to the state on the right-hand side, the state legislature. It composition is the state legislative assembly or legislative council. This is also, assembly is the lower house, council is the upper house. A similar picture as you have in the center. And then the state executive head is the governor, followed by the chief minister, the state ministers, and the council of ministers. And the state has again another constitutional authority in the state who is not a member but advises the assembly, is the Advocate General of the state. Constitution in article declares India, that is Bharat, shall be the union of states. So we are actually a country which basically is the union of all these states. The legislative powers between these two sources, two tiers of government, are distributed in accordance with three lists, which lists out the subject matters in the 7th schedule to the Constitution. There is one schedule called the 7th schedule that gives a distribution of the subject matters in list 1, list 2, and list 3. And the subject matters of legislation give the requisite, subject coverage on which the parliament and the state can make the law. They don't discuss the width of the law, but the subject matter of legislation. In the extent of the laws, the state legislature can enact law which will be enforceable and applicable throughout the state, but parliament can make law which is applicable throughout the territory of India. And one other important feature I'm not mentioning here, but parliament is also empowered to make law having extraterritorial operation. And there are a few important subjects on which parliament does exercise that power to make extraterritorial, its law operation extraterritorially, and that we will at appropriate time bring that up before you. So go to the next slide, please. Yeah. So the broad division is this, because there are a very large number of subjects mentioned there. Now, if you see first on the right-hand side, the Union list. Union is the parliament's list. This consists of 100 items. Now, originally it was 97, increased by new topic, on which parliament has exclusive power to make law. No state has power to make law on these subjects. And they include foreign affairs, defense, armed forces, arms and ammunition, atomic energy, foreign affairs, citizenship, extradition, railways, shipping, navigation, airport, airways, post and telegraphs, banking, insurance, stock exchanges, taxes on income, other than agricultural income, customs duty, to mention some of the important ones. Parliament also is very important, as I told you, as the residuary power to legislate on subjects not enumerated in the state list or in the concurrent list, including any tax not mentioned in either of those two lists. I given the constitutional provision. Now coming below that is the state list. State has 61 items now on which they have exclusive power to make law. And this includes maintenance of law and order, which is one of the vital subjects, police forces, healthcare, transport, intoxicating liquor, not intoxicated, it is intoxicating liquor, which is a substantial revenue earning subject for the state, land and land revenue, taxes on lands and buildings, taxes on consumption and sale of electricity, taxes on sale and consumption and sale of electricity, only the state can levy, it is an exclusive power. Taxes on agricultural income is again the state subject, and mineral taxes, mines and mineral taxes. That is another very important tax subject which the state has exclusively enjoyed. Parliament can make law on certain subjects, like it's basically if the state was to give up its right, so two or more states can pass a resolution requesting the parliament to make a law for themselves. Many states can join together and say, okay, you make, so that we want an uniformity in the law, and uniform law being followed in all these states. The parliament can then get into the state field and enact a law. Then come to the concurrent list on the left-hand subject. Concurrent list consists of 47 items. It includes transfer of property and other than agricultural land, education, contracts, bankruptcy, insolvency, civil procedure, contempt of court, drugs and poison, economic and social planning, trade union, labor, welfare, electricity, newspaper, and only tax entry is stamp duty. Now, the concurrent list is a subject on which both parliament as the state have the power to make law. But there is a big catch on this. If the state law and the parliamentary law overlaps on the same subject, then the central law or parliamentary law will prevail, unless the state law gets a special approval by the President of India. Very well. So then it becomes operational within that state. Otherwise, if the subject, both of them have the power to make law, parliament as well as state, but if both make law on the same subject, then parliamentary law becomes effective, unless the state law is reserved for assent of the president and the president gives his assent. So this is, broadly the legal framework under the Indian Constitution. under the next chapter, I'll just take only one slide and then pass it on to Mr. Suri.
Okay, can I stop you here, Amal? Because
Yeah.
thank you. I think first of all, I'd like to thank you for this introduction. It's been very detailed, very, very informative. And I can tell you that from the Italian perspective, of course, we are making comparisons. Going back to the constitution, I see you're very proud about your written constitution, but it's very advanced because in 1950, having prohibition of traffic in human beings. I mean, human trafficking is very advanced for the time in which it was approved. And so I think it's very important for us to understand that all these rights are included in the Constitution. I noted this role of the Supreme Court. A law declared by Supreme Court is binding on all the courts within the territory. So the role of the judiciary, which implements the laws enacted by Parliament. It's very interesting that way, the way it's set up. And looking at tribunals, I'm amazed to see that you have a national green tribunal, which sounds a wonderful idea. You know, in Europe, we are moving towards a Green Deal, but I don't think anyone has yet thought about national green tribunals. I mean, this is something that we should be learning from you relating to environmental protection and conservation of forests. This is very, very advanced. Again, from an Italian perspective, we understand regulators. We have authorities, so we understand the regulators for securities and the regulators for insurance. We understand tax appellate and all things that comparing, but and also the Central Administrative Tribunal, we have a similar situation in our administrative law. But there again, something that comes out is this National Human Rights Commission, yes. Which Italy does not have, for example. And this is again a wonderful suggestion. And another area you may not appreciate how interesting it is for us, but this issue of the union list, the state list, and a concurrent list, we have a similar situation. Of course, Italy is much smaller. We are 60 million compared to your 100 million. But we do have this problem of the concurrent powers of the regions as compared to the central state, which is governed from Rome. So this is very interesting to see that, for example, healthcare is on the state list and not on the union list. Exactly. For example, which is I mean, now in the, and I noted your comment on the UK that does not have a written constitution, and we are going to have a webinar organized by the Italian chapter of the UIA on Brexit, and I was just wondering whether the UK entering into a trade deal with India, because the European Union passed an FTA, a trade agreement with the UK last minute, sort of at the very end of December. So now we have this trade deal, and we need to look at it from a perspective of lawyers. And I would expect that then the UK will be trying, or has already tried, to negotiate a trade agreement directly with India. It's you know, times changes now. The UK is probably asking for a trade deal because India is such an important country. So just to come back to you and highlight how many important issues you've highlighted without even being aware that we have what we are looking at by means of comparison. I don't know whether anyone has any questions. I don't see any questions in the chat. If there are any questions, it's a good moment, but maybe not yet. Okay, well, sorry for interrupting, but I thought—
No, perfectly right. I was changing some other topic. So
Thank you.
I would not go on for long now, because I'll just introduce the next topic and hand over the baton to my friend Suri. So next chapter is on taxation system in India. Please go to the next slide. Yes, go to the next. Yes, I'll just take this slide and then my friend will continue on this. This I want to broadly tell you what the taxation, what does the Indian Constitution contemplates. You know, there's a declaration under Article 265, the mandate of the Constitution, that no tax shall be levied or collected except by authority of law. The significance of this declaration, Carlo, is that by any executive action, you cannot have a compulsory exaction of a tax. No. If you want to exact a tax, it has to have a backing of a law made by Parliament or by the state legislature, but not by any executive fiat, which is a fundamental protection against any compulsory exaction of money by taxes. Second, that taxes are levied basically by the central government, state government, and some taxes are permitted to be levied by local municipal bodies, but they also levies those taxes under an authority of a law made by the state governments. So the state legislature makes the law. Then see, these are the major taxes on the left-hand side. I've given you the broad features. Major central taxes are the income tax, central goods and services tax, customs duty, and integrated goods and services tax. These are major central taxes now. And major state taxes are state goods and services tax, stamp duty and registration, excise duty on alcoholic liquor for human consumption. These are major taxes of the state. And of course, land revenue, I've not mentioned, but land revenue is also a very good head of taxation for the respective state legislature. Now see the division on the right-hand side. The taxes I have put here broadly, as we all call the tax lawyers and judges. You have direct taxes and indirect taxes, and then there are divisions. But first, let me tell you, the Indian Constitution does not adopt a concept of a direct tax and indirect tax. The taxes are not classified as direct taxes and indirect taxes. Nor, unlike the US Constitution, the distribution of tax power between the federal government and the state government made on the basis whether it's a direct tax or it is an indirect tax. So the concept of direct tax and indirect tax is alien, if I may use that expression, to the Indian Constitution, because it does not adopt such a concept at all, constitutionally. But as you know, every economist would tell you, if you say this is the tax, he would say, okay, this is direct or indirect. Because from economic principles, you can determine where is the incident falling. If it is directly falling against individual, corporates, etc., you call it direct. If it is indirectly on such individuals or the corporates, you call it indirect taxes. But we have not constitutionally recognized this division, and the distribution of tax power is not based on that. But going by the economic principles as accepted and as they classify these taxes, you can say, for example, corporate tax, income tax, gift tax are the direct taxes. Then on the right hand side, indirect taxes are sales tax, value-added tax, goods and services tax, and excise duty. Now, each of these taxes, although I have broadly mentioned, we can't go into everything in so much in detail. Now, when you say indirect taxes, sales tax, generally we associate that sales tax is on the goods. No, it is on the transaction of sale. It's a transaction tax. Therefore, it becomes indirect. But if it is a customs duty, it is on the goods directly. That's the difference between a transaction of sale and a transaction with goods. Value-added tax is on each time a transaction of sale takes place. So there the tax component, the element of the base of the tax is the change in the value from transaction A to transaction B. That is what is great tax. Now, goods and services tax, I want to tell you, this is something totally new tax which has been levied And I'll come to that later. We have a separate chapter on that. I'll first request my friend to take over now and continue on the taxable income and income tax components, because that's the first one comes here under the classification. So, Mr. Suri, may I request you to please take over?
Yeah, please. Thank you, Mr. Ganguly. Great, yes. Can I have the next slide, please?
Yeah. Yes.
Before I begin, I must express my thanks to UIA Italy, to Florence State University, to Mr. Carlos, and 42 students, the consumers of knowledge. In these COVID times, in the black clouds that we are hovering around, these kind of ventures which UIA Italy is venturing in is kind of a silver lining for the growth of society and never let die spirit. My compliments, Carlos, for organizing this program. I have been to Turin, and I was vice president then of Supreme Court Bar Association, and we entered into sister relation with the Turin Bar and Supreme Court Bar Association. The next year, the delegation from Turin did come to Delhi, and we participated together, but thereafter the entire effort has not been fructified later on. Now, coming to the topic, my colleague Mr. Ganguly has very ably told about the various nuances of Constitution. In nutshell, the sovereignty in India is exercised not by any person other than the Constitution of India and by its various institutions. And therefore, this is the master norm or the master and grid norm which governs the entire country. The taxation is necessary because that's how the economy will grow and how you progress. Because whether it is individual, it is partnership, or it is a company, or it's a country, you have to grow, you have to produce, you have to save some element out of it, and you have to reinvest. And if you do keep reinvesting, the growth will take place. And therefore, taxation which is applicable by the center, by the state, by the municipalities, as Mr. Ganguly has already explained, it is only taken into account by very strict interpretation of fiscal laws. Constitutional laws, the rights are given very liberal interpretation. But as far as fiscal laws, that is the taxation laws are concerned, very narrow and specific interpretation is given in this. So there is a big difference between interpreting fiscal laws and constitutional laws. India has got 28 states. Each state may be equivalent to some of the European countries. We also have 9 UTs, and we have diversity of language and of various local conditions. Now, India being governed by constitution, it's really a remarkable thing. And since early 50s, this constitution is in place, and we haven't had to repeal our constitution even once, when our neighbors have had to do it time and again. The taxable income, as shown in this slide, it is levied as per the fiscal act of that particular year. It's called Finance Act, and the rates are given there. But the income which is taxed is not of that year when assessment takes place, but is of the previous year when things have taken place. Now, how do we produce things? We use capital, labor, land, worker, and entrepreneurship. These 5 factors of production combine to produce something in the country. And therefore, under section 14, we have the various heads of income, that is salary, salary, interest, profits, capital gains, and from any other sources. And also income is taxed if there is a business connection in India. So all income accruing or arising, whether directly or indirectly, through or from any business connection in India, or through or from any property in India, or through or from any asset or sources of income in India, or through the transfer of a capital asset situated in India, shall be deemed to accrue or arise in India. Therefore, distinction must always be kept about the previous year and the assessment year, because this distinction would be very vital in case you start doing business in India. Next slide, please. Now, individuals have the option to account for two kinds of accounting. One is the accrual basis, that is, moment the invoice is made, the accrual takes place, or an actual receipt basis. In India, most of the professionals follow the actual basis, because what you bill, you may get or you may not get. But this option is not available to the corporate world. They have to create the invoice on the basis of accrual basis, and accrual basis the taxation is also paid, and later on they can take credit if the money doesn't come. We also have a concept of advance tax payment under a certain condition, so that government starts collecting money right from the beginning itself by certain provisions like TDS, tax deducted at source, and advance tax payment. Next slide, please. Now, don't get bogged down with this complex chart which is there. All it means is that if you are a resident of India, and that will be determined by how many days you stay in India, say 182 days, then your income would be taxable in India. And if you are ordinarily non-resident of India, then yes, Indian income would be taxed, but the foreign income would not be taxed. So what is the status going to be? That's very vital. And you as an investor in India would decide how many days would you like to be in India and not a day more, so that your global income does not get taxed in India. So it requires detailed tax planning, but yes, under certain circumstances, you protect your global income, and in other circumstances, it gets added. You have to do the proper planning over here. And it goes by the number of days. Like in India, if you are for 182 days in a financial year, then you are resident. Yes, and then you are taxed on the your income. And if you are not in 182 days, then the next criteria is, and come down bottom, 60 days in the financial year or 365 days preceding 4 years. And similarly, on the right side, if you are in India for 729 days in preceding 7 years, the ordinary resident status would be there, and income would be taxed, but your foreign income may not be taxed. Now, just take a simplistic view that if you are resident, you have to pay taxes. If you are non-ordinary resident, then you don't have to pay the taxes on the foreign income. Next slide, please. I must give you background, because India is a socialist republic, and some or the other, the income was taxed at very high rate in the initial decades of the India's independence. So much so that the tax rate went as high as 95%. And we also had at that time the institution of estate duty. And if estate duty was taken along with the 95% rate of taxation rate, then almost the taxes came to 105% or 107%. So there was a big disincentive to reveal your income or to express your income, because the government will take away everything. But over a period of time, especially in 1990s, from 75 to 1990, we were following one particular regime where public sectors played a very major role. In 1990, the government, the Indian economy opened up and taxation started coming down. And since then, the rates have been coming down quite steeply. So if you look at the tax rates for individuals over here, you will find that the highest slab, only 30% is being taxed. And there are earlier slabs where taxation is far less. The next slide will show us about taxability of a company. Here, we would find that corporate tax in India is perhaps one of the lowest in the world. A company incorporated in India or has place of effective management in India, its income would be taxed in India for both Indian income as well as foreign income. And if a company neither incorporated in India nor has place of effective management in India, then Indian income tax is taxable, but foreign income is only taxable if income is earned received in India. Next slide, please. Now, the two kinds of assessment has been given in 2020 and 21 and 21-22. So this is the new tax regime which has come in. So highest tax is 25% and any other domestic company is 30%. So, but there is a surcharge applicable at the rate of 7% of such tax where total income exceeds Indian rupees 1 crore but does not exceed INR 10 crores and at the rate of 12% of such tax where total income is more than INR 10 crores. Health cess and education cess is applicable at 4% of income tax and surcharge. Now, figures can be quite boring, but they are very vital for doing business in India. Now, there are special rates in case for existing manufacturing companies, the tax rate is 25%. If there are no restrictions on nature of business, that is of manufacturing, then the rate comes down to 22%. And where new companies are come in and they are incorporated after 1st October 2019 and commence manufacturing on or before 31st March 2023, tax rate is only 15%. So remarkable decline in the tax rates. Where is 15%? Next slide, please. This is the slide that I was referring to. The latest incorporated company interest, the tax rate would be as low as 15%. Next slide, please. Now, if there is an old agreement before 1st April 76, the royalty or fees for technical service would be charged, tax rate would be 50%. And any other income accruing or arising in India would be 40%. There is a surcharge also. The amount of income tax shall be increased by surcharge at the rate of 2% of such tax where total income exceeds INR 1 crore, but does not exceed Indian rupees 10 crores at the rate of 5% of such tax where total income exceeds INR 10 crores. You will have to do quick mathematics as to what does a crore mean and what does a million mean and how are they correlated to each other. Now, next slide, please. We have the institution of double tax avoidance treatment because you are earning money in Italy also, you are earning money in India also, and so in other countries also. So each country has entered into, and about 85 countries have entered into double tax avoidance agreement. So when you pay tax in one country, you get the credit of the same in the other country and you are not taxed twice. So therefore, before doing business, one must minutely go through the letter and the small print of double tax avoidance agreements. Next slide, please. First time that I had been introduced the concept of limited liability partnership, it had not come into India, but I realized it when going to Italy, that you already have this concept of limited liability partnership. Thereafter, this concept has come into India and LLP is very much there. And most of the institutions, especially professionals, etc., are working under the banner of LLPs, because partnership entails unlimited liability in case something goes amiss. But LLP then protects you to the extent that it is limited liability pension also. So it's like a company, you get benefit of limited liability. And here also, the issue is the Indian income and foreign income. If control and management wholly in India, it's a resident firm or LLP, Indian income would be taxed, foreign income would be taxed. But if control and management partly in India, then it is non-resident, Indian income would be taxed. But if it is earned abroad, no taxation would be there. But if income is received in India, then taxation would be there. Mr. Ganguly, I think you want to say on GST.
Okay, before I do that, let me just say one word about LLP. You are lucky, you are right. Before, about 2 decades before, we didn't have the concept of LLP. In fact, Indian law firms, they were all acting as a registered partnership under our old Partnership Act. The Partnership Act actually restricted to only 20 members who can form a partner. So actually, I had an interaction with our government agencies like the Ministry of Commerce on the one hand, and the Bar Council of India on the other. So after my exposure to the European Union and US and other countries, so I brought with the notice that, look, we have now become a global player in the international world. We are part of WTO. We are part of WTO discipline, and we are part of all the agreements covered by the WTO. So it would be unfair if we remain maintain our status of the law firms to that of a restricted partnership firms as they were under the partnership law, and with no restrictions on the liability, because the Partnership Act did not restrict the liability. So that's how the concept was broached, and we got the Parliament to enact a law ultimately. Ministry of Commerce took the lead, and this was more needed for foreign firms to come and set up their entities. That was the first step for opening up of various sectors, including the legal sector. So if you didn't have the LLP, I doubt whether we would have had many international legal firms or organizations to come step into India. Though we have not fully opened up the legal sector, but in a way their presence is accepted, but a formal exemption or allowance would come, which is a subject matter pending consideration right now. Should come now. All preparations are done. I'm sure we will be able to tell you more about it. So we hope that change would come. But right now, on principles of reciprocity, the Bar Council of India has agreed to permit all, give all licenses to lawyers coming from abroad, provided you have a reciprocal, arrangement with regard to the Indian law firms and Indian lawyers. That's how the matter stands today. So you go to the next topic now.
Excuse me, Amal, you've touched, if I may interrupt you, but you've touched a very important point here about law firms, because I was still, my understanding was that effectively in India, you could not, a foreign law firm could not set up and practice in India. So that what you're telling us is that is changing, that there is an
That is changing. It's in the offering. But let me tell you a few things. For example, today, what is permissible is foreign lawyer, like you can come, you can appear in arbitrations, do your cases, and you can go back home. So you can appear in Indian arbitration proceedings. It is perfectly permissible. But if you want to set up a full-fledged practice, then you need a licensing. For that purpose, the Bar Council of India is right now agreeable to allow the licensing based on reciprocity. But the formal regulation disclosures have not come, but it is all in the pipeline, and I expect it to come very soon.
Thank you for clarifying that point.
Thank you. Now, please turn to the next slide. Yeah, GST, goods and service tax. If you go to the next slide, then this is just the beginning. Yeah, just remain there for a while. I would just give you the introduction to the subject and then request Mr. Suri to take over. It's important for me to give you the background of, see, as I've explained to you, in the our constitutional structure, as you've seen, there is parliament subjects, there are state subjects, and there are concurrent subjects. In the concurrent subject, there are no taxation except the state duty, so stamp duty, so you can leave that out. Between the center of the federal government and the state government, they distribute all the power of taxation. India being a vast country, and each state being sovereign so far as its own territory and the subject matters of legislations are concerned, each state was levying taxes in their own wisdom the way they like. So that created a big problem for many years. First was multiple taxation, multiple levies of similar nature. Now, if you have a transaction of sale, if the transaction of sale involves movement of goods from, say, from Punjab to Delhi, the earlier conditions was Punjab will say the goods are moving from my territory, so the movement of the goods have taken place as a result of contract of sale, wherever it might have been entered into the contract of sale. But since the movement commences from my state, I shall tax this transaction as a sales from Punjab. So Punjab will tax. Then the goods will move through Punjab, Haryana, etc., and ultimately land in Delhi. Delhi state would say, look, I am the final destination of the delivery of state. The goods have finally arrived in my state. So the transaction of sale is completed or concluded only in my state, so therefore I would tax it. So there were conflicts. Transaction is one, it is only one transaction, but the goods has moved from one state to several states to another state. Both will be claiming right to taxation on the same one single transaction. So that gives rise to harassment, that gave rise to multiplicity of proceedings, disputes, multiplicity of litigations, etc., etc., etc. And ultimately, the revenue also got affected, because if all the matters get jammed in the litigation, the taxation suffers. The state doesn't get its direct revenue, so they have to wait and hang on till the issues are resolved. That was one thing that was to be avoided. Second, even if there be no such conflict, each state was entitled to tax every time there is a transaction. So supposing a goods has come from Punjab, it has gone to Haryana for a fault. And somebody says Haryana, it takes a view, oh, I'm getting some good price, let me sell it off. So he sells it in Haryana. So Punjab has taken a tax. The second sale is taxed in Haryana. The goods come to Delhi. Again, another sale takes place in Delhi to someone. Delhi taxes it. So same goods now suffered 3 taxes as 3 different places. This also ultimately, the final consumer would be burdened with, for the same goods, 3 times taxes. So it becomes counterproductive for the transactions. Secondly, most important, under our constitution, the movement of people and goods is assured. Freedom, unrestricted movement. Constitution assures you that your goods, you can move and your goods can move unrestricted. Now the question is, if you levy taxes for every time you cross a border, are you not restricting the movement of the goods? And if that is so, then the question of free trade component of the constitutional guarantee gets completely infringed. So there were a large number of issues coming up. So everybody felt that, particularly after we opened up in the 1990s, as Mr. Suri told you, we needed to be competitive to the international world also, not only within our own country, but also to the international world, because our goods, export goods, will be valued much higher because of multiple taxations. So we wanted to be competitive to the international market as well. We needed to have a rational market and a rational tax structure in this country. So a long time debate ensued. Fortunately, the states and the center, particularly the finance ministers, after a debate and consultation for more than a decade, they came down together to accept, well, the state as well as the center would have to sacrifice their exclusive power of taxation, certain rights. Their exclusive power of taxation, they have to sacrifice both of them to allow an uniform tax regime being brought into force. Now, the most important component was central excise duty for the central government. That is the big earner. But excise, as you know, is a duty levied on the manufacturing activity of the goods. Sales tax is levied on the sale activity of that goods. So when you produce a goods, the production activity gets taxed by the center by levy of excise duty. The transaction aspect of their goods gets taxed at the hands of the state, being sales tax, levy of sales tax. And this additional excise and all, they're all in the nature of excise duty, but these are all additional taxes. Particularly these additional duties of excise are levied to as a counterbalancing duties, etc. Now, the major tax thing or concept change was from taxing goods and taxing income to this taxing services. Now, the service sector earlier, say about 20 years back, did not occupy a major portion of the state's GDP. The state's GDP was contributed by all other taxes. Service sector was never considered to be a money spinner or an earner. 20 years back, with the advent of the technology and the IT sector, there was a sea change in the concept of contribution to the GDP. India realized that the largest contribution makes is not from your direct sources of revenue, from goods, services, income tax, etc. No, those are all very small. Their contribution to the GDP is much smaller, less than 50. The largest chunk that contributes to GDP is the service sector, and all kinds of services put together, which were hitherto not being tapped at all. But because service tax as an element of taxation was not contemplated in the Constitution where it was adopted in 1950, Parliament alone had the power to levy such a tax under the residual power. As I told you, Parliament enjoyed a residual power in the distribution of tax list of distribution of legislative power. The residual power is vested only in the Parliament. So Parliament exercised that power and brought in a service tax element in 1994. It came by a financial, measure by a finance budget, 1994. Slowly and gradually, it came to occupy a very large portion of exceeding 60% of the national economy and the GDP. So the state said, look, our taxes on sales tax, VAT, octroi, luxury tax, purchase tax, they all put together would become a very small segment. So if you want a uniform structure, you got to give us a share on the service, because services are all rendered to the states as well. So give us a share on the service tax on which we can never levy. You have the exclusive power. So it was a kind of a give and take bargain between the state and the federal government. And eventually they agreed, okay, central government agreed very well. I'm prepared to give up my exclusive right of taxation on central excise. That is the excise duty on manufacturing. Additional excise duty, which is again a countervailing duty. Service tax also I'll give up. Additional customs duty, which is again a countervailing duty to imports. Special additional duty, that was in lieu of central sales tax. Searches and cesses levied by the central and by the center under the Central Sales Tax Act. So center agreed to give up all these rights. Then come the states. States' most important revenue, first revenue is VAT, value added tax, and the sales tax. That's the first thing. Second, octroi and entry tax. Now these are all, octrois and entry tax are actually, they block the movement of the goods. So if that is given up, you automatically ensure a free flow of the movement of the goods throughout the country. Purchase tax, luxury tax, taxes on lottery, gambling, entertainment tax, and surcharge and state cesses. All these, the states agreed to give up. So, as a matter of prudent bargain between the two sectors, emerged what is called the Goods and Services Tax Act, and how they have apportioned their rights from that levy is that on service and goods and service tax, levy would be one for the center, another for the state. So there were two taxes levied on goods and services, but equal. Rate is equal. And these rates are all finalized. Suri will tell you a little later. So on one single transaction, there will be central tax, there will be state tax, and that's all. And another important thing is important feature that this is a one-time levy. So at any point you have paid this tax, throughout the rest of the transactions, you can go on taking set off for that amount that you have paid. So the tax component does not go up with the number of transactions. Number one. So it is uniform levy at one go. Second, the entire system is based on e-billing. So you do a kind of electronic billing. You don't have, there are no stoppage, there are no octroi and entry tax. So no entry point stoppage of any goods. It is all highways. Once you put up the goods on the trucks, they move throughout the country from one end of the country to the other end, unobstructed. Paid taxes one, it will be realized at other point after giving the due regard, having given regard to the taxes already paid and taking a set off. This is the kind of revolutionary arrangement that I must compliment to our the leadership of the states, because they are the prime sacrificer, and central government agreed to that in the larger interest of the country. That is how we are able to replace in one stroke the entire lock, stock and barrel, these huge taxes of all kinds of obstructing features, replaced by one single uniform tax, that is GST. So Suri will now take you through the next of these slides. Can you go to the next slide, please? Yeah. Suri, you have to start from your next slide 28.
Yeah, I'm starting from there, sir. I'm just saying that how difficult it was to have the tug of war between the state revenue and the center revenue. And India has thereafter successfully implemented it. And India is better for that. Now, business under GST Act 2017 has been defined under Section 2 within bracket 17. Now, this is an inclusive definition and it covers 9 items. Firstly, trade, commerce, manufacture, profession, vocation. Then any incident or ancillary activity. Then any, whether or not there is a volume, frequency, continuity or regularity. Then supply or acquisition of goods, including capital goods and services. Then provision of facilities to members of a club association. Admission for consideration of persons to any premises. Services supplied by a person as the holder of an office. Services by a race club. And activities undertaken by the central government or state government or any local authority in which they are engaged as public authority. Now, because of the tug of war between the state and center and how to not get less revenue, on the right side, you will find that GST is not applicable on all goods other than the following. Firstly is alcohol, liquor for human consumption. This is subject matter of excise. Then 5 petroleum products, petroleum, crude, high-speed diesel, motor spirit, natural gas, and aviation turbine fuel. This is value-added taxation. So these are the exceptions where the states are playing a major role at this juncture and is holding on to their revenues. And in due course, center would be bringing that in its ambit also. Next slide, please. Interesting to note the tax rates under the GST regime. We have within GST 1300 goods and 500 services, and there are 4 tax slabs: 5%, 12%, 18%, and 28%. And there would be in fact 5 tax slabs in case we take the 0% on consumer prices baskets, including food grains. So for essential things, it is 0%. For slightly more essential things, it's 5%. For goods of usage is 12%. And then luxury goods are 28% under GST. Then 7% of items come under the exempted list, 14% of items attract a 5% tax, 17% of items attracts a 12% tax, and 43% of items attract an 18% tax slabs, while only 19% of items fall under the highest slab of 28%. The 0% tax slab consists of 50% of the consumer price baskets. So all these rates have been fixed by a common consensus between state and center, and it keeps revising and it gets updated from time to time. Next slide, please. The procedure under the GST regime, a simple process has been stated that if you are already registered under previous acts, such as VAT, excises, etc.
Mi mancano I primi 2.
Hello?
Yes, okay.
Yeah. So if it is already previously adjusted act such as VAT excise, then you have to register your business. You have to issue tax invoice. As Mr. Ganguly says, electronic tax invoice. Accounting for GST has to take place. Then tax return filing takes place. And wherever you have paid a tax, you get the benefit of input tax credit. And then you claim GST refund and then making GST payment by the center. So aggregate turnover exceeds INR 40 lakhs. It requires registration. Aggregate turnover exceeds INR 20 lakhs for, these are 3 states, the hill states where the amount is less turnover: Jammu Kashmir, Himachal Pradesh, Uttarakhand, and northeastern states, 4 of them. Then business specified under GST Act, irrespective of above stated conditions, and every importer and exporter has to register his business. Any business can be registered under GST by applying via the GST. This is all now electronically, GST online portal or a GST Seva Kendra set up by the Government of India. The success of GST experiment in India is very efficient IT platform which supervises and which doesn't let any deviation take place. Next slide, please. This is what Mr. Ganguly has already touched, benefit of GST. Minimum physical interference, there is no human interference, so it's all electronic. Compliance costs reduced due to the unification of indirect taxes. The indirect taxes have been reduced and they have been clubbed together. Then check over tax evasion through a robust IT-based administration. Now, this is the IT platform that I was referring to, robust IT-based administration, and then unified tax regime for both goods and services. And there is no cascading of taxes, and net, the final taxation amount is far lesser than the earlier amounts that was coming with multiple taxes at the state and the central level. This covers the GST topic. And next slide, set of slides, is with regard to foreign direct investment.
Okay, can I please, Rupina, just
please, sir.
Alert the audience, alert everyone, because this is an extremely important part you're going to go on to. So I do invite everyone in the audience to pay particular attention, because this is very, very special and specific of India. So let's go through it. I suggest you're probably spending about 20 minutes on it at least. Maybe after this this part, we might have a coffee break. But I do ask everyone to pay maximum attention, because this is very important when you're advising clients investing in India. Thank you, Rupinder. Sorry, but I wanted to make that.
Thank you, Mr. Carlos. Absolutely, you're right. This is important. And please, the next slide. The routing of foreign direct investment in India can be done in 2 ways. One is automatic route, that is, you don't have to take any permission, you can straightway invest. And other is government route, where the permission of government is required. A non-resident investor or the Indian company does not require any approval from RBI of India or Government of India for the investment. Now, this is a sea change from the earlier time, and for everything you had to take a permission. So government has laid down a policy of FDI that here you don't have to take permission at all, you can straightway do it. And through the government route, under the government route, prior approval of Government India is required under Indian Companies B. The governing policy that would be is the Indian Foreign Direct Investment Policy, which gets amended from time to time, looking at the needs of the country. A non-resident entity can invest in India subject to FDI policy, except in those sectors activities which are prohibited. There is a prohibited class of investment, which I will be touching little later. An entity of a country which shares the land border with India, or where the beneficial owner of investment into India is situated in or a citizen of any such country, can invest only under the government route. This is a development which has taken place because of the misgivings with China and the Indian concern of its own security interest and all that. So all the border states' permission has to be taken through government route. But these are only for the neighboring countries, not for any other investment. Then a citizen of Pakistan or an entity incorporated in Pakistan can invest only under the government route in sectors, activities other than defense, space, atomic energy, and sectors, activities prohibited for foreign investment. Department of Promotion and Industry and Internal Trade, that is DPIIT, is the nodal agency entrusted to formulate FDI policy. Next slide, please. Now, category 1 depicts the 100% FDI permitted through automatic route. Agriculture and animal husbandry, plantation, mining and exploration in metal and non-metal ores except titanium, coal and ignite mining, railway infrastructure, construction or development projects such as townships, residents, commercial complex, roads, bridge, hotel, education institutions. This would also include smart cities. Then transport services, then civil aviation, greenfield and brownfield. That is both development of civil aviation in the new airports and brownfield which are already developed. Then marketplace, e-commerce, pharmaceuticals, greenfield, that is already which is required to be developed, manufacturing, insurance intermediaries, financial services, industry park. Category 2 is 100% FDI permitted through government route. Mining and mineral separation of titanium being mineral and mineral ores. Retail trading, including through e-commerce in respect of food products manufactured or produced in India. Publishing, printing of scientific and technical magazines, special journals, periodicals. Publication of facsimile edition of foreign newspaper, satellite establishment and operations. And here you'll have to take specific permission. Category 3 is up to 100% FDI permitted through government route plus automatic route. So two vertical columns are given. Up in telecom services, up to 49%, it is automatic.
You have to change the
Through
slides.
government route, you can go above 49%, and there is no upper limit. It can go up to 100%.
When you ask for the
Defense
change the
industry
slide,
is up to 74%. You can invest in automatically, but above 74, you would require government permission. Pharmaceutical brownfield, you can invest up to 74%, but above 70%, you will be going to the government.
Slide.
we need to change the slide, yes.
Yeah, we need to change the slide.
Yes.
Oh, my apologies. My bolna beta.
Can you go by it again, Luki?
Yeah, I'll do that. I'll do that. My apologies. Category 3 up to 100% FDI permitted through government route and automatic route. Now, telecom services up to 49%, you can invest directly. You don't have to take any permission. But if you want to exceed 49%, government permission would be required. In defense industry, as high as 74% you can invest. That's a priority India is giving to defense industry. And above 74%, you need government's permission. Pharmaceutical brownfield, you up to 74% you can invest directly. And above 74%, again, we have to take government permission. Air transport services up to 49% directly can be invested. Above 49%, government's permission is required. Banking private sector up to 49% direct investment is there. Above 49%, up to 74%, government route is required, and no permission is given beyond 74% for banking. Then private security agencies up to 49%, and above 49%, up to 74%. Then category 4, FDI permitted through government route, automatic route. Insurance company up to 74%. As Mr. Gangli was saying, it has now been raised 74% from 49%. Petroleum refining by public sector undertaking without any disinvestment or domestic equities up to 49%. Then infrastructure companies in security markets up to 49% automatic route. Then power exchange up to 49%. Pension sector up to 49%. Now government route, requires uplinking of news and current affairs TV channel up to 49%, territorial broadcasting FM up to 49%, multi-brand retail trading up to 51%, banking public sector up to 20%, and print media publishing up to 26%, digital media up to 26%. Next slide, please.
Excuse me, can we, because this is quite, this is extremely interesting. Do you mind if I interrupt you?
Yes, sir, please.
We could go back and can we make some examples? I mean, like typically in the manufacturing area, so manufacturing of, for example, clothing, for example, or for example, motorbikes or clothing, or industry that involves construction of in the mechanical area. Would that be automatic route? I mean, could an Italian company?
It will be automatic route, except the multi-branding may have restrictions. But if it is single brand, it will be automatic. 100% investment would be permitted.
Okay, wonderful. And so the complication really is when you go into the mixed in these particular sectors such as telecom.
That's right, sir. And multiple branding.
Okay, then it becomes complicated, and so automatic up to a percentage, it's 49%, and from 49 above, it's government route. Okay.
Yes.
Now, is this a complicated route? In other words, is it a timely route? Does it require?
No, the government itself has set its time limits. So within the time limit set up, you will have your answers. Okay. There would be no practical interaction with any person, but it is all the IT platform which will be utilized, and you will get your answers faster than anything else you have ever imagined in India. Okay, so I imagine you typically you would require the services of a local law firm to assist in the red tape, I would guess, or probably yes. Yes, I have. Even if it was otherwise, I would still say yes.
Yes.
Now, yes. Now, this slide sets out what businesses are totally prohibited. One is lottery business, including government, private lottery, online lotteries, etc. Now, here I must bring it to your notice that in certain states, they are allowing this lottery business, and they are also allowing casinos, etc. in certain states. But by and large, lottery business is prohibited in India. And the distinction that Supreme Court has made is the game of chance not permitted, the game of skill permitted. So like bridge would be permitted because it's a game of skill. But purely games of chance may not be permitted. Then gambling and betting, including casinos, are prohibited, except I think perhaps for the high seas of Goa and Sikkim. Chit funds not permitted. Nidhi company, Nidhi is money company is not permitted. Then trading in transferable development rights, TDRs, are not permitted. Construction of farmhouses not permitted. Manufacturing of cigars, cheroots, cigarettes, and cigarette of tobacco or tobacco substitutes are prohibited sectors where permission has to be taken. Sectors not open to private sector investment. Atomic energy is exclusively not open to the private sector. Railway operations, other than permitted activities mentioned under the consolidated FDI policy. Foreign technology collaboration in any form, including licenses for franchise, trademark, brand names, management contract, is also prohibited. Real estate business in relation to construction of townships, commercial complex, roads, and hotel education allowed under category 1. So the farmhouses are prohibited, but the smart city construction and commercial complexes are permitted. And the reason for this FDI policy has come in because India is now focusing on manufacturing in India. And India wants to become the hub of manufacturing for the world, because this COVID experience has not been very good, because the supply of certain raw materials was totally stopped and it did not reach, not only in India, but abroad also. So it's not a good policy to just rely upon one source. It's better to develop alternative sources also. And what better than where the rule of law is there, the transparency is there, and strong judiciary is there. These are the positive things, and which would help in India grow faster and becoming a manufacturing hub. Next slide, please. Now, just a procedure set out that how one goes to the government route. Proposal for foreign investment along with supporting documents to be filed online on the Foreign Investment Facilitation Portal. So the format is already given there, it has to be filed there. No procedure prescribed for entry through automatic route. Then in internal process for approval, Department of Promotion of Industry and Internal Trade will identify the concerned ministry, department, and circulate the proposal within 2 days, and RBI for comments from FEMA perspective. So here is the time limit given. Within 2 days it will be circulated, and RBI permission would be sought. There is no time limit given to the RBI, but RBI would act as quick as possible. Then proposed investments from Pakistan and Bangladesh require clearance from the Ministry of Home Affairs. This is purely for security reason. Then proposals involving FDI exceeding INR 50 billion, approximately $775 million, shall be placed before the Cabinet Committee of Economic Affairs. So this is a high-powered committee which is empowered to take decisions quickly. Once the proposal is complete in all respects, the same gets approval within 8 to 10 weeks. So time frame is given, and these are the ideal time limits that government would like to follow. Now, in case we receive FDI, then what are the FDI reporting requirements? Next slide, please. Yes, these are the compliance for reporting requirements. Documents for form FC, GPR, foreign currency, gross provisional return, SMF, company secretary certificate, practicing in India, declaration by authorized representative of Indian company, LLP, pre and post shareholding patterns in the Indian company, copy of government approval if applicable, copy of order of High Court on the scheme of merger, demerger, amalgamation of applicable, RBI approval on amount of refund with respect to amount of the issue of applicable, valuation certificate, approval letters of non-compliant with the guidelines if applicable, relevant RBI approvals for issue of equity shares against funds payable to the foreign investors, the debit statement, know your customer requirements, and board resolutions. And within 60 days, you have to allot the shares. Within 30 days, you have to form FC, GPR that I mentioned already. As per RBI notification on foreign investments in India, reporting in single master forum of 7th June 2018 now provides for all extended reporting. So this master forum which came on 7th June 2018 is important. Now provides for all extent reporting. Structure of various types of foreign investments in India are now provided under single master form, which is required to be filled online. as per RBI notification, advanced remittance form of FCGPR is merged into single revised FCGPR. All new filings for the form FCGPR have to be done in single master form only. Filing for all forms, FCGPR, FCTR, LLP, various forms, convertible notes, employee stock options, and downstream investment have to be done in SMF. So these are the minimum forms which have to be filled in for government to take quick action.
Excuse
And
me.
that would complete this FDI topic, sir.
Thank you. Can I ask you, so the FDI reporting is regardless of the route, whether it's
That's right. That's right.
any kind of investment, whether through government or direct, automatic route or government route, they have to be reported.
It has to be reported, and there has been a history where money has come from abroad, but it has been misutilized by certain trusts, certain associations, certain societies. So government would like to keep a tight control on that, that money which comes here for a particular purpose is only utilized for that.
Okay. I'm wondering whether there are any questions. I don't know whether there's any questions on the chat, because I don't see any at the moment. I was going to suggest, I don't know what you'll feel, but I was going to suggest a coffee break, because we've had 2 hours now and you're probably exhausted, you and I see that we still have many very interesting slides, including a case study. So I hope we will have time for all this, because it's so wonderfully interesting. But may I suggest like 15 minutes of a coffee break for all of us?
That's great. That's great, Carlo.
Is that acceptable? So for CET time, it's now 12:37. So I'm going to suggest we reconvene at 12:55 Italian time. That's 15 minutes, just over 15 minutes, about 17 minutes. Is that acceptable for you?
Yeah.
Okay. So thank you ever so much. This has been extremely informative and interesting. And we'll leave it to the next slide is highlight of budget. Thank you, and we'll be back then in 17 minutes time. Thank you ever so much. Time is out, and we should be ready to start this second part of this session. Hello, Rupinder. Nice getting you back. Hello,
Yes.
Amal.
Hello.
Okay, it looks as if everyone is connected and ready to go for the second part. So again, the floor is yours. Thank you. It's so now it's been extremely interesting. Thank you. If apologies if every now and then I interrupted you, but I feel that your questions. Okay, thank you. The floor is yours. Thank you.
Yeah, the next important topic is the highlights of the budget 2021-2022. Kindly change the slide, please. Now, what is vital is that every year budget is passed in Parliament, and in Parliament, after discussion, then the Finance Act is passed. So at this juncture, it gives the trend about what is the government's thinking about helping, facilitating, aiding, and encouraging investment in India. So these are the various aspects which have been highlighted. They still have to be debated and final act to be passed. But the trends which will be there is firstly, a single securities market code. Now this is going to be a revolutionary, where all the capital governing codes are going to be merged in one possible thing, so simplified. Then support for development of a world-class fintech hub at GIFT. GIFT IFC is a unique center in Gujarat. a new permanent institutional framework to help in development of bond market by purchasing investment grade debt securities both in stressed and normal times. Now, hitherto, the bond market of India was not very matured, but this is an attempt towards that. Setting up a system of regulated gold exchanges, then creation of institutional structures, that is rupees 20,000 crore to set up and capitalize a development financial institution, DFI, to act as a provider, enabler, and catalyst for infrastructure financing. So this is a step towards infrastructure financing. Then rupees 5 lakh crore lending portfolio to be created under the proposed DFI in 3 years. And this from 20,000 crore to 5 lakh crores would be the lending portfolio to be created within 3 years. And then debt financing by foreign portfolio investors to be enabled by amending ITs and rates legislatures. Then tax dispute settlement scheme. We no longer have the settlement commission per se, but the settlement is very much part of the income tax provision, where from conflict to a solution and settlement will take place. This is a bill from Vivad se Vishwas. Vivad is dispute, Vishwas is faith. Bill of 2020. It is still to be debated and a final version will come. No changes have been introduced with respect to direct tax regime. Next slide, please. Lot of emphasis on mega investment textile parks. 7 textile parks are to be established over 3 years. Then 5.54 lakh crores for capital expenditure, which is 34.5% more than the last financial year 2020 to 21, opening up an opportunity for all investors. Then for power infrastructure, there is the focus. Consumers to have alternative to choose the distribution companies for enhancing competition. 3,05,984 crore over 5 years for a revamped, reforms-based and result-linked new power distribution sector scheme. A comprehensive National Hydrogen Energy Mission 2021 to 22 to be launched. Then economic corridors for swift industrial development, rupees 1.3 lakh crore outlay for 3,500 kilometers of national highways in state of Tamil Nadu, 65,000 crore investment for 1,100,000 kilometers of national highways in state of Kerala, and rupees 25,000 crore for 675 kilometers of NHS in state of West Bengal. There is a new concept which came a couple of years back of one-person company, which is limited and entitled only to an Indian citizen, where the 182 days necessary for being declared as a resident in India has been reduced to 120 days, and then allowing non-resident Indians to incorporate in one-person company in India. So it is only the Indian citizen, whether resident status or non-resident status. And Mr. Ganguly, yours the next topic, sir, on capital markets.
Okay, thank you. I just only want to tell all of you, for the audience, the figures that you see, lakh and crore, just to tell you the conversion, 1 lakh is 100,000 and 1 crore is 10 million. That's only to understand. I mean, because you would not know what is lakh and crore. So 1 lakh is equal to 100,000, 1 crore is 10 million. So with that, let me proceed with the next topic. Please change the slide. Capital market in India. I suppose that also should be a matter of great interest for all our colleagues who are attending the meeting today. Go to the next slide, please. Yeah. This is the capital market structure in India. You have government securities, you have industrial securities market, development financial institutions, and financial intermediaries. Financial intermediaries are of several kinds. You have merchant banks, mutual funds, leasing companies, venture capital companies, and other financial organizations. So far as industrial securities are concerned, there are two kinds, the new issue market and the old issue market. Now the security market structure, this includes basically the platforms in which the security market operates, and they get regulated by the stock exchanges. So these are the market: MCX, SX, BSE, NSE, and other regional stock exchanges, and two depositories, that is the National Securities Depository Limited and the Central Securities Depository Limited. They all act in together in tandem to maintain the Indian capital market. There are two regulators who are involved with this. One is the Reserve Bank of India, and other is the most important, they are the direct one, Securities Exchange Board of India. So they lay down the various norms which the stock exchanges have to follow, and regarding trading in the market, as well as the reporting. And also to maintain the transparency, there are certain regulations which they provide for time to time. Now look at the capital market. Next page, please. Next slide. See how the capital market has developed, and see the 2020 had been a bad year for all over the world, but just see the capital market conditions in India, something unbelievable. It seems to be an exceptional year for the capital markets in India. And why do I say that? COVID-19 pandemic initially had an adverse impact even on the Indian capital market, as indices across size and sectors fell during the period from February 2020 to May 2020. Then from June 2020 onwards, the Indian capital market had a bull run, a complete change now. The GDP for first quarter contracted sharply, but showed a decent growth in the second quarter after the lows. India saw marked the 17.7 billion inflow in dollars of inflow in 12 months up to November 2020, which includes 8.3 billion in 1 month alone, that is in November. Nifty earning per share for the first upgrade after 23 quarters of a downgrade. So that's how another progress measure. 182 of the Bombay Stock Exchanges and 200 constituents gained in November 2020, with 116 stock position greater than 10% gain. So this is just a statistics of how the stock exchanges has performed. By December 2020, the net investment by foreign investors in equities was INR 1.2 lakh crores. So lakh is 100,000 and crore is 10 million. 1.42 lakh crores, the highest level of such investment in a calendar year since 2002. Just imagine at the turning point in the COVID year, the capital market is something, an exception it seems, to what all that has happened all over the world, and also what has happened in India as compared to other sectors. The Indian government and the Bank of India took many proactive steps to deal with the situation of slowing growth that the country was facing in all sectors and lack of liquidity. But the capital market showed a great thing. Now, having given you this picture, I want to tell you the significance of the capital markets today, and not just India, it is all over. With the liberalization, and today anyone can trade any business in the capital market, and you can see millions and millions, billions of dollars have come, 17.7 billion, 8.3 billion in 1 month has come. So these are all come from abroad, these investments in the capital market. Why do they invest in the capital market? See, if the capital market shows the kind of liquidity that the market is enjoying, and obviously when the market has slowed down everywhere else, and if the Indian capital market is on the run and the bull is on the run, obviously people want to make a quick money. That's how you come in with a very huge investment, and you can see by and large, even in COVID 2020, the market is so stable and it is on point, going up and up and up. That's the reason why they do it. But there are certain, fallouts of these also. So we come to a case study which will give you some interesting, insight as to what happens in the capital market investment. And this is not just Indian scenario; it happens all over the world. But the case study is with reference to a case that arose in India, and I happen to be a counsel appearing in the matter, so I can give you some bit of an insight about the case. So let's change the slide. Please go to the next slide. Yes. This was a case between Technip and IFP. See, these are two different entities. Technip is a corporate entity. Institut Francis the Patron, that is a research organization set up by the French government. In this case, I represented the IFP. Now, what they do is, they do research, and when they succeed in any product, and they are able to bring in some final result, then in order to experiment as to whether the product will have a market or not, its commerciality, they float a company. IFP, they float a company. So the company is floated by them, so they have the 100% shareholding in that company. Then the company is assigned just a license with the requisite intellectual property rights which vests in the IFP, including patents, trademark, etc., etc. They are allowed to do business. And if the company succeeds in doing a good business in that product, then what they do is, then they disjunct the company with the IFP, and they withdraw themselves. They dispose of the shares, or ask the company to buy up their shares, and they segregate themselves. That was the position. Now, what happened in this case? Technip was one of the companies that it had floated in the past. The other company here is SMS Holding Private Limited. This is an Indian company, which I will show you from the next slide, what is the relationship between this company and the IFP or Technip. That I'll show you. But what is the question involved? Just a minute. Now, please remain the previous slide. Just see what was the question involved in this case. The question was, does the Indian takeover code trigger when a French company acquires 29.86 shares in another French company, which through a series of overseas companies controlled a subsidiary company in India? That was the question. Now we go to the next slide so that you can have a picturesque concept as to what is the relationship. Now look at this. IFP, I told you, they are the apex organization, they are the research body. They floated ISIS company, 100% owned by them. ISIS in turn floated Technip, and ISIS also floated a Coflexi. Now, when the product in question became commercially viable, IFP withdrew its shares from the ISIS, so it disconnected. This was not connected anymore. So ISIS had some relationship with Technip and Coflexi. There was another company called Stena International. They made some investment. They held some shares, both in Coflexi and also in Technip. Now, what happened was, in the relevant year, it was 2001-2, there was a transaction of purchase of 29.68% of share of Coflexi by Technip. Technip bought these shares of Coflexi. Mind you, both these are France. They're incorporated in France. All these are incorporated in France. These two are French companies. Coflexi had a 100% subsidiary in Netherlands, CSO. CSO had 100% subsidiary Stena. Stena was had a 100% subsidiary of Cisco. Cisco had not 100%, held 58 point plus shares in CIMAC, which is an Indian company. Now, what happened was, moment Technip purchased 29 plus 0.68% shares of Coflexip, Indian company in India, that is CIMAC, the shareholders of CIMAC, they lodged a claim before SEBI that Indian Takeover Code, which is a legislation which contemplates buying and acquiring of 15% share as amount amounting to takeover, that has triggered. And if that has triggered, then that by reason of that, the company which took over the shares of Coflexip, that is Technip, must make a public offer to the shareholders of CIMAC as on that day, and whatever was the price, prevailing market price of the shares of CIMAC on that day, they must offer them to buy those shares at that price. And if they don't, then they have violated the takeover code. So that was the litigation complaint they made before SEBI. SEBI accepted their argument, yes, the Indian takeover code permits only 15%, and this was 29 plus 0.68%. Obviously, it is by that Indian standard law, it is taken over. So CIMAC control was taken over by Technip through all these subsidiaries of Coflexip by acquiring 29.86%. This was challenged by Technip, and also, now why did they join IFP, ICs and all that? The case was, look, all of you are acting in concert, all of you, ICs, IFP, Coflexip, Technip and Stena, all of you are acting in concert to take over the management of CIMAC. Therefore, you are liable to make a public announcement in terms of our law. SEBI accepted this complaint and directed Technip and Coflexip to make that offer, public offer. Technip challenged it in an appeal to SAT. The SAT reversed the order. The matter came to Supreme Court. The Supreme Court ultimately decided this case, applying several complicated questions of law. But in short, let me tell you, what they said was that the domicile or the residence of a company doesn't get decided on the same principles as individuals. Company is a creature of a statute. So generally, the concept of incorporation, lex incorporatio, would be applicable to a company's domicile, because it's a creature of a statute. So wherever it is incorporated, that is the country where it will be counted as having its residence. Then the court said, this is the first thing they decided. So all these are companies incorporated in France. So they would be primarily guided by the French regulations. So according to them, this transaction did not violate French law, because French law permitted, or rather, under the French regulation takeover code, only if Technip would have acquired 30% plus shares, then the French takeover code would have been triggered. But their acquisition was less than 30%, it was 29 point something. So the French code did not trigger. Not only that, this purchase of Coflexip share by Technip was also approved by the French regulators. In any event, they still went to the regulators and took their approval. So there was no violation, and it was a perfectly valid transaction in France, where the transaction had taken place. Now, the question is, can a foreign company do any business it likes and affect a subsidiary which is ultimately 58% holding in the Indian company, and they get away with the Indian regulatory measures? The court said, first holding was that, look, the transaction was primarily between these two. And there was no evidence, that's most important. There was no evidence produced by anyone to show or suggest this takeover of CIMAC was the target of this transaction. No one targeted to take over CIMAC. Though 58% shares of CIMAC ultimately vested in ultimately the conflict, but it was still not a targeted company. It was incidentally affected, if at all. So therefore, unless you target that Indian company, then if you don't target Indian company, the Indian regulations would not apply. So this will be governed by what is called the principles of conflict of law. French law will govern this transaction. Since according to the French law, it's a valid transaction and it is in conformity with the French regulations, only those regulations would apply. CIMAC was not a target company. No one tried to change the management of these. There was no intention to violate any Indian law, nor was it desired to trigger the takeover code of the Indian law. And therefore, the shareholders of CIMAC could not compel Technip to make a public offer to compulsorily purchase its shares, etc. Now, this was a very, very interesting and landmark decision of the Supreme Court of India. But it is way back in 2005-06, they said that the judgment is relevant even today because the capital market transactions continues to, unabated, and rather it is going magnifying, many more times than what it used to be at one time. So this is a very salutary principle. In fact, post this judgment, I had occasion to interact with many of my colleagues from many other countries. And we thought that why should we not initiate some kind of an action at the international fora to evolve at least a practice or a norm that in such events, the shareholders may not be allowed to go high and dry. Some kind of a remedial measures could be provided for. Secondly, when the investors make these, they should get to know what repercussions that action can have in all over the world. Because today you have so many multinational companies present in so many other countries. So this is one single example of what can today happen of trading in the capital market, not just in India.
Excuse me, Amal, can I ask you,
yes,
one piece of information? CIMAC, the Indian company that was not targeted, at least according to what market share did it have? I mean, was it does the Indian Takeover Act apply depending on the share in the market? So it had a relevant share. That was,
you see, although holding of Cisco was 58% in CIMAC, but CIMAC's role, contribution to the big shareholding of Technip was just 2% of one market share.
So the market share of CIMAC is only 2% in
India. So that is
relevant market. Okay.
Very relevant. So that was another important consideration that made with the court. That obviously they were not looking to control a 2% market. They were not. That is why one of the reasons why the court said CIMAC was not targeted. It was not a target company. Had it been a target company, then they would have been justified in raising the issue that day. So you get the findings very briefly. We have indicated at the next page, in the next slide. Yeah. Conflixive and technique incorporated according to under the laws of France and therefore domiciled in France. Jurisdiction of SEBI and SAT of the Supreme Court is based on just disposal of the proceedings having a foreign element. Questions as to the status of a corporation are to be decided according to the law of its domicile and incorporation subject to such exceptions, including exceptions of domestic public policy. Relationship of technique and conflixive, whether one of control or not, is really a question of their status. Applicable law would be the law of their domicile, that is the French law. Having determined their status as per the French law, the next question as to whether their obligation under the Indian law vis-a-vis same act would have to be governed exclusively by the Indian law. The court decided that no, because it was not targeted. And then therefore the challenge by the shareholders of SEBI ultimately failed. This was the net result. Anything else you want to ask on this question, on this aspect? No.
So basically, I mean, the law of the domicile, which is French law, applies.
Yes.
But the situation might have been different had CMAC had a larger
Exactly.
market share. Yeah. Had it had, I don't know what the market share would be to become relevant for competition law purposes, whether it's more than 10 or 15 or 20%. But had that been the case, then regardless of French law, you would have applied.
Exactly.
Okay.
Could have been possible. Could have been possible. The decision, I consider this to be one of the landmark because, on conflict of laws principle, this is so great because it shows the respect for other countries' laws and respect for transactions, that is valid transaction that takes place abroad in another country. The argument that this is opposed to Indian public policy was not accepted by the court. So in the capital world market, this is a very, very salutary decision which actually goes in favor of growth and development of the capital market in India. That's how you get 17.7 billion investment in the capital market and 8-point-something billion in 1 month. That's the reason why. So our courts in India are very supportive of competition and international investments, even in the capital market. Although these capital markets, as you know, they are all very unstable market in the sense nobody remains invested for a long time. Their whole object to invest, it's not FDI. That's the difference. There one gets a very slow and steady growth and long drawn affair and earning profit, no doubt, but over a period of time. Here, most probably people take a chance. It's a speculative market. But the go to that market which is boiling, which is coming up, where the bull is running. Indian capital market definitely seems to fulfill that requirement. That's why it is attracting so much of capital investment. So that's an interesting area for all the lawyers, for all of you, to study and to guide your clients.
Okay, thank you for that.
Thank you. The next topic is setting up a business in India. Suri will deal with this topic. Yes, Mr. Suri.
Next slide, please. Now I'll briefly take you through, these are the procedures already set in there, and that how can a foreign company do business in India. Foreign company can have a license office. It can also have the option of branch office and then project office. It can execute projects through joint venture with Indian company or through wholly owned subsidiary of either Indian company or the foreign company. and then through limited liability, LLP and society. But I think the main interest would be here on foreign company and Indian company and their collaboration with each other. A special purpose vehicle is normally formed for execution of projects. Condition precedent is that company has to be incorporated as per provisions of Companies Act 2013. Under the company law, a resident having permanent account number to be appointed for receiving notices in India for foreign company. So it's not that one can rely upon service abroad, but within India it will be taken into cognizance by serving on permanent account number. Next slide, please. Foreign company is defined in both Income Tax Act also and Companies Act also. Section 242 of the Companies Act 2013 means any company or body, corporate or incorporated outside India, which A has a business in India, whether by itself or through an agent, physically or through electronic mode, or conducts any business activity in India in any other manner. With respect to business in India, there is no difference whatsoever in treatment under the law between a foreign and a domestic company. Foreign company, after having registered with RBI, ought to get itself registered with the Ministry of Corporate Affairs for it to be registered as an establishment of a foreign company in India. This is a practice direction. Necessary documents shall be filed with ROC, Registrar of Companies, within 30 days of establishment. Foreign company can have unincorporated presence in India through liaison office, branch office, or project office. Next slide, please. Next slide. Now, as far as liaison office is concerned, it acts as a catalyst. Just one slide before, please. A slide before this. Yes. Now, liaison office is a link between the foreign company and the liaison office. It only exchanges the information, but no business can be done. So there cannot be any income earned in India as far as liaison office is concerned. Now, as far as branch office is concerned, profit-making track record during the immediate preceding financial years in home country and for worth of for less than 1 lakh in equivalent. So branch office can be opened provided it is doing good business earlier on, and the income here would be taxable. And the project office is the special purpose vehicles. They are permitted to execute specific projects in India and cannot undertake or carry any activity other than the activity relating and incidental to the execution of project validity till the tenure of the project. So the special purpose vehicle can be wholly controlled by them, or it can be joint venture with the Indian companies who have bid with them for getting contracts. Next slide, please. Now, this is just the statutes which are applicable for entity in India. Private limited company to be incorporated under the Companies Act. Purpose as specified in charter documents. Time to establish comparatively fast mode of incorporation. Can be incorporated in 2 to 10 days. The number of members, minimum 2 members, maximum 200 as far as private limited is concerned. Then we have limited liability part B. We also have public limited company, which gets registered on the stock exchanges, etc. And then LLP is Limited Liability Partnership Act 2008, as specified in charter document. Also, fast mode of incorporation can be incorporated in 50-20 days. Minimum 2 members, maximum no limit. Society Registration Act is for propagation of any science, literary event, scientific or charitable purpose. Minimum 7 persons, maximum no limit. And then Indian Trust Act, it's applicable in some states, other it is not, but the trust is well described and well understood concept here. Next slide, please. Now, establishing incorporated presence in India, private limited company compliances under governing law, bank account, appointing authority, board meeting in 30 days, tax deduction, director's report, prerequisites, charter documents, name approval, digital signature, and director identification number, that's called in here, permanent account number of directors, online facility. Then LLP is bank account, filing partnership deeds, statement of account, and solvency. Drafting documents, name, approval, design, identification number, permanent account, number of directors, online facility, declaration of solvency, approval by creditors, resolution by not less than 3/4 partners, followed by publication LLP. Next slide, please. These are various procedural steps that obtained in digital nature. I did not go through it. You can please follow it up because it's step by step that what it's kind of a checklist which everybody should follow.
Next.
Then the next list, please. Next slide. Agencies of Ministry of Corporate Affairs, Competition Commission of India, other agencies, Serious Fraud Investigating Office, National Financial Reporting Authority, Security Exchange Board of India, the RBI, Central Board of Direct Taxes, Central Board of Excise and Customs, Income Tax Department, State Commercial Tax Department, municipal bodies, local property tax department. Official liquidators are in, now part of the Companies Act. The institution of chartered accountants is there. The institution of company secretaries is there, and institution of cost accountant is there. Next slide, please. This is a list of licenses required and the statute under which they are done. Importer-exporter code number under Foreign Trade Act 1992. Then permanent account number under Income Tax Act. Then Employees Provident Fund registration under Employees Provident Fund Act and miscellaneous. Registration for Employees State Insurance, Employees State Insurance 48, Employees State Insurance. Certificate of conformity or license for using a standard mark, Bureau of Indian Standards Act 2016, Bureau of Indian Standards Conformity Regulation 2018, GST registration under Central Goods and Services Tax 2017, tax deduction account number under Income Tax Act. Next slide, please. Register of Companies has this record registration, industrial license, district industry center, small scale industry, secretariat of industry for large and medium industries, the allotment of land, State Department does it, permission for land use, State Department of Industries, case study is located outside an industrial area, Department of Town and Country Planning, local authority, district collector. Next slide, please. The approval of construction activity has to be given by town and country planning and municipal and local authorities. Building plan has to be accepted approved by Chief Inspector of Factories, Pollution Control Board, Electricity Board. Sanction of power use and storage of explosives, boiler inspection certificates, all these various authorities are mentioned right across them. Weights and measures, this is to facilitate all the persons who are likely to invest in India. And Mr. Ganguly, this would be the procedural part of the agencies, etc., which permit. Now we come to the next slide, competition law in India. I think you take over, please.
Okay, I just say, I gave you the background about the change in the framework, legal framework in India.
Okay.
Earlier, we had a new act in 1972, Monopolies and Restrictive Trade Practices Act. Now, there the object of that act was to really curb monopoly. But now there is a change in the perspective, complete change. So rather than controlling the monopoly, the present structure of the law is promote competition. It is more positive, and it helps in development of a level playing field in the market conditions. Some of the features I have mentioned what it does: promotes fairness in business and provide a level playing field for the corporates to prevent monopolies and to promote competition in the market, to protect the freedom of trade for the participating individuals and entities in the market, protect interests of the consumers. And the basic prohibited items are these: abuse of the process, dominant position, and then anti-competitive combinations, and competitive anti-competitive arrangements like cartel, etc., are also curbed or prohibited activities under this. These are like any of the other antitrust laws that as you have in Europe and also in the US. So Competition Commission is the regulatory authority. As I told you, there is an investigator attached to the Office of the Competition Commission of India, and that is independent investigation outside the government. It is part of the statutory body, which is an adjudicatory body. So this investigation is done by an office called the Director General of Investigative Wing, attached to the Competition Commission of India. They do the market survey, etc., study the backup material, and if they find that the competition laws are violated by anyone or some activities are anti-competitive, then they collect the data and then bring the offending parties to book by subjecting them to a process of noticing. They're given a notice with the facts disclosed to them, and they're called upon to explain their conduct. So when they come to explain, if they accept and they rectify, well and good. But if they don't accept and they say, no, we don't accept, then the matter goes for adjudication. It's a question of then trial on evidence, and then the final decision is taken by the Competition Commission. And then if somebody wants to challenge that, there is an appellate forum which I mentioned to you, that is NCLAT. An appeal could be taken from that order to the NCLAT. That is in brief is the competition law. Now we go to another aspect now. Next slide, please. Bilateral investment treaties in India. See, between 47, that is independence till 1989, India followed the principles of mixed economy. So the investments are more than was from the public sector, there's the government sectors, and investment in the core sectors came only from the government, like steel, power, then infrastructure like ports, airports, roads. They're all part of the government investment. The private sectors were not interested, although it was a kind of mixed economy, so private was allowed. But the private sector's investments were very small. Pharmaceutical, for example, the high value pharmaceutical products were part of the private industry, but crucial life-saving drugs they were not manufacturing, like penicillin, for example. So the government had to set up pharmaceutical sort of companies to undertake this kind of manufacturing of life-saving drugs, because India was then very large population living in the villages and in rural areas, and the quality of healthcare was very poor. So in order to ameliorate that situation, the government intervened by making huge investment in the public sector. That's how it all began. In the 1990s, when we opened up, then India started the new venture of entering into bilateral investment treaties, because investments have started coming in from all over the world, particularly then large number of them came from the UK. We practically followed the UK model of the BIT. But there were some experience that India gained through some court cases and some arbitrations, etc., that gave rise to a new dimension of the government accepting that, well, the BITs could as well be the gateway for some adjudicated proceedings where government may not be directly involved, for or responsible for the action or inaction, but government may vicariously be held responsible. For example, the white industry case. What happened there was there was an arbitration award in favor of a foreign entity, white industries. That was all that was challenged through different proceedings in High Court, and an appeal was pending in the Supreme Court. Because of laws delays, the court was not in a position to take up this, and parties did not actually expedite the hearing. They didn't take steps. So the matter was allowed to lie over for a long time. Then the white industries took up this matter by invoking the BIT and said this amounts to a breach of equal treatment. They extended by the government of India failed to extend, and they succeeded in getting an award. And it was held in that award that the delays in the courts, although courts are independent of the government, and executive government has no role to play, they don't control the court proceedings. Yet the government was held to be bound, and for the court's laws delays, and that entailed a huge liability for the government. And eventually the government accepted that liability, and they honored that liability under the award. But that was the eye-opener for the government to sit up and have a relook at the BITs. And then they formulated what is called a model BIT that should govern the future courses of action. That's available on the government website. So this is just an information which I wanted to give to you. And one of the latest BITs with Brazil-India Investment Corporation Facility. I've given one instance of India being party to many of the international institutions, but it is not a member of ICSID as yet. So the settlement of a dispute where India is a party would not be through ICSID rules, but of course, UNCITRAL India is a party and many other bodies does. And UNCITRAL, of course, is followed by the PCA, Permanent Court of Arbitration, as you know, and there quite a few matters arbitration proceedings are pending, in which the government is a party and they are prosecuting their rights under those proceedings. So that is in short about the BIT. Could we proceed to the next slide, please? Unless you want to ask some questions on this. Now we come to a very important aspect of alternate dispute resolutions. Now, we go to the next slide, please. Mediation has now taken the center stage of resolution of disputes in India. In recent times, mediation has become a grand success, and this applies to both pre-litigation and post-litigation mediations. Now, our Civil Procedure Code has been amended some several years back, or a decade before, which requires that every court to identify cases where an amicable settlement is possible. And they have to compulsorily take a call on every single case. And if the court comes to the conclusion that yes, this is a case where amicable settlement is possible, like in all commercial causes cases, it is always possible. Then the court will then formulate the terms of the settlement and invite the parties to respond to those terms. If they agree, the matter gets settled through the court. If they do not, then the court can relegate them to a mediation center or to a process of mediation by private negotiation between the parties. In fact, our Arbitration Conciliation Act has a separate chapter which deals with the mediation and conciliation. Conciliation is a form of a mediation, but that's a statutory mediation. So the mediators and the conciliators have certain protections, and those proceedings also give certain protections. But the interesting thing is that if at the end of the conciliation proceeding, there is a agreement between the parties eventually, that can be treated as an award, and a valid and binding award, and enforceable as an award. So even in a conciliation proceeding can result into an enforceable award with the parties mutually settling their disputes. The Commercial Courts Amendment Act has also been introduced now, so that gives a special impetus to the form of mediation, and there are rules being framed for this process. Today, even MIDA, that is mediation in arbitration, is also a very popular measure that the parties are resorting to. Halfway through, they settle in an arbitration proceedings. So we have given some, the Delhi High Court, there's a huge mediation center, and you can see there from the graph, see the progress. It only started in 2006. So between 2006 and March 2020, look at the result. The number of cases where parties decline mediation is very small, the light blue. Number of cases settled by mediation. Look at the graph. And there's cases where no agreement was reached was also comparatively low. So there is an increasing trend by the litigants, either before litigation or during the course of the litigation, to mediate or conciliate and settle the disputes, which will result in an agreed award and enforceable award. Next slide, please. Arbitration in India is now the most popular mode of resolution of disputes, both for domestic disputes as well as for international disputes. The most preferred method today. Almost every court is encouraging everyone to go and arbitrate rather than mediate. And parties, when they get into a difficult situation in the court, they offer to go for a more informal settlement by arbitration rather than going through the ordeal of the court litigation, etc. So the type of arbitration we have in India is ad hoc arbitration, which is of very large extent. Number are the ad hoc arbitrations. Then institutional arbitrations, which is also quite popular and becoming more and more popular now. We have statutory arbitration. Those are arbitrations which particular enactment contemplates an arbitration, and it provides for the machinery of that arbitration. For example, if there be a certain typical disputes between a licensor and the licensee in a power supply contract, that could be settled by a process of arbitration contemplated under that particular act, Electricity Act, that contemplates an arbitration. So those are statutory arbitrations. So we have the applicable laws of the Arbitration Conciliation Act 1996. This act is entirely based on the ancestral model law. India has always had been a party right from 1958 to the New York Convention on recognition and enforcement of foreign awards, and has stood by its commitment under the New York Convention. India is also signatory to the Convention on the Execution of Foreign Awards, that is the Geneva Convention 1923. So India is a part of both the international conventions, and therefore all international awards, whether it is governed by New York or it is the Geneva Convention, either way, they are enforceable in India and recognized in India. They are recognized and enforced in India. We have, in the next slide, you will find there are a number of ADS centers in India. These are all arbitration centers. For example, Delhi International Arbitration Center, DIAC, I'll tell you about that little bit in detail because I was involved with the creation of that body and continue to be associated with them even now. Then Indian Council of Arbitration, New Delhi, Mumbai Center for International Arbitration, Thani Phalkewal Arbitration Center in Chennai, Delhi High Court Mediation Center, then International Domestic and Arbitration Center in Vadodara, Associate International Council for Alternative Dispute Resolution, then Bangalore International Mediations and Arbitration Conciliation Center, Center for Advanced Mediation Practice in Bangalore, Construction Industry Arbitration Council. That's a huge success now, Construction Industry Arbitration Council. Indian Institute of Arbitration and Mediation, Kerala, International Center for Alternative Dispute Resolution, ICADR, that's also one of the old institutions in New Delhi. Then ODR Railways, ODR Ways in Calcutta, and Online Consumer Mediation in Bangalore. So these are all the institutions which are very effectively functioning in India. I have brought to your notice in the next slide the performance of this organization called the Delhi International Arbitration Center, that is the DIAC. I must tell you, I was associated with this institution right from its birth in 2009. And if you see the table from here, it all began with activity. It was inaugurated in October, started functioning, in November, and it started functioning from November. November itself, there was a kind of a reference started, and you see the references, year-wise references. Then what you see, the progressive total from 3 in 2009, it has come to 2,862 in 2020 references. Disposals are also fantastic, phenomenal. If you look at it from 15 to 145, 16 is 159, 17 264, 18 303, then 19 278, and even in the pandemic year 187. Disposal means so many awards have come. So this has been a phenomenal performance of there. If you go to the next slide, that gives you, apart from the references and the disposal, you also get the panel. What is the panel of this center? It is former chief justices, former judges of the High Court, former judicial members, engineers, architects. You have former Supreme Court judges, district judges, chartered accountants, senior advocates, and professors. And you have all kinds of mix of people in the panel and we give the percentages. This is how you look at it. And if you go to the next slide, you can have a look at how the center looks like. This is one of the hearing room. That's a meeting room, breakaway room for the lawyers. And this is the meeting room. This is the corridor where the reception is. And that's how it looks like. And I feel proud to be associated with this organization from day one. In fact, I was responsible not only for framing of the rules, etc., but also doing bit of architecture job also. In fact, the architectural planning is by me, because it was the first center of this kind that was set up in India. So I'll now leave the floor to Suri to conclude the last bit of slices, and he'll tell you why should we invest in India. That would be the concluding remark. I think we will be well within our time, so that Carlo, we will then have questions if somebody has questions on anyone to ask to any of us. So
okay.
What?
Thank you, Amal.
Next slide, please. Why invest in India is the question. And Mr. Ganguly or myself, we are not selling India, but we are trying to invite you to India, because this is the place where activity is going to be there, which no other country can afford not to be part of that activity. And it would be for mutual benefit of the foreign countries investing also and the product being made in India. The reasons why you should invest in India is firstly the mindset of the change of the mindset of the government. Our Prime Minister has said government has no business to be in business, and the private sector must take over whatever public sector was doing, because the best of the people must come, best of technology must come, and there is no compromise on that. We have demographic dividend, which no other country would be having, is that the India has its, the India has its largest ever adolescent and youth population. It will continue to have one of the youngest populations in the world till 2030. IMF projects growth of 11.5% for Indians in 2021. There's a lot of emphasis on skilling India and giving training to youth for in various professions, vocations, and training. And India has the third largest pool of scientists and technicians in the world. And along with that, when you say that the people who had gone abroad, settled abroad, they have got experience of running companies here and they have come back, this all is a positive thing. It's one of the fastest growing economies. The India crossed 70 billion and recorded a total FDI inflow of 73.45 billion. IMF projects 11.5% for India. A special economic and comprehensive package of more than 270 billion, equivalent to 10% of India's GDP announced, self-reliant India. The prices are competitive. Access to justice is there. It's governed by rule of law. Time-bound ADR process. The institutional ADRs are now taking prominence rather than ad hoc. India has jumped 4 positions and ranks 48 in the Global Innovation Index 2020 ranking. Well-developed legal system and well-trained advocacy. And mindset of the judiciary now is that in the arbitration awards, there would be least possibility of interference, and it will be by and large accepted if proper arbitration award has taken place. Next slide, please. Wide sweeping tax reforms have taken place. Goods and services tax, the biggest tax reform since independence, paves way for a common national market by integrating various indirect taxes. Opening up business to foreign direct investment. Ease of doing business. India jumps not 1 or 2 positions, but 79 positions from 42nd in 2014 to 63rd position in 2019. World Bank's Ease of Doing Business ranking 2020. Connectivity is a very important thing. It is well connected to Central Asia and Europe via the international North-South transport corridor. Connectivity within the country is well connected from Kashmir to Kanyakumari through a robust network of airport, railways, highways, and roadways. The Indian rail network has 123,542 kilometers of total tracks over a 67,415 kilometer route and about 7,300 stations. It's the 4th largest rail freight carrier. Indian carriers aviation are projected to increase their fleet size to 1,200 aircraft by 2024. Anything else? The next slide is about the recommended readings. One of them articles has been written by Mr. Amal Gongli also. So this is for your input. So all the topics that we have covered ultimately have a grand finale that please come to India, invest in India, and taste the pudding by tasting it, and you will not regret it. India is a changed country now, and wish you all the best, please. Mr. Ganguly, please take over.
That's all right. Carlo, we are happy that within the time frame, I think we have been able to give you a package program of a broad view of what India today is, and also to appraise our good friends who wants to know what is the legal framework in India and how does the legal system work, and what are the avenues open for the international players to come in, and how do they come in? What is the method by which they'll come in? What are the stakes involved? What are the pitfalls, if any? And how, in a setup of an open, transparent system, of a democratic government, ruled by a written constitution and the rule of law, everyone having access to justice right up to the Supreme Court directly, is a phenomenal circumstance. I thought we have been able to bring to all of you, and we'll be happy to answer any of your queries, whatever you have.
Okay, well, thank you. Thank you to both Amal and Rupinder. I think this has been a wonderful presentation, and I couldn't agree more that we are faced with India, which is an enormous democratic country, and it was quite good, very good of you to start your presentation, starting from the Constitution and highlighting that this is probably, I would say, yes, certainly the largest democracy in the world. This is something we must remember, which is important in international trade and international investments. I'm wondering whether there are any questions, but whilst we collect questions, I'd like to go back to this last part, which is the setting up business in India. And I noted the slide number 50, where you talk about foreign companies. And again, stressing that there is no difference in treatment under the law between a foreign and a domestic country, which is equality of treatment, which goes back to, of course, your constitution. It all builds into the same principles. I was very interested to run through your slide on permitted activities of a foreign corporation, which is the representative or the liaison of, this is your slide 51, simply not a taxable entity, but simply a presence of communication. A branch office, and I see you mentioned special economic zones. Of course, this is just a very general highlight. So special economic zones is clearly something that one in practice would have to investigate if and when advising a client or project office only. So I think your slides are extremely well done in connection with guiding to how to establish an incorporated presence in India, listing all the agents. I was extremely interested in the competition law. I would imagine that you probably have a similar, in Europe we have this selective distribution system whereby a supplier can enter into a vertical agreement with a limited number of dealers in a geographic area to distribute products which are prestige products, like I would imagine something like Chanel or one of these French or Italian fashion houses. And online sales, that's another aspect we haven't spoken about. But of course, India is a country where you manufacture and you export. It's not only, we should not look at India for importing goods, but for manufacturing goods with the brand and then selling on the domestic market or exporting because of the favorable pricing. So this is what India is about. The bilateral agreements, that's very important to underline that there are bilateral investment treaties. Thank you for touching on the in the dispute resolution and mentioning mediation. We had a session on mediation during this course, and it's good to see that there is a mediation, Delhi High Court Mediation Center. Thank you for touching on arbitration, the ANSI trial, and in particular on the center that you contributed to create, the Delhi International Arbitration Center, DIAC. It's good to understand that in cross-border disputes, an arbitration clause in a cross-border contract which makes the foreign investor or the foreign party in a business contract feel more comfortable, although there is a great respect for foreign entities, and there is equal access to justice. We know that foreign enterprises feel somehow more comfortable when they can agree an arbitration clause, and that would be respected. It would be upheld, whether if it's ICC or whether it's DIAC. If it's a foreign arbitration, then it would be implemented through the 1958 New York Convention. If it's a domestic arbitration in an international context, but still domestic, the Delhi International Arbitration Center would, I guess, lay down a domestic arbitration award, which would be immediately enforceable in the Indian territory. So that is certainly a very good dispute resolution system, maybe even combined mediation with arbitration, a double step or something like that. So quite frankly, I don't have any additional comments or questions in addition to those that I jumped into every now and then. I don't know whether we have any questions on the chat. I don't see any at the moment. So I must say we were all very intrigued by your contribution. Let's see whether I would suggest that we then consider closing this this session. I am sure that everyone here would like to give a how can I say, a virtual applause of thanks to Amal Ganguly and to Rupinder Singh Suri. Thank you not only for the presentation, but thank you for your slides, because that is something we will be looking at, and possibly from there one can get a better understanding and go into more detail. So this has been wonderful. Thank you.
Thank you, Carlo.
And
good seeing you. Good meeting you after a long
so
time.
we will reconvene at a different time. I'm going to just remind you that we reconvene at 15:30 our time, Italian time. We will then have a focus on the USA. By the way, Amal, you know Jim Rosner from New York.
Yes.
It's really a real UIA day of having our best speakers throughout the world, including yourselves. So it's a great honor, a great pleasure that we've had you on board. So thank you, and all the best again.
Thank you, all the best. Have a great time and a very successful program you are already doing. You always succeed. You have never been anything less than a grand success.
Okay, thank you.
Thank you.
We will be disconnecting, and we will reconnect back at 3:30. Okay.
Thank you. Bye.
Thank you. Thank you very much. Managing partner di un famosissimo, direi primo studio italiano negli Stati Uniti, se posso dire così. In realtà non so neanche se posso dire studio italiano, uno studio internazionale di derivazione italiana, ma di diverse generazioni fa, Pavia Hardcore LLP, e essere managing partner, una bella carriera fatta da Giovanni Spinelli, che però nasce a Firenze e si è laureato a Firenze, e l'esame d'avvocato inizialmente in Italia l'ha superato qui in Italia, e poi si è trasferito negli Stati Uniti a New York per un master che fosse inizialmente, poi è rimasto facendo questa scalata della Pavia Hardcore adesso come managing partner. Allora, stamattina abbiamo fatto una panoramica focus India. Diciamo,
il mestiere di consulente della procura, però dall'altro...
Quindi no, dovreste, ecco, perfetto. Quindi adesso passiamo al focus Stati Uniti. Abbiamo due relatori. Giovanni Spinelli, e l'altro relatore James Rosner, ve lo presenterò quando si collega. Abbiamo fatto un paio di conference call per coordinare, diciamo, questi interventi, e quindi ci sarà un'alternanza che rende sempre più interessante le presentazioni. Credo che questa presentazione, non so se la farai in italiano o in inglese, questo non lo so. Comunque ci sono delle slide che verranno messe a disposizione subito dopo, e per il quale ti ringraziamo, perché so che la preparazione di slide da un lato è particolarmente gradita, chi le riceve, e dall'altro è anche particolarmente onerosa per chi le prepara, perché è impegnativa, e quindi ti ringrazio a nome di tutti dello sforzo per mettere insieme queste slide. Allora, sono le 15:30 esatte, quindi the floor is yours. Grazie Giovanni, e procediamo allora con questa prima parte del Focus USA.
Grazie mille Carlo per l'introduzione, e devo rimarcare che io ho iniziato da praticante nello studio dell'avvocato Carlo Mastellone a Firenze il 9 novembre 1990, stavo dicendo al dottor De Napoli ieri, proprio prima di completare la laurea, ma insomma è stata un'esperienza ovviamente iniziale, fondamentale e interessantissima. Ringrazio la Scuola di Alta Formazione, la Scuola Superiore dell'Avvocatura. Devo ringraziare ovviamente anche l'Università degli Studi di Firenze, devo anche ringraziare il dottor De Napoli per l'assistenza e la cortesia, e il mio collega l'avvocato Nicolò Mainoni per il supporto, ovviamente. Allora, parliamo di investimenti da parte di aziende e individui italiani negli Stati Uniti. Io inizierei da qua. Forse riconoscerete questo personaggio famosissimo, Walter Chrysler. Walter Chrysler diceva tante cose interessanti, simpatiche, ma una delle mie preferite è quando riferiva che quando ho un compito particolarmente difficile e devo affidarlo a un dipendente, scelgo sempre di affidarlo al dipendente più pigro, perché il dipendente pigro sicuramente troverà un modo più facile e più snello per compiere quella operazione. Allora, siccome venerdì la settimana è stata lunga e io mi sento particolarmente pigro di fronte a un compito difficile, vi chiedo, io cercherò di fare intervenire anche voi, vi farò delle domande e vi prego di non aver timore, sia mai detto che un avvocato, no, abbia avuto timore di parlare. Accendete il microfono e rispondete liberamente, sentitevi liberi. Allora, iniziamo da un'altra domanda, da una prima domanda per voi. Vi chiederei, vorrei sapere chi mi può dire chi è quest'altro personaggio, chi mi può identificare questa persona.
Enzo Ferrari.
Bravissimo! Ah, ma guardi, mi ha colpito, guardi, mi ha preceduto l'avvocato Paris. Bravissimo, un premio speciale.
Filippo, siamo fra colleghi,
Benissimo.
non dobbiamo formalizzare.
Benissimo, benissimo. Enzo Ferrari. Oh, spettacolare, un intervento in prima battuta, mi piace. Allora, Enzo Ferrari, anche lui diceva tante cose simpatiche e interessanti. Una delle mie preferite è quando diceva che la macchina da corsa perfetta è quella che si rompe appena superato il traguardo. Perfetto. Ma diceva anche una cosa interessante per noi avvocati. Quando si rivolgeva un po' instizzito ai propri collaboratori, dice: guardate che il cliente non ha sempre ragione. Allora io a questo punto vorrei focalizzare proprio su questo, su il momento in cui il nostro cliente, la nostra azienda italiana sbaglia, quando commette un errore nell'approccio al mercato americano. E benché vi siano degli ostacoli, delle barriere all'entrata tipiche e storiche che esistono tuttora e di cui parleremo più avanti, esiste anche un pericolo forse concorrente o maggiore, e direi che è quasi un pericolo che non è molto noto, è un pericolo che rimane un po' in secondo piano. Ed è un errore di impostazione. Cioè è il momento in cui l'operatore, dell'azienda italiana presuppone erroneamente che il sistema americano, che il mercato americano o gli istituti giuridici americani siano simili o identici a quelli nostrani, a quelli europei o a quelli italiani. E sembra una cosa banale, però si estende e ha una portata spesso devastante, anche perché purtroppo psicologicamente gli Stati Uniti, diciamolo pure, ci sono abbastanza vicini, come dire, culturalmente. Pensiamo, un imprenditore può vedere l'America come un'entità più conosciuta rispetto magari, che so io, l'India o il Brasile o la Cina, ad esempio, tanto per citare gli altri paesi coinvolti in questo programma al momento attuale. Allora, per illustrare questo pericolo, questa impostazione errata, vi presento un'altra domanda. Questa invece è la domanda tipica del vostro cliente. Supponete di essere voi un consulente legale di un'azienda che debba affrontare il primo passo negli Stati Uniti. Questa domanda è una che viene rivolta a noi molto spesso. È una domanda un pochettino forse ingenua, forse un po' grossolana, forse a voi vi potrebbe irritare, ma la devo mettere in evidenza perché sostanzialmente la domanda avviene quando al primo contatto squilla il telefono, si sente l'email e la domanda è questa. Si legge un'email, la domanda che viene posta al cliente è questa. Avvocato, noi e la controparte ci siamo seduti o ci siamo incontrati, abbiamo fatto una Zoom e abbiamo negoziato tutti gli elementi essenziali del nostro contratto.
Pronto?
D'accordo? Mi sentite?
Ciao, trovata la mamma.
Tutti gli elementi essenziali del nostro contratto. Mi dica lei, avvocato, se questo contratto che abbiamo già, come dire, delineato è conforme alla legge americana. Ora vi dico subito che questa domanda, in tutte le componenti, per un avvocato americano quasi non ha senso. In tutte e quattro. Perché? Partiamo da questa legge americana. Sapete meglio di me che una vera e propria legge americana non esiste. Esistono 51 ordinamenti, ci sono a livello federale, ci sono delle leggi federali che però incidono, diciamo, incidentalmente, scusate il bisticcio, spesso nelle operazioni commerciali, e ci sono 50 ordinamenti statali. Quindi molto probabilmente nel vostro affare, nella vostra operazione, sarà di rilievo una legge, un insieme di norme, un diritto di uno Stato. Ma che caratteristiche ha questo diritto statale e anche federale spesso? Sapete anche questo da studi di diritto comparato e dalla vostra esperienza che intanto c'è una minor rilevanza della norma scritta, per cui se in Italia e in Europa e in altri paesi, ma perfino anche nei paesi dell'est, anche in Cina per esempio, si possa in prima battuta far riferimento a una norma scritta in bianco e nero, pensiamo al codice civile, primo approdo, la prima, diciamo, pure ancora di salvezza è la norma scritta e il codice, questo non è vero negli Stati Uniti. Il diritto è a formazione prevalentemente giurisprudenziale e è fondato, come sapete, sul sistema dei precedents, dei precedenti giudiziali, per cui una corte in teoria può essere vincolata o soltanto influenzata pesantemente dalle decisioni precedenti su casi simili. Però il giudice americano ha anche la facoltà di distinguere dal precedente con la tecnica del distinguishing. Cosa fa? Guarda i fatti concreti della fattispecie di cui ha dinanzi, guarda i precedenti e individua degli elementi della fattispecie attuale che giustificano una decisione diversa. Voi capite da questo quali potrebbero essere le conseguenze di questo? Beh, innanzitutto è un diritto più difficile da accertare, spesso, perché spesso implica un momento, vediamo una ricerca della giurisprudenza, andiamo ad esaminare i casi. E infatti un trattato di diritto in quasi qualsiasi materia di diritto americano c'è il paragrafo introduttivo A, B, C, D, E, F e subito si parte con una disamina della giurisprudenza. Molto difficile da ricavare dei principi, diciamo, netti. Non solo, ma è un diritto spesso più incerto. Ovviamente sto generalizzando, ma questa è la nostra esperienza diciamo da 25 anni negli Stati Uniti. È un diritto spesso più incerto proprio in ragione del fatto che non si sa mai un giudice anche su un filone giurisprudenziale consolidato che possa mai essere convinto di distinguish the case, di distinguere il caso concreto dal precedente. Ok? Quindi ora vi faccio una domanda. Secondo voi queste caratteristiche del diritto americano che impatto avrà sui contratti? Cosa determinerà nella redazione di un contratto?
Saranno lunghissimi.
Bravissima, questo lo sappiamo,
Sì,
lo
si sapeva.
sappiamo purtroppo, bravissima, contratti più elaborati. Il contratto diventa quasi una sorta di legge privata tra le parti, si cerca di includere tutto l'immaginabile possibile per evitare un'area di incertezza che poi possa dar luogo a una disputa, a una causa. Quindi tecniche di drafting esaustive, che i nostri clienti fanno disperare i nostri clienti, ma l'avvocato americano, come sapete, ma anche questa è una tecnica che si diffonde, ovviamente anche l'avvocato inglese, ma è una tecnica che si sta diffondendo anche in Italia, ovviamente. Ma sono tecniche di drafting esaustive, per cui l'avvocato americano non si accontenta di dire se si verifica A, allora accade X. Subito dopo dirà e se non si verifica A, accadrà Y. Il cliente questo non lo capisce spesso. Come non capisce, mi piace parlare spesso al cliente dei 4 angoli del contratto. E gli dico, guarda, caro cliente, non dare per scontato, non ci sono norme suppletive di un codice qua, che se tu non lo metti nel contratto questo aspetto, si rischia di non poterne beneficiare. Si rischia che venga posto in dubbio. Quindi il tema è contratti elaborati e lunghi, prevenire, spendere di più tempo e purtroppo onorari in redigere e negoziare un contratto piuttosto che spendere tempo e denaro in un contenzioso. Questa è ovviamente la regola. Allora però il negoziato, il terzo elemento di cui parlavamo nella domanda del cliente. Ora, io parlerò più diffusamente delle tecniche negoziali, diciamo, americane, più avanti, quando parliamo della distribuzione. Però già nella domanda del cliente sono insite 2 trappole concettuali, 2 errori di impostazione. La prima è questa. Ah, abbiamo già deciso gli elementi essenziali del contratto. Avvocato, faccia in fretta, non abbiamo tempo da perdere, ci metta questo timbro su questo contratto, ecco, come se il resto, no, non fosse importante. In realtà gli americani amano dire the gods are in the details or the devil is in the details. E gli esempi si sprecano, ma per esempio, tipico esempio, nell'ambito della moda, del lusso, quando i rappresentanti di una griffa arrivano, individuano dei locali che fanno per loro, abbracciano il landlord, si mettono a un tavolino e redigono una term sheet, una letter of intent e ci dicono: avvocato, abbiamo coperto tutti, abbiamo negoziato tutto. Ah, benissimo, che avete fatto? Sì, il canone, la durata, i lavori di rinnovo, eccetera, eccetera, eccetera. E poi gli dico, guardate che ora, sapete cosa accade? Che ora ci arriverà una bozza di contratto dal legale del landlord che affronterà degli aspetti a cui forse non avete neanche pensato, tipo la radius restriction. Nei grossi centri commerciali o altrove può essere normale, cioè l'obbligo di non aprire altri negozi entro 50 km dal nostro, ad esempio. Oppure il fatto che il lease, e questo è difficile che sfugga, ma che il lease sia un triple net lease, vale a dire non si paga solo il canone, ma si pagano ovviamente l'assicurazione e si pagano le tasse immobiliari. Non avete affrontato come aumenteranno nel tempo, in modo spesso vertiginoso, le tasse immobiliari. Tutta una serie di cose che vengono tralasciate. Vi farò un altro esempio di dettaglio nell'ambito del contratto di distribuzione e della disciplina della manleva, dell'indennizzo, che spesso sfugge. Ecco, quindi l'illusione di poter negoziare, l'illusione di poter individuare gli elementi essenziali del contratto è il primo, diciamo, la prima trappola. La seconda, la conformità alle leggi. Noi vogliamo che questo contratto funzioni, che sia ammissibile negli Stati Uniti. Ora, la risposta è, guardi, caro cliente, ma se lei non sta, se l'oggetto del contratto non è illecito, se non stiamo parlando di tratta delle bianche o di commercio di stupefacenti, bene o male, ci sono pochi esempi di contratti che potranno essere, diciamo, in violazione, non conformi alla legge. Un esempio potrebbe essere, più avanti ne parleremo, del franchise involontario. Ma la realtà è che la mentalità americana è che tutto è negoziabile, quindi l'avvocato lo chiami per massimizzare il valore economico che potrai tu, caro cliente, ottenere alla fine della vita di questo contratto. Perché non è dato solo, ad esempio, dal canone che paghi o dalla durata, ma è dato da anche altre cose, da come è strutturato l'obbligo, per esempio, di indennizzo, per esempio. Potrà voler dire moltissimo a lungo andare. Infine l'avvocato, il quarto elemento. Allora, intanto gli si dice, caro cliente, ora ovviamente non gli si dice mai esplicitamente, arrivi tardi, scusa, mi chiami tardi, ma già ti sei esposto, già hai negoziato. L'avvocato americano, la figura del business lawyer, è uno più forse simile a quella del commercialista, è coinvolto nello strutturare e nel negoziare l'operazione. Tipicamente, in ragione, per, diciamo, virtù dell'incertezza di cui parlavamo del diritto, anche dell'incidenza della responsabilità professionale, che qui è molto grave, molto pesante, troverete un avvocato più cauto, più conservatore nei pareri, spesso, grossa generalizzazione, pareri più circostanziati. A me piace dire, quando mi propongono dei candidati da assumere, gli dico, guardate, non mi portate Tom Cruise qua, portatemi Woody Allen. Io voglio vedere un avvocato tormentato dai dubbi quando dà una risposta, perché spesso il dubbio paga, nel senso, avere dubbi paga in questo ordinamento. Ora, passiamo velocemente a delle caratteristiche del contenzioso americano tanto temuto che voi conoscete, una rapidità dei processi relativamente parlando, che è abbastanza documentata quantomeno in certe aree degli Stati Uniti, costi processuali sicuramente più elevati per motivi che diremo, maggiore effettività. Uno dei temi essenziali che sono assolutamente determinanti in questa, diciamo, logistica culturale o questo gap culturale è questo elemento dell'effettività che noi non abbiamo, non è nel nostro DNA. E ora vi illustrerò. Allora, caratteristiche del contenzioso. C'è quello che a me piace chiamare la trinità maledetta del contenzioso americano, quello che fa tremare gli stranieri in genere, i nostri clienti italiani. Prima cosa, la discovery. Per chi capisce realmente cosa significa la discovery, che i nostri clienti spesso non la afferrano. La discovery, come sapete, è quello scambio predibattimentale di tutte le cose che possono essere oggetto di prova, quindi sia testi che documenti, email, tutto. Sotto la vigilanza di un giudice che non è il giudice del dibattimento. Qual è l'impatto della discovery? Due cose fondamentali. Uno, mediamente parlando, l'azienda, la piccola media azienda sicuramente, ma anche le grandi aziende europee, non sono in grado di affrontare la discovery realmente senza sviare risorse, cioè senza prendere dipendenti e adibirla a quel compito e quindi con costi enormi. Ma forse ancora più importante è questo, che quando parte una causa in altri paesi, non anglosassoni, non di common law, in cui non c'è la discovery, diciamo, ma il concetto è, beh, intanto c'è partito l'atto di citazione, c'è un rinvio, c'è tempo, prepariamo, analizziamo, ci sarà un'udienza, eccetera, eccetera. Con la discovery, anche a non aver ragione, e poi vedremo i limiti della legge temeraria in America, si spende subito, perché si è obbligati c'è la richiesta iniziale di discovery, va esaminata, Quindi dal giorno 2 stiamo spendendo di avvocati, di contenziosisti. Questo è fondamentale. Secondo elemento, il ruolo della giuria. Se, e ecco altri dettagli importanti, se non si è introdotto una jury waiver, una disposizione con cui si rinunci alla giuria, oppure non si ha una clausola arbitrale, la causa eventuale sarà giudicata e decisa da una giuria. Immaginatevi voi l'impatto della giuria, che spesso è, diciamo, è l'elemento che determina questi risarcimenti enormi, no? È la giuria americana che decide se l'avvertenza che avete preparato per il vostro prodotto era adeguata o meno, se la capiscono o meno. The warnings. Ma pensate poi che statisticamente una giuria deciderà quasi sempre a favore della parte debole, del consumatore leso, del distributore piccolo che cita in giudizio la grande impresa. Figuriamoci poi l'azienda straniera, che fine fa con la giuria. C'era un avvocato texano che, quando si parlava di una possibile causa contro un grosso gruppo italiano, un conglomerato italiano, diceva con una parlata texana: "You guys that don't stand a snowball's chance in hell avete la stessa probabilità di successo di una palla di neve che si trovasse all'inferno, cioè zero." No, queste sono cose, c'è una giuria texana, lasciamo perdere. Allora, escludere la giuria è importante in quasi la totalità dei casi. Terzo elemento, e questo veramente fa perdere sonno ai nostri connazionali, quando gli si dice che ciascuna parte sostiene i propri costi legali. Questa è la regola. Ci sono eccezioni che vedremo tra poco, ma la regola è: caro cliente, tu puoi avere ragione al 1000%, la controparte la distruggiamo, vittoria assoluta, il giudice non è che ci attribuirà necessariamente l'obbligo alla parte soccombente di rifonderci le nostre spese legali. Pagherai di tasca tua. Ci sono naturalmente eccezioni, e ne parlerò tra un pochino delle eccezioni, ricordatemelo. Però intanto guardate, si è parlato di costi di avvocati, di costi processuali e di durate. Ora vi inviterei a guardare questa tabella. Questa è della Banca Mondiale dell'anno scorso, è simile agli anni precedenti. Cosa indica? Indica i tempi complessivi per arrivare a una sentenza di primo grado, quindi il tempo totale, la prima colonna, i tempi per la notifica, i tempi per arrivare a sentenza, i tempi per ottenerne l'esecuzione, sentenza di primo grado, ottenere l'esecuzione, e l'ultima colonna a destra il costo della procedura espressa in termini di una percentuale totale del valore della controversia. D'accordo? Quindi l'Italia purtroppo ha ancora il triste primato per cui ci vogliono più o meno più di 3 anni per arrivare mediamente, ovviamente, a una sentenza di primo grado ed eseguirla. Vedete, a New York invece è poco più di 1 anno la media. Però intanto guardate a estrema destra. Il costo complessivo dopo questi 3 anni sarà più o meno lo stesso costo di una causa a New York nell'anno richiesto, anzi un pochettino di più. Quindi dire che l'avvocato americano costa tantissimo è vero, ma si fanno le cose anche più alla svelta. Questa è la morale. Ovviamente altri primati preoccupanti sono quelli della Gran Bretagna e della California, che hanno costi elevatissimi e tempi processuali, diciamo, medi. Della California potremo parlare più avanti. La California è un po' veramente un ordinamento a sé stante, che ha tante particolarità e dal punto di vista delle cause, soprattutto dei rischi legali, è da tenere d'occhio. Torniamo al discorso del contenzioso e intanto a quelle eccezioni al principio per cui ciascuna parte sostiene i propri costi, spese processuali, costi degli avvocati. Le eccezioni sono di una frode, cioè di un dolo che ha determinato il danno, la lite temeraria, e di questo parlerò tra un attimo, e certe aree in cui è previsto legislativamente l'obbligo del soccombente di rifondere le spese del plaintiff's lawyer, per esempio l'Americans with Disabilities Act, che è la legislazione a tutela per le barriere architettoniche, di cui parleremo più avanti, l'FMLA in materia di impiego e di malattia. Sono tutti casi in cui invece non solo rischiamo di perdere, non solo rischiamo, come vedremo dopo, i punitive damages, che vanno oltre il danno, ma dobbiamo anche pagare per l'avvocato dell'attore in una class action, quindi molto preoccupante. Però focalizziamo un attimo sulla lite temeraria, perché questa è importantissima. I limiti della lite temeraria negli Stati Uniti sono difficilissime da integrare. Molto raramente un giudice dirà all'attore questa è una causa inventata, diciamo pure in termini grossolani. Come dicono i miei contenziosisti, e qui ho resistito dalla tentazione di introdurre l'immagine di un panino al prosciutto. Io però vorrei che vi rimanesse impresso, pensando al plaintiff's lawyer americano, un panino al prosciutto, San Daniele, Parma, quello che è. Perché? Perché i miei contenziosisti mi ricordano sempre you can sue a ham sandwich. Tu puoi portare una causa contro un panino al prosciutto, vale a dire, è un modo di dire per dire sia dal punto di vista della legittimazione attiva, sia dal punto di vista del merito, c'è una libertà quasi assoluta. Quindi da tenere presente anche nel proseguio, anche nel negoziato, la libertà in questo senso. I punitive damages, li conoscete, i treble damages e i punitive damages sono quel danno, quel risarcimento che il giudice commina per ipotesi particolarmente gravi di dolo, di negligenza gravissima, che vanno oltre la misura del danno subito dall'attore e quindi servono ovviamente a incentivare delle condotte di correttive. Sapete anche, per tutti questi motivi, soprattutto per l'aspetto costo, c'è negli Stati Uniti un'altissima incidenza delle transazioni, più del 90%, quasi sempre. Altro aspetto fondamentale, la prescrizione. E una cosa da cui va tenuto presente è che negli Stati Uniti la prescrizione non si interrompe con una lettera di messa in mora. È richiesta un riconoscimento del debito con una scadenza, una promessa di pagamento. Questo può voler dire molto, come sapete, se si presume che con una lettera si abbia arrestato il corso della prescrizione. Un altro errore a cui facevo riferimento, come esempio, lo vedremo più avanti, è quello per cui negli Stati Uniti non esiste il decreto ingiuntivo. E lo vedremo più avanti in ambito della discussione sul contratto di distribuzione. Allora, per questa parte introduttiva, diciamo pure che conclusioni si possono trarre. Abbiamo detto c'è un diritto con maggiore incertezza, costi legali generalmente più elevati, spesso di gran lunga, una maggiore effettività del sistema giuridico, intesa nel senso che è più probabile arrivare relativamente rapidamente a una decisione o comunque alla necessità di transigere. Difficile scappare dall'attore. Quali sono le conseguenze per l'imprenditore italiano nella mente di chi investe negli Stati Uniti diciamo, da un ordinamento europeo? In termini relativi, una maggiore rilevanza degli aspetti legali. E questa è chiave da far capire che l'impresa che dedica tempi enormi alla strategia, a scegliersi partners, a giudicare tutti gli aspetti commerciali, a raccogliere i dati di vendita, eccetera, eccetera, e dedica una parte piccolissima della propria attenzione, del proprio budget all'aspetto legale. Questo è un fatto culturale, ma va sottolineato. Vi faccio un'illustrazione solo perché capiate come funziona realmente questa maggiore effettività. Mi trovo in una situazione, ma accade abbastanza spesso, alla firma, in questo caso il contratto a cui facevo riferimento prima, il grosso contratto di locazione con un landlord americano. Un contratto prevede una durata ventennale, una ottantina di pagine, disposizione su disposizione negoziata ad oltranza, triple net lease, tasse, no, che si prevede possono aumentare nel tempo, e il rappresentante del nostro cliente seduto mi fa: allora, avvocato, ma posso firmare? No, può firmare, un momento, ma ne abbiamo mandato anche un resoconto di tutti gli aspetti, diciamo, di rischio che ci sono. E fa: vabbè, ma tanto, avvocato, se va storto, se il mercato va giù, no? Se andiamo in difficoltà, rinegoziamo. Allora, a parte abbiamo visto anche nel corso della pandemia quanto è stato difficile rinegoziare contratti in questa situazione di emergenza. Lasciamo stare questo. Ma il landlord americano, e anzi è accaduto il landlord americano che quando arriva il cliente europeo, gli arriva in sala riunioni e dice: guardi, vogliamo rinegoziare, si mettono a ridere. Perché l'anno dice: cosa fa lei? Perché in Italia cosa farebbe il nostro cliente? Di un momento, ma io sono in difficoltà, il negozio non vende più, sono in difficoltà per pagare il canone. Allora il landlord, il proprietario italiano ha un incentivo a rinegoziare, perché se deve iniziare una causa, no? Verosimilmente avrà grosse difficoltà a ottenere soddisfazione. Qui il landlord americano in 448 ha già praticamente, si è soddisfatto sulla lettera di credito, ha già messo in default il proprio cliente, il locatario, non ha a New York neanche l'obbligo di mitigare il danno. Vale a dire, il nostro cliente rimane obbligato anche se il nostro non ha cercato di sostituire il locatario attuale con un altro. Quindi immaginatevi, quindi è un'abitudine diversa di non aver paura delle conseguenze che invece qui ci sono, per spiegare questo aspetto dell'effettività. Allora, conclusa, se non avete domande su questa, conclusa questa parte introduttiva, io vorrei passare a esaminare, diciamo, la prima fase tipica dell'investimento, dell'approdo al mercato americano dell'azienda europea, dell'azienda italiana, che tipicamente può essere quella di fare un passo cauto, un passo sperimentale, e cioè di commercializzare il prodotto, testare il mercato tramite un agente o tramite un distributore o più distributori. Cosa normale, lo si fa anche in altri paesi ovviamente. Questo ovviamente per non esporsi a rischi e a investimenti più grossi, senza avere sperimentato il mercato in questione. La scelta tra agente e distributore, come anche in altre zone, dipenderà anche molto dalle caratteristiche del prodotto e del mercato, ma più o meno molte delle considerazioni che facciamo qui per il distributore valgono anche per l'agente. Ci sono minori norme imperative in materia. Per il distributore in termini assoluti, per l'agente pochissimi, cioè non c'è un equivalente alle direttive europee che tutelano l'agente, non ci sono forme di contrattazione collettiva o posizioni di, diciamo, norme che tutelino in modo imperativo il contraente debole, che in questo caso sarebbe l'agente o distributore. Detto questo, intanto al cliente, prima di scegliere, dobbiamo fargli pensare alle caratteristiche del territorio. Ovviamente, oltre alla, diciamo, vastità in termini geografici del mercato americano, e questo pensate, cioè intanto pensate a questo, mentre è concepibile che una nostra azienda possa avere un distributore in Germania, uno in Svezia, uno in Olanda, è possibile. Pensare di avere un solo distributore per tutti gli Stati Uniti è veramente difficile, cioè quasi nessuno lo fa. Non solo, ma le dimensioni, non solo geografiche, ma anche la concentrazione a livello delle canali distributive è tale per cui spesso il mercato americano presenta delle barriere alle entrate forti. E un esempio forse più indicato è l'esempio dell'alimentare, del food, dove spesso addirittura un'azienda di primissimo rango in Italia o in Europa che ha un prodotto eccellente, che vende benissimo, spesso addirittura non riesce neanche a fissare un appuntamento col broker del supermercato, del distributore. Perché il broker gli fa: mi scusi, ma che capacità produttiva avete? Riuscite a riempire tutti gli scaffali della catena di supermercati? Questo è un problema è ricorrente. E l'unica sono le forme, la soluzione sono delle forme aggregative, le forme consortili. Comunque di questo potremo parlare in un'altra occasione.
Pronto?
Prego. Non ho sentito. Ah, forse non c'è.
No, la trovo al mio.
Ecco. Allora, l'altro aspetto importantissimo da considerare è la diversità, proprio in senso non solo geografico, ma anche in senso demografico. Non solo abbiamo 50 sistemi di legge, non solo abbiamo una geografia molto diversa, abbiamo anche una demografica molto diversa, stato per stato, zona per zona. Quindi, per esempio, per un'azienda di moda, vendere un vestito a una signora di Miami oppure venderlo alla signora di Boston o di California sono cose radicalmente diverse, non solo per le, diciamo, per le preferenze del consumatore, non solo per le esigenze del consumatore, addirittura a livello, diciamo, demografico, fisico, le dimensioni. Quindi da tenere presente anche questo. Ecco, un dato importante è la concentrazione. Questo è molto interessante. Se vedete questa immagine, vedrete che quasi un terzo del prodotto interno lordo degli Stati Uniti è generato in sole 31 contee, vale a dire più o meno 31 città, diciamo. Ma queste 31 città sono l'1% delle città americane. Quindi vedete qua, è concepibile che il fornitore europeo, fornitore italiano, scelga delle zone e si concentri sul Northeast, sul Southeast, sulla West Coast, sul Midwest, dove più crede. Allora, parlando del contratto di distribuzione, la scelta del distributore, qui intanto avvertenze di cui parleremo più avanti. Il distributore americano, come molti distributori, è tendenzialmente da prendere con le proverbiali molle. E questo perché, da un lato, più bravo è, in fin dei conti, qual è il mestiere del distributore? È un venditore, più bravo è, più aggressivo è. E quindi sarà anche un negoziatore difficile, lo vedremo più avanti. La scelta del distributore è importantissimo. Il nostro consiglio è quello di evitare conversazioni esplorative, parlare per parlare, semplicemente perché in quelle conversazioni inevitabilmente si rivelano delle informazioni, soprattutto relative al prezzo, ai canali di vendita, eccetera, che poi possono venire sfruttate in domani dal distributore scartato, diciamo, da quello che non è stato accettato dal fornitore, per delle recriminazioni, soprattutto in materia di antitrust. Definizione del territorio, anche qui attenzione a verificare che il distributore è effettivamente in grado di coprire il territorio che propone, dati i discorsi che abbiamo fatto prima. Ecco, della legge applicabile e clausole giurisdizionali ne parleremo più avanti con Jim Rosner, quindi rinvio a quanto dirà Jim Rosner che esaminerà questo aspetto in dettaglio, in via generale, non solo nei contratti di distribuzione. I seguenti aspetti sono simili a quelli che incontriamo anche in altri contratti in altri paesi, quindi non mi dilungo molto. Direi semmai che possiamo soffermarci un attimo sul tema intanto dei minimi di vendita. Come in altri paesi, importante prevedere un meccanismo automatico di aumento se le parti non si dovessero accordare in un futuro rinnovo, che questo è spesso oggetto di contenzioso. Vale a dire, se il contratto si rinnova automaticamente, le parti non si accordano, è meglio prevedere un aumento di base, un aumento percentuale base. Riservarsi la facoltà di modificare i prezzi, importantissimo. Sulla durata, ecco, questo è un altro aspetto. Al nostro cliente europeo consigliamo sempre di resistere alla tentazione di fissare un termine eccessivo, termine iniziale lungo. Perché? Perché la tendenza è quella, hanno lottato, hanno negoziato strenuamente per settimane e mesi, dicono io, guardi avvocato, non voglio trovarmi fra un anno a rilitigare con Bob qui su queste cose. Quindi facciamo un termine lungo. Il nostro consiglio invece è un termine iniziale breve e rinnovi annuali. Questo è in base a quello che vediamo. Riservarsi possibilmente la facoltà di recesso ad nutum, senza dover indicare motivi, ma anche quando siamo riusciti a negoziare e ottenere la facoltà di recesso ad nutum, è sempre meglio innanzitutto documentare bene l'andamento del rapporto e dell'adempimento o meno da parte del distributore, documentarlo bene, e al momento del recesso dare un preavviso il più lungo possibile, anche oltre quanto previsto contrattualmente, e in terzo luogo cercare di minimizzare il disagio, minimizzare il danno che subisce il distributore, in sostanza per far assorbire il colpo della risoluzione del rapporto. Questo perché le probabilità di una causa successiva alla risoluzione del rapporto è elevatissima, vogliamo cercare di renderla meno probabile e di levare più armi possibili. Saranno possibili permessi, la necessità di ottenere permessi amministrativi, l'FDA per l'alimentare spesso, o anche il Department of Agriculture, l'FTC, permessi ad esempio inerenti alle sostanze e alle pellicce, per esempio, nell'ambito della moda. Sono esempi classici, ovviamente adempimenti doganali. Allora, veniamo ai pericoli più grossi da evitare. Ho già accennato ad un aspetto. Pericoli più grossi da evitare con il contratto con il distributore. Parleremo della registrazione del marchio e del cosiddetto franchising volontario fra pochino. Gestione del credito. Dicevamo prima, intanto non esiste la possibilità di mettere in mora con una lettera unilaterale. Non solo, ma un altro aspetto, e questo è uno di quei classici errori di cui abbiamo parlato con Enzo Ferrari, il classico errore del fornitore italiano è di pensare che ci sarà sicuramente negli Stati Uniti, paese avanzato, la figura del decreto ingiuntivo di qualcosa di simile. Quindi posso avere una fattura, un credito liquido, certo ed esigibile, e invece qua, sulla base soltanto di questo e di un contratto, si dovrà iniziare una causa a cognizione ordinaria, quindi con i tempi e i costi normali, non una procedura accelerata. Quindi gestire attentamente il credito, termini brevi, cash on delivery nei casi estremi, se possibile nei settori in cui è concepibile una standby letter of credit. Esiste anche un istituto che è il security interest, il purchase money security interest, che è una sorta di diritto di seguito che potrà dare una preferenza del fornitore rispetto alla merce venduta e al corrispettivo rispetto al concorso di altri creditori in sede di fallimento. Gli aspetti di antitrust. Ecco, questi sono degli aspetti che spesso il distributore può sfruttare anche a prescindere dal merito, cioè semplicemente come arma di fronte alla risoluzione del rapporto. Cioè si trovano sempre, argomentazioni del tipo: guardi, signor giudice, ipotetico, il fornitore ha risolto il rapporto non perché per un inadempimento, ma in realtà perché io scontavo i prezzi. Questo è il mantra, è il leitmotiv. L'antitrust americano è a dir poco complesso. Lo Sherman Act, uno dei primi elementi legislativi di maggiore importanza, prevedeva una regola di illiceità per sé, intrinseca di qualsiasi accordo relativo al prezzo, al mantenimento dei prezzi di rivendita. Questa è la regola base, the per se rule. Mentre per accordi che non attengono al prezzo c'è la cosiddetta rule of reason, vale a dire il giudice dovrebbe valutare volta a volta, caso a caso, se l'accordo che non attiene al prezzo sia o meno anticoncorrenziale. A confondere le cose, la Corte Suprema nel caso Lige nel 2007 ha confuso le acque dicendo: un momento, ci possono essere dei casi di accordi relativi di mantenimento dei prezzi a cui invece va applicata la rule of reason, in cui vanno valutati, non sono tutti necessariamente illeciti i sé per sé. A confondere ulteriormente c'è il fatto che molte legislazioni statali e la giurisprudenza statale prevede di nuovo questa regola intrinseca del per sé. Mi capite che è un'area molto complessa e difficile. Allora c'è una forma di scappatoia, una cosiddetta safe harbor, che proviene dal caso Colgate, un caso della Corte Suprema del 1919, in cui la Corte ha stabilito che un accordo puramente unilaterale, non un accordo, scusate, una politica, un annuncio puramente unilaterale da parte col fornitore con cui annuncia che intende praticare soltanto un determinato prezzo e quindi farà affari fondamentalmente soltanto con distributori che rispettino questo prezzo minimo, è ammissibile, non è una violazione delle norme antitrust, perché non è un accordo. Il problema è, a me piace dire spesso, no, qual è la differenza tra la teoria e la pratica. La differenza è che in teoria non c'è alcuna differenza, no? Quindi teoricamente questa politica che piace moltissimo a tanti fornitori è quella. In pratica cosa accade? Che i commerciali del nostro venditore, del nostro fornitore, nel momento in cui il distributore comincia a scontare, alzano il telefono e dice: senti Bob, ma guarda che noi abbiamo questa politica naturale, guarda che va a finire che dobbiamo risolvere il rapporto, dobbiamo dar disdetta. Allora cosa fa il distributore? Corregge il tiro ed ecco che si individua che quello che prima era una politica unilaterale è diventato un accordo, perché ho esercitato non persuasione, ho esercitato pressioni. Ammissibile anche la cosiddetta minimum advertised price, cioè una politica e una sorta di accordo, è un accordo relativo soltanto al minimo prezzo di pubblicità, però anche questo presenta problemi analoghi, cioè è facile riconfigurarlo come un accordo relativo al prezzo successivamente. Ecco, continuiamo con i pericoli. Tema della product liability che conoscete anche se fosse soltanto per quello che sentiamo nei media, casi famosissimi con risarcimenti enormi. Focalizziamo su questo aspetto, siccome le fonti di responsabilità possono essere sia la negligenza che la responsabilità oggettiva, sia le garanzie che possono essere date al prodotto, c'è da dire che le corti americane sono abbastanza concordi nel ritenere che il consumatore o il terzo leso da un prodotto possa fondamentalmente far causa a tutte le parti, tutte le componenti della rete di distribuzione, dal fornitore fino al rivenditore ultimo. Tutti possono essere coinvolti. You can sue a ham sandwich, il famoso panino al prosciutto, scusate. E non solo, ma di conseguenza c'è un obbligo di indennizzo implicito da parte del fornitore se non c'è un concorso di colpa. Vale a dire, si ammette fondamentalmente che l'attore, la parte debole, il consumatore possa fondamentalmente far causa contro le parti che conosce, le parti con cui ha avuto rapporti, le parti con cui ha concluso un contratto, ma si prevede anche ovviamente l'obbligo di indennizzo da parte del fornitore del prodotto. E quindi ecco i dettagli importantissimi nel contratto, nel stilare, nel redigere le garanzie e soprattutto la parte del contratto relativa all'indemnification. all'indennizzo. E qui di nuovo i dettagli, perché il cliente mi può dire: guardi, il nostro avvocato è riuscito, perfino a includere, diciamo, escludere l'indennizzo per colpa grave. Beh, bravo, a parte che è difficilissimo provare la colpa grave, gross negligence, o willful misconduct, il dolo. Difficilissimo da provarlo. Ma qual è il dettaglio, il diavolo di cui parlavamo prima, che spesso si trova? Ammettendo che il distributore possa ammettere, va bene, se trovi un esempio di colpa o colpa grave, non ti tocca manlevarmi, non vale l'indennizzo. Difficilissimo, perché spesso il distributore non ne vuole sapere, vuole essere indennizzato. Se mi fa causa un terzo, tu mi devi manlevare. Questo è l'atteggiamento di partenza del distributore. Ma ammettiamo che abbia accettato, ok, escludiamo la colpa grave, la gross negligence. Cosa farà il legale del distributore? Includerà una frase che dica gross negligence, però che sia accertata giudizialmente. E quindi ora cosa entra in gioco qua, nella manleva? Entra tutto quel che si diceva rispetto alla discovery e via dicendo, al processo. Perché io, dal momento che dovrei attendere una sentenza finale che dica sì, e riconosca che il distributore era colpevole, io intanto sono costretto, io fornitore, sono costretto a manlevare, quindi a sostenere le spese legali della discovery, di tutto quant'altro, oppure il mero negoziato per arrivare a una transazione del mio distributore. Ecco il dettaglio di cui vi parlavo prima. Io vi farei un esempio interessante in questo senso, che è abbastanza, diciamo, può anche essere, illustra un po' gli estremi a cui si arrivano, ma è un esempio che ci è capitato da un cliente che purtroppo è arrivato tardi, perché non abbiamo negoziato noi i contratti, ma un cliente, diciamo, produttore di laser molto avanzati, prodotti eccezionali, che vengono utilizzati anche per delle cure estetiche, in questo caso depilazione. Una signora va a una casa di cure estetiche per una depilazione. Venga somministrata male la cura e lei porta delle ustioni dal laser, no? Riporta delle ustioni. Si dà il caso che era colpa grave del distributore, del rivenditore finale, però c'era anche la waiver, la rinuncia della signora a portare azioni in base alla cura. Quindi aveva rinunciato al diritto di causa. Chi fa causa? E di nuovo torna il discorso, scusatemi, del ham sandwich. Chi è che porta la causa a tutta la compagine? Al distributore, al rivenditore, diciamo alla casa di cura e al fornitore? Il marito. Il marito della signora, perché siccome lei ha dovuto portare le fasce per varie settimane per mancato connubio. La doglianza indicava questo, vi rendete conto? Ora, qui c'era di mezzo anche questa colpa, diciamo pure grave, di chi ha somministrato la cura. C'era una clausola di quella di cui parlavamo prima, che richiedeva che fosse determinato giudizialmente questa colpa grave del rivenditore o comunque di chi somministrava la cura, ed ecco che il nostro cliente ha dovuto transigere per una somma molto contenuta, perché francamente l'argomento del mancato connubio era molto tenue, ma insomma ha dovuto transigere per una somma relativamente contenuta. Assicurazione diventa, se c'è forse una parola che vorrei che vi ricordaste da tutta questa chiacchierata, è l'assicurazione. E perché dico questo? Il cliente mi dice spesso, ma avvocato, certo che siamo assicurati, abbiamo un'assicurazione con l'Alliance globale, benissimo. Il problema è che tale assicurazione spesso è inadeguata, anche se globale, per il mercato americano, e non solo, ma di fatto quando viene iniziata una causa, spesso la gestione dall'Italia o dall'Europa di questa causa da parte del broker assicurativo europeo è spesso insufficiente. Molto meglio far seguire un problema che si dovesse sorgere dal broker con un'assicurazione locale, assicurazione per il fornitore in questo caso, ma si deve imporre anche al distributore di avere un'assicurazione adeguata che indichi come additional insured o additional beneficiary il fornitore stesso. Importantissimo. E di questo potreste parlare tranquillamente con dei broker assicurativi americani per avere più informazioni. Un'altra sorpresa in cui ci si può imbattere nel...
Posso fare una domanda?
Prego, prego.
Chiedo scusa, ma l'inadeguatezza dell'eventuale copertura assicurativa globale che può avere il fornitore italiano con una compagnia italiana piuttosto che europea è un'inadeguatezza solamente sotto il profilo delle clausole della polizza stessa o è anche un'inadeguatezza sotto il profilo economico?
Prevalentemente economico.
Perché non è rapportata alla magnitudo dei risarcimenti.
Numero uno, economico, anche alle clausole stesse, perché diciamo ci possono essere delle interpretazioni, delle clausole diverse e che ci tornano contro, ma poi, ripeto, spesso la metà della battaglia è la logistica. La logistica di una causa americana è qualcosa che viene gestita molto male dall'assicuratore, diciamo, che si sta a Torino, a Milano, per dire, no? Questa è la realtà. La logistica invece impone che sia un broker americano che è abituato a avere a che fare con i legali americani e a gestirla da qua, è giorno e notte. Quasi forse più importante dello scelta dello studio legale, non dovrei dirlo, ma delle volte lo può essere. Allora, sorpresona piuttosto che può incontrare il nostro cliente europeo italiano è quella del cosiddetto franchise involontario. Il franchise, scoprite perché, il franchise è regolato anche qui, purtroppo, a livello federale con l'FTC Rule e a livello statale con tante legislazioni statali, che rende molto complessa la materia. Quali sono i 3 elementi che possono fare ravvisare un franchise anche quando le parti non lo vogliono, anche quando le parti non ci hanno pensato? La licenza di un marchio, quindi si affida al nostro distributore, che in realtà è un franchisee, un marchio. Controllo o assistenza da parte del franchisor, da parte del fornitore, che impone una certa modalità di vendita, impone degli orari, impone, che so io, un menu, impone delle uniformi, quello che è. Controllo o assistenza di qualsiasi forma. Pagamento di un compenso minimo, mi sembra ci sia un minimo di $500 sotto forma di royalty, di canone, di somma iniziale nei primi 6 mesi del rapporto. Quali sono le conseguenze? Queste sono tutte norme imperative, cosa molto strana nei rapporti commerciali americani. Norme imperative, quindi anche ove le parti avessero detto espressamente questo è un contratto di distribuzione, non è un rapporto di franchise, queste norme che sono a tutela della parte debole, che si ritiene debole, applicano comunque. Intanto ci sono dei requisiti di informazione del franchisee, cioè una disclosure che viene fatta secondo forme prestabilite molto onerosa, la registrazione presso l'FTC e gli stati molto onerosa, cioè un procedimento che è pesante. Multe e sanzioni addirittura penali per chi non rispettasse le norme. C'è poi questa forte tutela per il franchisee, per il nostro distributore mancato, la possibilità di rescindere il contratto, oppure la possibilità di ottenere una ingiunzione che impedisca la risoluzione del contratto. Quando il fornitore scopre, oddio, questa è una franchise, non se ne parla, potere ingiuntivo. Inoltre c'è una sorta di trattamento di fine rapporto, cioè è prevista un'indennità legale per la fine del rapporto che non esiste per il distributore puro e neanche per l'agente, cioè salvo casi particolarissimi. Infine, e questa è la ciliegina sulla torta, di fronte a un franchise c'è la responsabilità solidale del franchisor per le obbligazioni, per la responsabilità soprattutto verso terzi del franchisee. Registrazione del marchio, sorprese anche qua o cose da evitare. Prima di tutto, per favore resistere alla tentazione di far registrare il marchio dal distributore. Spesso il nostro cliente, perché vuol risparmiarsi la fatica oppure soprattutto l'onere finanziario, i costi legali e tutto, oppure perché pensa di incentivare maggiormente il proprio distributore, far registrare il marchio al proprio distributore. Pericolosissimo perché al momento della fine del rapporto può essere difficilissimo districare, può essere difficilissimo avere piena titolarità dei diritti. Ecco, altra abitudine, evitiamo di registrare per intere classi di prodotti o servizi se questi non sono venduti negli Stati Uniti, perché una registrazione del genere può essere contestata. Consigliamo sempre una ricerca di anteriorità e un parere legale. E questo principalmente per prevenire i famosi punitive damages, sono quelli che prescindono dal danno effettivo ma sono punitivi, ove vi fosse una contestazione. Ecco, anche qui assicurazione del distributore di cui abbiamo parlato prima, non solo per le ipotesi di danno da prodotto, ma anche per i danni che possono derivare dalla pubblicità. Danni pubblicitari, false advertising e via discorrendo. Ecco, ora fra poco arriveremo al discorso del negoziato. Vi dicevo che il distributore americano ha questa duplice natura, per cui spesso, paradossalmente, deve essere bravissimo, ma non troppo bravo. Pensate al fardello che porta anche a livello, diciamo, psicologico un distributore. Bravissimo, ma non troppo bravo, perché se è bravo deve promuovere e sviluppare il mercato, deve promuovere il prodotto, ma se è bravissimo cosa accade? Crea le condizioni per che cosa? Crea le condizioni perché il proprio fornitore entri nel mercato in proprio, no? Che è la fine del rapporto. Quindi entra o con una dual distribution oppure addirittura soppianti interamente la rete del distributore. Quindi consigli pratici. Prima di tutto, non sottovalutiamo il nostro distributore americano, assolutamente. E di questo parliamo più avanti, tra 2 minuti, nel negoziato. Non sottovalutiamo il distributore, soprattutto per i pericoli di appropriazione del marchio, del goodwill, o per la violazione dell'esclusiva di altri distributori in territori, eccetera, anche il parallelo. Ma neanche bisogna sopravvalutarlo, non presumere che il distributore compia delle operazioni oppure assolva degli obblighi che ci aspetteremmo normalmente, per esempio in Italia. Ma vi faccio un esempio, promozione e merchandising in un grande magazzino in Italia, è normale che se io ho un rapporto con la Rinascente, che la Rinascente si sobbarchi l'onere di una certa presentazione del prodotto, tutta una serie di obblighi. Negli Stati Uniti, Bloomingdale's, non più Bloomingdale's, Neiman Marcus, Saks mettono il nome e ai nostri, diciamo, clienti nel settore abbigliamento gli tocca fare quasi tutto. Quindi non sopravvalutarlo. Soprattutto attenzione, visto le potenziali responsabilità in materia extracontrattuale e per danno da prodotto, attenzione nel dedicare risorse all'addestramento, a creare una manualistica molto attenta e puntuale che sia portata all'attenzione degli operatori, dei venditori, degli operatori, del distributore e firmato. Attenzione agli obblighi di post vendita. E veniamo adesso un po' al negoziato con il nostro distributore. Molte di queste cose si applicano anche oltre l'ambito della distribuzione e il contraente americano in genere. Ma focalizzando su di lui, intanto direi 2 cose. Il fondatore del nostro studio, George Pavia, amava dire spesso che, e questo ovviamente non va preso in termini assoluti, è un'espressione abbastanza, un'immagine abbastanza colorita, ma diceva che il vizio cardinale di noi italiani è la presunzione, no? Negli affari, la presunzione che non è a livello personale di carattere, è culturale. Noi italiani, diciamolo pure, abbiamo inventato la civiltà occidentale, diciamolo pure. Abbiamo, e qui va detto, ogni tanto va detto, il diritto, se permettete, grosso modo, l'abbiamo inventato noi, vabbè, con un po' d'aiuto dei predecessori greci, ma fondamentalmente il common law è basato sul diritto romano, che non ci dicono diversamente. Cosa mi vuole insegnare questo qua? No, questo americano che non ha neanche un grado di istruzione, cioè, molti dei nostri clienti provengono, cioè hanno, diciamo, ha un background accademico importante, oppure hanno una formazione notevole. Tipicamente il vostro distributore avrà fatto esperienza in 2 settori: vendite, retail o immobiliare. Magari non ha neanche fatto l'università, per dire. Quindi pericolo, presunzione. Dall'altro lato, dice George Pavia, il vizio cardinale degli americani è l'ipocrisia. Perché? Perché il contraente americano tipicamente, e ancora non è una cosa personale, è culturale, tipicamente sarà molto amichevole, molto entusiasta, molto positivo, propositivo, vi invita i weekend a pescare, vi invita nella villa, vi viene a trovare in Italia, amici da sempre, conosciamo le nostre famiglie, i nostri figli vanno assieme, eccetera, eccetera. Al momento opportuno vi mangiano vivi, la pugnalata alle spalle. Ipocrisia. Perché questo? È un fatto, diciamo, culturale, per cui nel negoziare tutto è consentito. All is fair in love and war. Ora però, io vi cito specificamente nella distribuzione, ci sono tanti esempi di distributori che hanno fagocitato letteralmente il fornitore per una serie di passaggi, soprattutto in termini di forniture, di pagamenti. A un certo punto sono in grado di registrare il marchio e pian piano inglobarsi il proprio fornitore. Non sarebbe la prima volta. Quindi, in cosa consiste il negoziato con il distributore americano? In via generale, l'americano, e soprattutto il legale, e qui devo citare di nuovo George Pavia, perché ne diceva cose tante divertenti, ma questa ve la devo dire, con tutto il rispetto per i miei amici siciliani, che rispetto e amo tanto, ma diceva ci sono 2 combinazioni letali al mondo. La prima, più letale, è il siciliano con la sua lupara. La seconda combinazione più pericolosa è il distributore americano col proprio legale. Il legale americano tipicamente è un positional bargainer. Cos'è il positional bargaining? Lo sapete benissimo, è quella sorta, passate il termine, il mercato delle vacche, per cui per arrivare a 500 io parto da 1000, no? Di fronte a questo, e in contrapposizione a il consensual bargaining, per cui si dice sappiamo tutti, andiamo immediatamente al punto mediano perché è meno costoso, è meno faticoso, tanto lo sappiamo. E questo purtroppo è spesso l'atteggiamento dei nostri connazionali. Dio ce ne scampi che il rappresentante del nostro cliente sia un ingegnere. Io sono figlio di un ingegnere, ho avuto 3 zii ingegneri. L'ingegnere è la specie più pericolosa per l'avvocato, assolutamente, perché la prima cosa che diranno: ma su avvocato, andiamo direttamente al sodo, perdiamo tempo, spendiamo solo di avvocati, non lo sappiamo tutti che la posizione è questa, andiamo dritto al sodo. Quante volte vi capita di sentire questo atteggiamento? Ma cosa, perdiamo tempo, lo sappiamo tutti dove andiamo a finire. Allora, io vorrei mostrarvi una cosa, questa la chiamo l'atteggiamento dell'uomo di mondo, no? Vi faccio un esempio. Supponiamo che a Carlo Mastellone interessi acquistare questo guerriero di terracotta qua. Supponiamo che non ci conosciamo e che lui vuole questa statuina. Supponiamo che sappiamo tutti e 2 che il valore di questa statuina è 500, ok? Sia io che lui. Il valore di mercato sarebbe 500, non solo, ma Carlo, tutto sommato, come prezzo gli starebbe bene, no? E anch'io come venditore dico, vabbè, io a 500 lo vendo bene, non è un problema. Eccolo qua. Allora, io potrei fare l'uomo di mondo. Dice Carlo, senti, ma ti va questa statuina qua per 500? Gli mostro tutti i requisiti. E Carlo potrebbe dire, in un momento di razionalità, potrebbe dire, cioè, perché no? 500 è il prezzo che volevo, statuina, perché no? Stretta di mano e la vendiamo. Ma è molto più probabile che Carlo, non conoscendomi, Carlo dica, un momento, ma perché mi offre 500 e non 750 questo venditore? Cosa c'è? Sarà mica un falso, avrà qualche vizio, forse ha un modello, un'altra statua migliore che sta tenendo, non lo so. È molto più probabile che Carlo dica, guardi, no, io in realtà volevo spendere solo 300. Allora io, per voler fare l'uomo di mondo, molto probabilmente ci rimetterò, perché molto probabilmente chiuderemo a 400. Ora, la Harvard Negotiation Institute, che ha condotto ovviamente studi statistici sul negoziato, ha indicato delle cose interessanti. Una delle più interessanti è questa, è che questo gioco delle parti, cioè questo dare, diciamo, strappare reciproche concessioni per arrivare al punto d'accordo, rende molto più probabile un accordo. Cioè io sono molto più disposto, sono molto più incline a dire di sì, a stringere la mano quando pensi di aver strappato qualcosa dall'avversario. È un meccanismo naturale, è il meccanismo per cui quando c'è uno sconto si compra. Ah, guarda, sono riuscito a ottenere lo sconto, sì! È un fatto psicologico basilare. L'altra cosa messa in luce dal Harvard Negotiation Institute è che tutte le parti contrattuali, anche gli americani, anche il suo distributore, teme in modo irrazionale, cioè sopravvaluta il rischio di recesso della controparte. La mia impressione è che noi europei, soprattutto gli italiani, i francesi, ma anche altri europei, siamo più timorosi di questo. Quante volte sento dire dal cliente, ma avvocato, non possiamo rispondere così, se ne vanno. Cioè, la cosa da capire fondamentalmente è che l'americano concepisce il negoziato come un gioco, lo pianifica, c'ha tutta una strategia, è pronto quasi a tutto. E la barzelletta è: quando è che sai che un americano ha abbandonato le trattative in modo definitivo? Soltanto quando vedi ripartire l'aereo. Cioè, altrimenti quelli stanno a un gioco e noi dobbiamo fare parimenti, ovviamente, col nostro stile. Ci sono degli elementi proprio culturali, quasi, io direi quasi di pudore. Quindi, attenzione, l'ingegnere, il nostro cliente che pensa che il negoziato sia tutto un discorso tecnico, no? Tutto razionale, deve essere al corrente di elementi che sono psicologici, che elementi sono culturali. Ad esempio, vi faccio un altro esempio. Cliente nel settore lusso che sta cercando un direttore vendite americano, un commerciale, dice: guardi avvocato, devo intervistare il tal di tali. Poi le dico come va. Bene, lo intervista, fanno una chiacchierata e si mettono d'accordo per l'assunzione. Poi mi dice: ma guardi avvocato, ma questo responsabile, ma è un delinquente. Ma come è un delinquente? Perché? Perché partito mi chiedeva 360 di base più bonus e alla fine ci siamo accordati per 250. Cioè, capite? Cioè, il fatto che fosse partito dalla Luna, che fosse partito lontano, è visto come qualcosa che abbia un disvalore. E quindi c'è una sorta spesso di timore o di pudore in questo senso nel negoziato. Bisogna essere un attimino un po' più ipocriti. Così come il ruolo del silenzio, il fatto di non rispondere a una posizione, sia in un momento, diciamo, dal vivo, che in un momento negoziale, quando ci si scambia testi contrattuali, la paura che il silenzio faccia crollare le trattative. Non vero. State calmi, keep your head down, keep moving, state fermi. La responsabilità precontrattuale, questo è un altro elemento tecnico, ma molto importante, perché gli estremi della responsabilità precontrattuale, scusate, negli Stati Uniti sono anch'essi difficilissimi da integrare. praticamente ci vuole, direi, il dolo diretto, cioè ci vuole l'intenzione di danneggiare la controparte prolungando le trattative sapendo che non si arriverà mai a un accordo. Molto difficile da approvare. Quindi mi immaginate cosa voglia dire in un negoziato. Che finché non si è firmato non c'è alcun impegno. Quindi attenzione veramente a non cadere anche in questa trappola. Infine la mia preferita, il timore dei costi legali, perché alla fine è questo che conta. Il distributore, il cliente americano è ben contento di usare il proprio legale, lo usa come arma, lo usa come strumento. La prima cosa che fa l'americano è che deve fare un'operazione, aspetta, apre il portafogli, aspetta, devo trovarmi il legale, subito. L'italiano, il francese, lo spagnolo, molte altre, diciamo, nazionalità, anche i nostri amici cinesi, tipicamente sono molto più restii. Concettualmente, cioè vanno, io scherzosamente, ora spero che non abbiamo clienti sulla questa Zoom, perché dico spesso dei nostri clienti, vanno dall'avvocato con lo stesso atteggiamento con cui vanno dal carrozziere quando hanno abbattuto la macchina, con sommo dispiacere. Invece questo influisce perché alla fine il timore che i costi legali prolunghino il negoziato e che questo sia uno spreco di risorse, mentre in realtà un negoziato più prolungato e attento può massimizzare il valore economico dell'operazione. Questo è il momento, penso, cruciale. Bene, allora, di distribuzione, penso, avete domande sul tema negoziato?
Qualcosa abbiamo fatto sulla negoziazione, quindi credo che
Benissimo.
non proprio direttamente...
Sì. Questo è una discussione molto meno tecnica proprio perché focalizza su aspetti che sono extragiuridici, extra tecnici, ma che sono, ritengo, molto importanti. Se siete d'accordo possiamo passare alla seconda fase rapidamente, perché il tempo vola, ma la seconda fase tipica in cui il nostro cliente, impresa europea, impresa italiana, voglia stabilire una propria rete di vendita, una propria presenza negli Stati Uniti con una sussidiaria. E qui saprete benissimo le forme tipiche sono essenzialmente due, quella della corporation e quella della limited liability company, che vengono assimilate grosso modo a quello della società per azioni e la società a responsabilità limitata. Le differenze sono tante, quindi bisogna stare attenti a questo paragone, ma vi può dare un'idea. Diciamo che a livello corporate la corporation presenta degli organi tipici, è un'organizzazione, una governance tipica che è costituita da un board of directors. I directors che sono consiglieri, non sono amministratori, non hanno potere di rappresentanza esterna, lo hanno i cosiddetti officers, che possono essere anche ovviamente anche consiglieri, anche directors. Le forme di governance della limited liability company sono molto più libere. Spesso si cerca di replicare per comodità quelle di una corporation, ma altre no. Si può avere una limited liability company che è governata dal member o può anche essere un manager. Dal punto di vista fiscale, questo è l'elemento molto importante, la corporation presenta due livelli di tassazione, per cui paga in prima battuta, sarà responsabile la corporation per imposte sul reddito generato e il socio sui dividendi. Ovviamente, per quanto concerne un socio straniero, una corporation, c'è l'aspetto della ritenuta fiscale e da tenere presente, soprattutto con l'Italia, il trattato sulla doppia imposizione. Forse ne avrete avuto modo di sperimentarlo. La differenza con la limited liability company essenziale è che di base la limited liability company è un ente fiscalmente trasparente. Ora, bisogna stare attenti perché da un lato questo significa che, e dico attenzione perché molto spesso la controparte americana, vedendo un vantaggio in un unico livello di tassazione, cioè l'entità giuridica non viene tassata, viene tassato il membro, il socio, per la l'azienda italiana o l'individuo italiano che investe, che partecipa direttamente nella LLC può essere un problema, perché dal momento che quella LLC genera reddito, deve fare una dichiarazione dei redditi il socio italiano e quindi si espone con l'intero reddito mondiale a un potenziale scrutinio dell'IRS. Cosa succede in casi estremi? Succede che si ha un LLC che ha, diciamo, uffici importanti in una città americana, ha prodotto un certo reddito e l'IRS venga a dire: cara azienda italiana che partecipi nell'LLC, secondo noi una fetta più grande del vostro reddito mondiale è attribuibile ai vostri uffici di New York. Anzi, lo stesso Stato, la stessa città di New York, ma soprattutto lo Stato, sono particolarmente aggressivi in queste posizioni. Quindi attenzione a questo primo aspetto. L'altro aspetto è che di base gli utili, anche non distribuiti, sono tassabili. Quindi anche se non vengono distribuiti al socio nella LLC, sono tassabili. Ecco, veniamo al discorso invece del Delaware, perché ovviamente una volta scelta la forma giuridica, la struttura giuridica appropriata per l'operazione, si tratta di individuare lo stato in cui costituire la società.
Mi scusi?
Prego.
Mi scusi, potrebbe ripetere la differenza tra corporation e LLC?
Certo, a livello di responsabilità, limite alla responsabilità legale è virtualmente identica. Entrambi presentano il vantaggio della limitazione alla responsabilità giuridica. La corporation ha delle forme, diciamo, di governance standard. Sono gli organi standard, la limited liability molto più snella, molto più libera in quel senso. A livello fiscale, nella corporation ci sono due livelli di tassazione, quindi viene tassata prima la corporation sul reddito, poi gli eventuali utili vengono soggetti a tassazione del socio. Nella limited liability si salta il primo passaggio, cioè è tassato direttamente il socio che vi partecipa. È chiaro questo aspetto? Perfetto, grazie della domanda. Passiamo, dicevo, al discorso del dove, che stato scegliere. E vorrei subito mettere da parte questo mito del Delaware come paradiso fiscale, per cui uno stato in cui non si pagherebbero le tasse. Il motivo per cui non si pagano tasse nel Delaware è perché in Delaware non ci va quasi nessuno, vale a dire fisicamente operazioni nel Delaware non ne ha quasi nessuno. Ciò detto, più della metà delle corporations e delle società al mondo sono Delaware corporations. Ripeto, quella statistica, gli americani amano le statistiche. Più della metà delle società esistenti al mondo sono Delaware corporations. Non c'è nulla di strano. Vi assicuro che se voi aprite uffici nel Delaware, cominciate ad avere operazioni, produzione, vendite, quel che è, nel Delaware pagherete imposte federali e imposte statali allo Stato del Delaware. Ma normalmente accade qualcosa di diverso. Si sceglie il Delaware come stato di costituzione della società, della corporation dell'LLC. Perché? Perché presenta dei vantaggi, sono organizzatissimi, hanno un corpo di norme, diciamo di diritto societario molto avanzato, la Chancery Courts del Delaware sono particolarmente efficienti, insomma è il paradiso del diritto societario, se vogliamo, ma non fiscale. Mi dilungo un attimo sull'aspetto, è perché se io costituisco una Delaware LLC, una Limited Liability Company del Delaware, con un unico socio, e non ho attività negli Stati Uniti, io non sono tenuto, comunque non sono tenuto a presentare una dichiarazione agli Stati Uniti. Ed è per questo per cui il fisco italiano guarda con sospetto una situazione del genere. Ma non è il caso nostro, perché noi seguiamo dei clienti che hanno operazioni qua e quindi hanno delle effettive operazioni. Allora la scelta può essere, vi stavo facendo l'esempio, costituiamo una società nel Delaware, la quale ha uffici ad esempio a New York, oppure la quale ha uffici nel Texas, oppure in tutte e due. Pagherà a seconda di quanto reddito è attribuibile allo Stato di New York quanto in Texas, pagherà tasse statali in New York e in Texas, oltre ovviamente al corporate tax federale, che al momento attuale è un'aliquota fissa del 21% che ha voluto introdurre Trump. Molto verosimilmente l'amministrazione Biden metterà delle aliquote progressive l'imposta sul reddito corporate federale. Allora, la procedura di costituzione delle società negli Stati Uniti è estremamente semplice, voi lo sapete, estremamente snella e veloce soprattutto. Basti pensare che se mi date le istruzioni, abbiamo deciso la forma, abbiamo deciso in quale stato costituire la società, a me, dal cliente, mi basta una sola cosa per costituire la società. Mi sapete dire qual è? Abbiamo scelto la forma, abbiamo scelto lo stato.
Per il passaporto?
No.
Per il passaporto?
Neanche.
No, la firma?
Nulla. No.
Il nome.
Chi l'ha detto il nome?
Io.
Bravissimo, non riesco a vedere, ma bravissimo. Il nome della società, perché ne verifichiamo la disponibilità del nome, ed ecco che immediatamente nel giro di 24-48 ore, ma nel Delaware e New York addirittura si riesce a accelerare, si ha una società operante e capace di incorrere in obbligazioni giuridiche, con un atto costitutivo molto standard, molto semplice. È una procedura che si fa a distanza, cioè tutto si faceva anche prima del Covid, tutto per via elettronica. Successivamente verranno adottate tutte le delibere necessarie. Noterete che non interviene un notaio. Quindi è uno strumento, visto come uno strumento di business fondamentalmente molto snello, molto versatile, molto rapido. Ed è quello per cui spesso nel discutere di operazioni che possono avere un impatto fiscale o quant'altro, spesso questo è un altro elemento, come dire, di presupposizionalità, no? Che ha l'europeo. Oddio, un'altra società? No, complicato, no. Questo è importantissimo. Il fatto di costituire una società viene visto come un'operazione onerosa, un'operazione da ponderare, mentre spesso lo si fa in un battibaleno, con un dispendio molto contenuto. Tipicamente per stabilire una corporation inizialmente, una limited liability inizialmente, non stiamo parlando di operazioni successive, ma il costo iniziale può essere di $3.000 più o meno. La limited liability company richiede un elemento ulteriore della publication, un aspetto voluto dal legislatore, forse anacronistico, ma sono altri $1.000-1.500. Ma insomma, non è un passo enorme. Ecco. Vi vorrei parlare di invece un altro aspetto un pochettino che può essere sorprendente, ma che è diverso dagli ordinamenti di civil law e certamente dall'Italia. Negli Stati Uniti non esiste il registro delle imprese o una figura, un istituto analogo, per cui i poteri degli officers, i poteri dei rappresentanti legali non risultano pubblicamente, né tantomeno ovviamente sono punibili a terzi. Quindi, teoricamente, in base a questa teoria detta della apparent authority, io posso mandare un mio officer, io posso nominare il dottor De Napoli quale vice president della società della Spinelli LLC, gli dico: caro dottor De Napoli, vada da Donald Trump, oppure posso non dargli questi poteri. E De Napoli, preso da un raptus, va giù per Park Avenue, va da Donald Trump e gli compra la Trump Tower. In base alla teoria della Apparent Authority, il dottor De Napoli, che è andato certamente ultra vires, perché magari internamente questo non era un'operazione autorizzata né prevista, crea un'obbligazione vincolante per la società. E perché? Perché in teoria almeno si tutela l'affidamento da parte di Trump. quello che accadrà nella prassi è che per un'operazione del genere il legale di Donald Trump, con cui abbiamo avuto varie operazioni in passato, chiederà sicuramente una delibera di autorizzazione specifica all'operazione. Ma per ripetere, i poteri che noi possiamo conferire o non conferire internamente hanno valenza solo interna. Ci sarà una rivalsa per l'impiegato, il dipendente che dovesse andare a ultra vires, ma l'operazione che ha concluso vincola la società. Vorrei accennare a un aspetto legislativo nuovo, la Corporate Transparency Act, che andrà in vigore nell'inizio dell'anno prossimo, nel 2022. Voi sapete che fino a questo momento i soci e i proprietari ultimi di una società privata negli Stati Uniti non sono soggetti a pubblicità alcuna. La Corporate Transparency Act prevede invece che dal 2022 in poi le società di nuova costituzione dovranno notificare i beneficial owners, cioè i proprietari ultimi, al Dipartimento del Tesoro, all'IRS. Non sarà pubblico, ma sarà. Questo poi la legge prevede anche l'obbligo per le società già esistenti di informare l'IRS con delle tempistiche più lunghe. Ma insomma è uno sviluppo legislativo di cui va tenuto presente. Ecco, rete vendita retail, gli aspetti della rete retail, forse visti i tempi ci possiamo affrettare un pochettino, ma direi gli aspetti salienti è intanto ovviamente nella raccolta di dati di vendita e dati di mercato. Questo è il primo aspetto. Ci si può focalizzare forse su aspetti di struttura, su aspetti fiscali, ma gli aspetti ovviamente relativi ai dati del mercato locale sono essenziali. Importantissima l'incidenza dei rapporti con i proprietari immobiliari, perché per il peso che hanno, soprattutto in certe zone, soprattutto per certe industrie, il negoziato con i landlords americani può essere veramente molto molto difficile e impegnativo. Spesso quantomeno si contempla una struttura societaria per una rete diciamo pure di boutique o di negozi particolari, si prevede una holding e si prevedono delle LLCs, o delle società individuali per ciascun negozio, semplicemente per cercare quantomeno di limitare la responsabilità della holding, per responsabilità della operazione americana rispetto a quanto possa incorrere una location. Ovviamente nei riguardi del landlord questo ha poca valenza, perché per quanto riguarda il contratto, il landlord chiederà quasi sempre la garanzia della holding e molto più verosimilmente della casa madre. Ma parliamo soprattutto della esposizione a rischi da terzi, per esempio la classica sciura che inciampa e poi fa causa relativamente al negozio. Perlomeno se il negozio è in una LLC propria, le chance di limitare il danno sono più elevate. Detto, scusate i colloquialismi, ma è venerdì e a una certa ora succede anche di questo. Allora, dunque, direi che anche il rapporto col broker, cioè con l'agente immobiliare, è importante, non è una scelta casuale, è una scelta molto importante, quella di individuare un broker che abbia conoscenze specifiche del landlord e delle location di cui stiamo parlando, così come i legali. È veramente fondamentale e molto vantaggioso scegliere dei legali che abbiano già avuto dei trascorsi, che conoscono di già i legali e i precedenti di contratti del landlord stesso. Una parola di avvertenza riferita all'utilizzo dell'agente immobiliare. Anche qui, per il famoso timore dei costi legali di cui mi lamentavo prima, spesso e volentieri il cliente europeo, il cliente italiano, può pensare di mandare avanti il più possibile il broker e ridurre l'impegno, ridurre l'attività dell'avvocato. Perché? Per il semplice motivo che il broker è pagato su una commissione fissa E il legale no, il legale tipicamente, queste operazioni importanti ovviamente è pagato in base a una tariffa oraria. E quindi molto spesso il cliente dice no, facciamo discutere, facciamo parlare, facciamo negoziare il broker. Può essere vantaggioso però fino a un certo punto. E l'elemento fondamentale è questo, che il broker ha un solo cliente. E il broker inizia con la C. Io lo dico sempre, perché il broker vede soltanto la commissione. Non solo, ma siccome, come tipicamente anche i broker più di prestigio sanno benissimo che il loro successo, diciamo, economico dipende dal fare un certo numero di operazioni nell'anno, e quindi mettono fretta istituzionalmente, perché sanno è preferibile fare 12 operazioni in un anno che non 6. Quindi hanno sempre fretta e terrorizzano i nostri clienti sempre col pericolo: guarda, arriva un altro acquirente, arriva un altro tenant che ci può soffiare sempre, quasi sempre. Quindi attenzione, questo è vero anche, ovviamente, anche in Italia, anche in altri paesi, ma negli Stati Uniti è un aspetto, direi, cruciale. Nel retail, ovviamente, cosa che sapete benissimo, la gestione del consumatore americano, a questo bisogna prestare attenzione, non soltanto per le diversità, ma per il grado delle aspettative che può avere il consumatore, per la propensione al contenzioso che può avere il consumatore. Bisogna trattarlo veramente con i guanti, diciamo, di velluto, tipicamente. E purtroppo si arriva a situazioni paradossali molto spesso. Il paradosso di queste situazioni a cui faccio riferimento si riscontra sia, per esempio, nell'ipotesi di cause relative all'impiego, di doglianze relative all'impiego, sia per, diciamo, delle piccole doglianze del consumatore. Qual è questo paradosso? Il paradosso è questo, che in teoria sarebbe meglio ricevere una doglianza, una lettera con cui si chiede risarcimento di milioni di dollari, che non quella che chiede un risarcimento modesto. Perché se un cliente, come è accaduto a un cliente nostro, nel settore sempre lusso, la signora americana che acquista una borsa in pelle chiara, lascia la penna stilografica nell'astuccio della borsa interna, la penna stilografica si rompe, dopo vari lavaggi l'inchiostro non se ne va. Pretende la sostituzione della borsa integrale, come se fosse un difetto della borsa, mentre la reazione, diciamo, dell'azienda è sempre: ma come, questa è stupida, ha messo una penna rotta dentro la che c'entriamo noi. Qual è il paradosso? Che il valore della borsa, che pure varia migliaia di dollari, è molto inferiore che non la telefonata e gli scambi di letteracce tra legali, che costeranno molto di più. Quindi, paradossalmente, le doglianze piccole, che dal punto di vista morale sono le più offensive, perché spesso sono le più pretestuose, purtroppo sono quelle più difficili da gestire da quel punto di vista. Cioè, gli esempi si sprecano, ne ve ne darò degli altri tra breve. Comunque, gestione del consumatore con anche attenzione soprattutto ad elementi culturali. Casi recenti si riscontrano, per esempio, anche in operazioni di PR possono generare delle reazioni da parte del consumatore sui social media terrificanti, con un impatto anche di PR devastante. Ad esempio, un caso recente di un cliente che, pensando di fare una cosa giusta, voi sapete, c'è stato ovviamente il tema di Black Lives Matter, il problema ovviamente della violenza della polizia contro le persone di colore, e in una campagna pubblicitaria un cliente sui social media ha introdotto il concetto invece di All Lives Matter, senza sapere che questo ha un connotato politico molto pericoloso. E c'è stata una reazione, diciamo, devastante. Quindi attenzione a non presupporre poter fare le stesse cose. Gli esempi ovviamente non si limitano agli Stati Uniti, ne abbiamo altri anche con riferimento ad altri paesi, che sono casi ben noti, ma è la propensione alla doglianza, al contenzioso, alla lamentela, all'esprimere le proprie vedute, che è molto più pronunciata. Sapete che qui ci sono delle organizzazioni di tutela dei consumatori molto forti. L'e-commerce, 2 parole su questo, ovviamente dati nell'ultimo anno soprattutto assolutamente strabilianti, c'è stato un incremento del 44% delle vendite online negli Stati Uniti nell'anno scorso, 44%, quindi 860 miliardi di vendite online. È un trend che continuerà e continuerà anche in Italia, anche per semplicemente lo sviluppo di abitudini. La disciplina legale negli Stati Uniti è, diciamo, per certi aspetti paragonabile sotto l'aspetto della privacy al GDPR, ma ha altre particolarità. Soprattutto in California le conseguenze a livello di sanzioni possono essere pesanti. Ci sono altri esempi di legislazione di cui non vi posso parlare adesso, ma un aspetto anche qui paradossale, recente, che sta colpendo tutti i nostri clienti retail che hanno una presenza web. Quella, e forse l'avrete sentita nominare, quella dei non vedenti. Si tratta purtroppo di sono 5 o 6 studi legali che se ne approfittano, perché alla fine è soltanto l'avvocato che riceve il beneficio della transazione, ma fanno navigare un proprio cliente non vedente o comunque che ha una visibilità ridotta i siti web per individuare le difficoltà, le barriere architettoniche che incontra quel cliente. Qual è la teoria? L'Americans with Disabilities Act ovviamente è la legislazione sulle barriere architettoniche ed è in sostanza quella che prevede un obbligo di utilizzare reasonable accommodations da parte del gestore o del proprietario di un punto di vendita, di un retail store. Reasonable accommodations vuol dire anche a livello economico, per cui mettere la rampa anche temporanea può essere reasonable, ma invece, per esempio, i non vedenti che hanno cercato di fare causa ai ristoranti che non avevano i menu in braille, no, perché sarebbe un onere eccessivo. Il giudice ha detto no, il menu in braille è un onere eccessivo per tutti i ristoranti, quindi purtroppo fatti leggere il menu dal cameriere, ci dispiace. Nel caso web, questi legali hanno tradotto la difficoltà del non vedente di navigare il sito in una barriera fisica. Io, non vedendo i tuoi prodotti, non riuscendo neanche a capire dove sono i tuoi negozi, non riesco neanche ad acquistare. E sono stati sviluppati delle guidelines, delle linee guida che sono le Web Accessibility Content Guidelines, siamo alla versione 2.1, che non sono leggi, non hanno forza di leggi, ma sono delle linee guida che imporrebbero tutta una serie di modifiche e si fa una valutazione complessiva più o meno di quante di queste modifiche l'azienda sia riuscita ad apportare per valutare, diciamo, se l'ottemperanza. È veramente una materia molto, molto difficile da gestire perché non c'è assolutamente chiarezza, ma voi capite qual è il tema. I nostri clienti, soprattutto nel settore di lusso, ricevono queste cause mensilmente. Finiscono per transigere sempre per somme che vanno dai 5 ai 20 mila dollari, anche quando l'azienda ha già cominciato ad intraprendere o ha già intrapreso delle modifiche. Le modifiche spesso hanno un disvalore economico perché significa spesso, per esempio, imporre certi colori, imporre che non si possono utilizzare delle foto di testo, imporre che ci debba essere un minimo di contrasto. Sono tutte cose che rendono il sito meno esteticamente appetibile, meno commerciale. Quindi la valutazione che può fare il cliente è dire: guardi, avvocato, per adeguare il nostro sito spenderemmo 100.000 di consulente all'anno. Diciamo invece per transigere spenderemo 50. Forse ci conviene non far niente. Purtroppo questo è il tipo di valutazione molto realistica che si è costretti a fare. Diritto del lavoro, abbiamo pochissimo tempo, ma basti dire questo. Negli Stati Uniti non esiste uno statuto dei lavoratori e diciamo, la posizione base contrattuale per cui in partenza, se un impiegato, un dipendente, non ha il potere negoziale per negoziare una possibilità di recedere per giusta causa e una severance, un indennizzo, la posizione di partenza è che è un employment at will, vale a dire con la possibilità di recedere da parte di tutte e due le parti, dal datore di lavoro e dall'impiegato, ad nutum, per nessun motivo. Cioè non c'è bisogno di indicare motivi. Si dà tipicamente un preavviso molto breve. Detto questo, e quindi sembra molto più semplice, e lo è, in molti casi lo è, però per il motivo che vi ho detto prima, intanto ci sono le cosiddette mine vaganti, che possono essere veramente fonti di responsabilità molto elevate, anche a livello di class action, quello è il tema degli straordinari non pagati, il tema dell'inabilità, il tema soprattutto della discriminazione anche per razza, per età, per sesso, il tema del sexual harassment che è tristemente noto, ma diciamo corrisponde a delle esigenze a mio avviso molto importanti in realtà, perché è un tema che viene anche questo mal interpretato a mio avviso non solo dagli europei ma anche dagli americani. Questo perché non mi voglio dilungare sulla materia, ma guardate i punitive damages che sono stati comminati per delle casi estremi di sexual harassment che vanno da condotte fisiche a condotte non esattamente fisiche. Perché qual è quali sono gli elementi della fattispecie? Si va dai casi più gravi in cui un datore di lavoro, in cui una persona in posizione di autorità abbia subordinato la posizione di lavoro o la promozione a prestazioni sessuali, casi rari, quindi il do des, ma perfino condotte consensuali. C'è un caso famoso dell'esercito americano in cui la soldatessa e il sergente in Iraq erano una coppia consensuale, erano tranquillissime. A un certo punto, finito il turno della soldatessa, lei fa causa all'esercito per svariati milioni di dollari. Perché? Perché ha consentito questo rapporto e lei ha detto in giudizio, ha testimoniato che io inizialmente era consensuale il nostro rapporto, però a un certo punto io volevo lasciare il sergente, non volevo più stare con lui, ma avevo il timore che mi cambiasse, mi mettesse in testa al convoglio e quindi che rischiasse di più e ho continuato a essere la sua fidanzata, diciamo. Milioni di dollari. Il tema più importante per noi invece è il hostile environment, e cioè è un tema difficile perché culturalmente, diciamo, i nostri clienti, soprattutto italiani, francesi, ma anche altre nazionalità, pensano che le mere parole, le mere insinuazioni scherzose, che poi, ahimè, forse sempre meno, ma io penso che le nostre connazionali le tollerano di più, purtroppo, le sanno tollerare di più, ma le tollerano di più, non sempre ciò è appropriato. Chiudo questa valutazione personale, ma il pericolo è che vengano sottovalutate e tollerate dal datore di lavoro con delle conseguenze piuttosto pericolose. Qui di nuovo in tutta questa materia attenzione al paradosso di cui prima, per cui in ambito di impiego, del diritto di impiego, spesso accade che di fronte a un employment at will e si valuta, o anche non at will, ma si valuta che vi sia giusta causa anche per un licenziamento, motivi sono validissimi, si licenzia il dipendente e poi arriva, diciamo, il dipendente va si presenta dal cugino dell'amico che è avvocato, arriva la lettera in cui questo dipendente o si inventa di sana pianta o comunque ingigantisce delle condotte, e si capisce, si legge tra le righe che non avendo ricevuto una severance, non avendo ricevuto un trattamento di fine rapporto, in realtà sta cercando di ottenere qualche migliaio di dollari in più. E lì è un problema morale, perché il cliente dice: ma qui ci facciamo prendere in giro? Ci sono delle aziende americane che non hanno tolleranza, sono disposte, pur di mantenere ovviamente una linea molto netta e molto decisa, sono disposte a spendere in termini di costi legali cifre elevatissime pur di non farsi, diciamo, minacciare in questo senso. Ma di nuovo è quel paradosso per cui per una doglianza che si capisce sta cercando l'obiettivo di ottenere 10-20 mila dollari, anche 50 mila dollari, talvolta alzare il telefono e chiamare i litigators o gli employment lawyers forse spesso può non essere necessario o non essere opportuno. Io sono arrivato in fondo. Le conclusioni mie sono queste. Sapete bene che le opportunità per le nostre aziende nel mercato americano sono sempre state elevate e crescono. Il mercato americano, sapete, l'economia è in netta ripresa. Sono dati confortanti relativi all'impiego recente. La disoccupazione è scesa ora al 6,4% a febbraio, un dato importante. Gli ordini commerciali sono arrivati al livello più alto dal 2004, adesso nel febbraio 2021, quindi pensate un po'. Però penso per i vostri clienti, allora, il messaggio fondamentale è riconoscere la relativa importanza degli aspetti legali, non sottovalutare il legale, sappiate, non esitate a usare legale, a spendere di legale, diciamolo pure. E poi ci sono le due armi fondamentali. Io dico che proprio no, immaginatevi il US Marine che si vanta di aver bisogno solo di due cose per combattere, l'M16, che ora siamo al M19, e il K-bar, cioè il fucile e il pugnale. Gli basta questo. Quali sono queste armi? Il prevenire, il contratto, da un lato, e quindi dedicare più attenzione all'aspetto contrattuale, e l'assicurazione. Queste sono le due cose su cui assolutamente bisogna battere con molta insistenza. Io avrei finito con 8 minuti, ma il collega Jim Rosler sono sicuro è pronto per lanciarvi nell'esame dell'investimento, forse in direzione opposta, vi dirà, cioè dell'azienda americana che si affaccia al mercato italiano con delle operazioni italiane. Vi ringrazio molto dell'attenzione.
Grazie Giovanni per una esposizione brillante, molto tranquilla. La tranquillità deriva dalla profonda conoscenza di tutto quello che hai esposto. Io mi sono scritto diverse pagine di appunti e quindi siamo passati dall'esame degli aspetti di errori di impostazione, aspetti culturali, a parlare invece dei contratti e poi gli investimenti, investire sul contratto. Questo è un corso che parte proprio dalla ricerca di redigere un buon contratto, quindi è perfetto per noi. Gli aspetti processuali che il cliente italiano medio non conosce, dalla discovery al fatto di trovarsi una giuria in Texas, ai danni punitivi e alla prescrizione che non si interrompe con mera lettera, ma soltanto la causa, rapporti con il landlord, agenzia, distribuzione. Veramente ho aperto tantissimi argomenti in pochissimo tempo, con molta chiarezza, con molta franchezza, il franchising volontario. Anzi, altro, c'erano due domande che erano rimaste nella chat. Non so se abbiamo tempo, perché poi prima di Jim noi vorremmo prendere un caffè, ma c'era una domanda che di Alessandro Turco che chiedeva, questo un po', erano circa un'ora fa, se aprire una rete di distribuzione selettiva negli USA potrebbe essere rischioso, nel senso che potrebbe essere inquadrato come franchising. E poi Elisa Zimei che ha chiesto questa teoria della apparent authority se si guarda alla buona fede del terzo. Non so se sono
Allora,
poi il negoziato come gioca, ti lascio rispondere.
Partiamo dalla seconda, che è diciamo, la più semplice, nel senso che assolutamente sì a rilievo la buona fede, nel senso che se il terzo sa che il rappresentante dell'azienda sta andando ultra vires, ecco, si riesce a provare questo, non vincolerà l'azienda, sarà un negozio inefficace. La prima è, direi, molto difficile fare valutazioni di rischio relativo. Se la domanda è una distribuzione selettiva possa essere più rischioso per il rischio che venga inquadrato come un franchising. Diciamo, i rischi dell'inquadratura come franchising sono, innanzitutto è un rischio economico, nel senso che richiede un impegno e richiede delle risorse elevate, ottemperare dal punto di vista strettamente amministrativo agli adempimenti del franchising, innanzitutto. Direi che poi c'è quell'aspetto per cui voi vi dovete immaginare il franchisee è il gestore di McDonald's, è il gestore di 7-Eleven, no? Cioè come tutti i franchise anche in Europa. È la tutela che gli viene affidata, la tutela del contraente debole fondamentalmente. Però sì, ad ogni modo, siccome fra l'altro è un tema cruciale, l'esaminare ciascun contratto di distribuzione da quel punto di vista, cioè per essere certi che non venga inquadrato come franchising, è forse, direi, tra le prime elementi di una checklist, cioè i primi elementi da esaminare.
Perfetto. Allora io vedo altre domande nella chat, non so se ci sono mani, non vedo mani. Allora, Giovanni, grazie davvero perché è stata una carrellata.
Mi ha fatto molto piacere.
Con molta chiarezza, molta competenza, e a ogni 30 secondi c'era uno spunto utilissimo, quindi che poi è proprio quello di cui siamo alla ricerca, la chiarezza e i suggerimenti per i clienti. E quindi grazie davvero.
Grazie a voi.
Naturalmente facciamo un booking per la prossima volta, e sperando di poterti di nuovo avere a Firenze come ospite.
Con piacere, certamente.
Di questa scuola. Io suggerirei, prima di passare a Jim, almeno 10 minuti prendiamoceli per un caffè, perché è stato anche, voglio dire, seguire tutto questo, prendere appunti. Abbiamo bisogno di una mente più fresca, perché Jim poi parte in quarta, so già su cosa vuole parlare, quindi non sono argomenti semplici suoi. Quindi ci prendiamo 10 minuti di caffè e ci riaggiorniamo. Vedo che arrivano nella chat i complimenti, e quindi anziché gli applausi ti arrivano i ringraziamenti.
Grazie a voi, grazie dell'attenzione.
Grazie tante Giovanni, alla
grazie
prossima.
a voi, no, con molto piacere, mi ha fatto molto piacere. A presto.
We're all ready to go. As usual, I invite people back from their coffee stand or coffee, wherever they are, water. It's nice to be able to welcome the speakers by showing yourselves, and of course during the course of the presentation, if you feel more comfortable without showing on the video, but at the beginning it's a good idea if we can allow the guest speaker to visualize us. Great. Okay, Jim, thank you ever so much. It's a great pleasure really to have you here. Most importantly, because this is the UIA Italy school, So Jim for us is the president of the UIA Corporate Law and Mergers and Acquisitions Commission. So an official of the UIA, and of course a member, a partner of New York law firm. I think you've changed name actually. Is it?
No,
Sorry, I have to. It used to be Pepper Hamilton, but I've got you down now with a different name. It's Jonathan Pepper. Okay.
we merged in July, notwithstanding the pandemic, and we're now Troutman, Pepper, Hamilton.
Okay.
Sanders.
Wonderful. Apologies for that. Okay, Jim, the floor is yours. I see that Giovanni is still with us, so I guess as a participant, we're going to listen to your presentation now, and I don't know whether it's Emanuele who will put your slides, or whether you will operate the slides.
No, if he could do it, that would be great. Because
okay, well, so I'm sure that Emanuele will be able to do that. Okay, Jim, thank you, and we look forward to your presentation. Oh, here we are, the anatomy of a cross-border. Okay.
Thank you, Carlo, and appreciate it. So I hope you don't mind. I'm going to give this presentation in English, because if I gave it in Italian, it would be very short. It would end after buongiorno. If there's any place that you'd like me to stop, just send me a question. I'd be happy to answer it. You know, the first transaction I did between the United States and Italy was back in the early 1980s, and things were quite different then. I remember the transaction. We had tabled a purchase agreement of a typical American size. Even then, it was probably 50 pages. And the lawyer on the other side, I remember him very well, a very distinguished lawyer named Mario Ardito in Milano, gave me back an agreement that was 4 pages, and he said, "You don't understand, you're in Italy, and this is the way we're doing it here." Things have gotten a little closer together, but there's still, very much different approaches to the practice. We both end up in the same place. We acquire the company that is the target, whether that target is in Italy or in the United States. But very often through the process, the focus and the process can be different, and the perceptions can be very different. And it's important to really understand those distinctions. Next slide, please. So you may think it's unusual to start with, legal considerations in a cross-border mergers and acquisition agreement, where I start with, do we ask for arbitration or do we ask for litigation? But at the end of the day, the purchase agreement that is so negotiated through the transaction and sets out the rights of the parties, you have to be able to enforce it. And you have to be able to enforce it in a forum that respects the laws of both Italy and the United States, and is enforceable in each of those countries. And interestingly, in the case of arbitration, there are 163 UN members of the New York Convention and 167 signatories to the New York Convention that binds each of those member states to respect the arbitrable award given under the laws of any one of the reciprocal jurisdictions. And we use it in international transactions for several reasons. One, it creates a contractual foundation to make a neutral forum. It gives the parties the ability to agree to how the process will be conducted. It's not in a court of law, so it's confidential. The decision of the arbitrable panel, for better or for worse, is not appealable to a higher court, except in very limited circumstances set out in the New York Convention, and that generally applies to corruption, fraud on the arbitrable panel or by the arbitrable panel, that the parties don't get to make their case, or some other defect that shows bias on the part of the arbitration. And those all are very, by intentionally so, very difficult to overturn an arbitrable award. And they are enforceable, as I said, in 167 countries. And what's interesting about the choice of law in any agreement, and certainly in the context of a purchase agreement, is that the choice of law, and whether it's arbitration or litigation, is left to the very end. And it's usually left to 3 o'clock in the morning when the lawyers are trying to finalize the agreement. And, you know, interestingly enough, it's the most important provision of the agreement, because even if you are all happy about the success of the conclusion of the deal, if there is an issue, you need a place to enforce it. Now, the nice thing about arbitration is you can generally pick a neutral forum. Switzerland seems to be a common seat between Europe and the US. But I'll talk about it when we get to litigation, only for arbitration. And there are other arbitration friendly places like New York, London, Paris, or Singapore. There are others, but these are the ones that are most commonly used. Interestingly, litigation, while it's got the draconian benefit of getting people to settle without having to go to court and getting people to really focus on what's important to them, the forum that's chosen can have a very significant effect. I remember we were asked to help a Dutch company with litigation in Switzerland over a contract between a Swiss company and a Dutch company. And they wanted a New York lawyer to help our Swiss counsel with that. And, you know, we showed up with a US client who, like most US citizens, spoke no language other than English, in a Zurich court with a 5-judge panel speaking German, Swiss German, and our client really unable to understand the proceedings, and recognizing that the motivation of the Swiss court was to get us to settle with, you know, great incentives to do so. So, you know, when people think of picking a jurisdiction that's, quote, neutral, they have to understand really the consequence of it. And it's not something to try and really think through at 3 o'clock in the morning when you're trying to finalize an agreement. Next slide, please. That takes us really to what law is going to govern the contract. the interpretation of the agreement. And one of the complications in dealing with a U.S. party, the choice of law is not U.S. law. The choice of law is a state's law. And generally speaking, regardless of where the U.S. company is located, be it Kansas or California or Pennsylvania, New York or Delaware, New York or Delaware is the most common law chosen by the parties to govern the contract when it's going to be when U.S. law is going to be accepted. I don't recommend choosing a neutral country's law to govern an agreement simply because you can't agree whether it's going to be Italian law or New York law. I just strongly urge early on in the process when parties want to move it forward that they agree on either the country of, in this case, Italy or New York or Delaware as governing, and that will guide the entirety of the negotiations of the agreement. If arbitration is the way that disputes are resolved, you can really pick any law that you want, but if you're going to pick some third country's law or third, jurisdiction's law to govern, it's going to inform every provision of the agreement. And if the parties aren't familiar with every provision of the agreement and how the laws of that third country apply, you're going to have unintended consequences. You also get to choose the language that the parties are going to use in the arbitration. In my example of Switzerland, where the parties spoke English, or at least the U.S. party spoke English, and the judge and the lawyers advocating spoke, Schweizerdeutsch. It was very difficult for the parties, and yielded a very difficult proceeding. Next slide, please. Turning to the transaction structure that the parties are going to apply when they're going to acquire a private company. You can buy the assets of that private company. Probably more difficult when you're acquiring an Italian business than when you're acquiring a U.S. business for various corporate governance and tax reasons. But or you can buy the equity, the stocks, the quotas of the company. We have a concept of merger where you're actually fusing the target and the acquirer or subsidiary of the acquirer contractually. And obviously it needs to work in both the jurisdiction of the target and the jurisdiction of the acquirer. Some jurisdictions don't recognize a merger. More and more we're seeing what we call carve-outs. A large company would have a division that may not be incorporated separately within it that it wants to sell, and the party on the other side, often a private equity firm, will look to acquire those assets making up that division. That's really an operating company, and in that regard, you have to create a structure really out of from scratch, because while you have the operating business that makes the products, that has the sales department and has the revenue that comes in and the cost, often it doesn't have an accounting department, a legal department, a governance structure that's separate from its mother company. So that all needs to be put in place, and there's acquirers who are very good at that, and there's acquirers who are very bad at that. And in each of those cases, the selling company, especially if it's a large company, is often most concerned with the fact that the acquirer is able to continue the operation of the business, because, I'm reminded, we acquired a company, in this case in France, through a carve out, and it was a company that was not, very much in difficult financial straits. The company acquired it, and the company didn't succeed in fixing those operational issues. And within 6 months, the company was insolvent. And what happened was that the employees who didn't have a solvent parent who they could get their indemnities from basically went back to the seller and said, you sold this to an insolvent company incapable of fixing it. You owe us the indemnities. And frankly, they were successful in bringing that charge. And then sometimes when people are unsure of what direction the relationship will take, they'll form a joint venture which doesn't fuse the companies together, or a strategic alliance that lets those companies work together in pursuit of a common goal. And so long as the strategies of each of those companies are aligned, that joint venture continues. My experience in the 45 years I've been doing this is that joint ventures have, and strategic alliances have, a limited life. They should not be expected to continue forever, because the strategies and abilities and focus of each of those companies can diverge over time, such that the joint venture doesn't work for one or both of the parties. Next slide, please. When structuring a transaction, the parties need to consider several things. First of all, the type of company. Is the company publicly traded on this Borsa or the stock exchange? If so, which one? Or is it a private target? Is it a private target where you're dealing with some number of equity holders who you can actually reach out and touch and negotiate with? There, of course, are corporate law considerations. Do you need approval of those equity holders? And generally, if you're buying equity, of course you do, because they're the ones who need to sell you the equity, so they often have to sign the agreement. And the more equity holders there are, the more difficult that is. And that's why we employ the device of the merger, which, while it requires their approval, it can be done with less than a majority or less than all of the shareholders. You can accomplish the merger itself. Sometimes in transactions where the acquirer is going to issue equity in exchange for equity of the target, the acquirer's equity holders also require approval. And in the case of a merger where a shareholder who's in the minority doesn't agree with it and doesn't believe that the value being paid for the target is sufficient, can assert what's called appraisal rights and ask a court to value its interest, and if it's greater, is entitled to the difference. Now, when acquiring a company, there are some filings that are naturally done, and we'll talk a little bit more about this later. But there are antitrust filings that are required, and in the U.S., there is a committee on foreign investment in the U.S. that oftentimes should be consulted to approve or at least not deny a transaction involving something that would be covered, usually things involving national security, certain kinds of real estate, depending on where they're located, and other factors. And then, of course, for industry-specific approvals, there are agencies such as the Food and Drug Administration and the Federal Trade Commission that are required to be consulted. And in any transaction, there are, of course, tax considerations that come into play, and those need to be considered both on from the country of the target and the country of the acquirer. And that often involves the form of the consideration, whether it's a merger or a stock purchase, and whether it is for a stock for stock transaction or not. And those things need to be considered very early on in the transaction, because it will drive entirely the structure. And as in any contract negotiations, there are deal dynamics, the leverage of the parties, the need for the seller to sell, the need for the buyer to acquire, the financial strength of the parties will really drive the leverage of the parties to impose transactions that most favor them. On a target that has liabilities that are of concern to any acquirer, that will shift often the leverage to the acquirer. How it's financed, whether there are banks involved, whether the leverage is very high because it's a private equity fund that's doing the acquisition, will also drive very much the deal dynamics and how it gets structured. And then what kind of third-party consents are going to be required, be it customers, suppliers, agencies, and the like. Next slide, please. So a typical transaction begins with the parties getting together and one of the parties suggesting that they do consider some kind of alliance, be it an alliance that is, constitutional, which brings the two parties together as one, or whether it's some other transaction. But it begins with initial discussions, and those initial discussions are often done by a CEO calling another CEO, or an investment banker on behalf of one party contacting the investment banker on behalf of the other party. Before confidential information is exchanged and before access to company due diligence is permitted, a non-disclosure agreement is often negotiated. And those really run the gamut as far as how detailed they are and how involved they are. If the target is a public company, the public company may impose on the putative acquirer the obligation that if negotiations fail, that the acquirer will agree for a period of a year or two or some number of months not to seek to acquire the target in exchange for opening up its books and records to due diligence. There's often, certainly among competitors, there's often a need and a desire to say, if I open up my books and records to you, I don't want you to contact or take my customers or take my employees, and you agree to not do what's called a non-solicit, where we won't solicit your employees, we won't solicit your customers, unless of course we complete the transaction and acquire the company. After that NDA is negotiated, and it's certainly is a preview to the tenacity with which the parties will negotiate, the acquirer begins due diligence, and that's usually accomplished through a virtual data room, rather than people flying all over the world to look at documents. Those documents are posted on a data site that people who are given the permission can access and review the documents from their own office. If things seem to be progressing towards, a transaction, a party will table a letter of intent. That letter of intent will yield some negotiations to solidify a purchase agreement. Depending on who the buyer is, that will also run in parallel with the obtaining of a financing commitment, and then the signing of an agreement, the request for appropriate regulatory approvals, and the satisfaction of other conditions precedent, and then ultimately a closing of the transaction. So let's dig into that a little bit, and let's turn the page. So in a term sheet or letter of intent, the typical terms that you'd see is what, based on what they know at that time, a buyer is willing to pay for the company, and what kind of assumptions went into the arrival at that price. And usually that has to do with what kind of earnings before interest and taxes and depreciation and amortization. So if that's materially different than what was assumed, the price could change. What kind of adjustments that would be assumed in there, and those adjustments can go both ways. If it's a privately owned company with lots of family members that are employed by it who don't expect to be continued, those would be costs that would be added back. If they use expenses, use the company to pay their personal expenses, that will often be added back. And then other adjustments that you need to replace those people will be added back in. If there's an indemnity package, will there be an escrow? What the deal timeline will be, and how that will be conducted. To the extent that there's any conditions precedent to proceeding to a transaction, those would be revealed. The expectation of indemnification, how long it will survive, what kind of limits or caps will be placed on particular liabilities, and whether there is a threshold below which there's no indemnification. Of course, there'll be confidentiality. There'll often be a request that the seller and its representatives only deal with this particular buyer, for the period of time when it's exclusive. What happens if the deal doesn't proceed with the expenses that are incurred by the parties for due diligence and for negotiations? And generally speaking, at this phase, absent circumstances that are different, the each of the parties bears their own expenses. And then, of course, as I mentioned earlier, choice of law to deal with the letter of intent and whether disputes would be litigated or arbitrated. Now, it's interesting, generally a letter of intent that's based on European law or laws of a member state of the European Union is going to require good faith and fair dealing in negotiating the agreement. That is not necessarily a requirement under Delaware law. And so the expectations in negotiating an agreement, meaning a party can terminate discussions abruptly and move on to something else, subject to the exclusivity provision, is much more likely to occur on a US governed document or Delaware governed document than it would be in a European law governed document, where a brutal termination of the agreement is generally reviewed or potentially reviewed by a court or by an arbitrator. And then in the letter of intent, we generally bind, the only binding provisions is the exclusivity, the confidentiality, how governing law is going to be, and of course expenses. And then, but as to the obligation of the parties to complete a transaction, that's rarely binding at this point in time. Next slide, please. The most, I guess, intense part of the process to acquire a company really begins with the legal due diligence and the other due diligence that's conducted by the other professionals. And frankly, it is extensive. Parties typically are concerned about it because it really does require full candor by the seller, opening up its books, records for the good, the bad, and the ugly. Oftentimes, the parties have talked about how great their company is and how wonderful its prospects are. And when the due diligence begins, you know, some of the things that really were left out of those discussions can turn up. And things as simple as on corporate diligence, you know, does the company exist? And oftentimes, especially on older companies, the record is not necessarily clear, and that needs to be remedied through the process. The capitalization, who owns the company? You know, is this a situation where family has owned the company for, you know, decades, and it's you know, nobody's really sure whether cousins or uncles or aunts have an interest in the company that's been willed by, you know, the estate of the owner, or employees claim that they were promised rights to equity if it's ever sold. And that really does require extensive due diligence, because if you're going to acquire the equity of the company, you want to make sure you acquire 100% of it. And then, of course, you know, what kind of authorizations are are necessary. We often conduct regulatory analysis, especially in certain industries, most notably in the life sciences world, where there's clinical trial and phases. Often the value of the target greatly exceeds its current business, and sometimes companies that are bought for literally billions of dollars don't have $1 worth of revenue, and the value is based entirely upon the prospect of the compound that is currently developing as a life sciences company. And so, you know, the legal and technical experts need to evaluate those clinical trials on each of those phases. And then there's government approvals. What kind of notifications are required? What kind of consents are necessary? The Foreign Corrupt Practices Act is a act in the U.S. that most people have heard of, and to the extent that you haven't, where some instrumentality of the U.S. has been or is used in connection with paying a government official for the exercise of discretion, generally, that would involve the FCPA, and the reach of the U.S. Law is really global when there's a instrumentality of the U.S. That doesn't mean anything is subject to the FCPA, and you know, you really do need the professional experts to evaluate them. So, for example, if a Italian company has paid a Libyan company some amount of money for orders between those two companies, and money went from Italy directly to Libya, didn't involve meetings in the U.S., phone calls using the U.S. banks from the U.S. That's between the Italian company and its own laws, which frankly now I don't think are a whole lot different. In the case of the UK, probably more strict than the FCPA. So just because it might not be applicable to the FCPA doesn't mean there's not another state's law that would apply. The need the business arrangements, you need to look at customer contracts and suppliers contracts to make sure that you have good customer and supplier agreements that will continue post closing. And some people say, well, why is that necessarily important? The customer likes the product, why wouldn't they buy that company? Well, sometimes if you're a competitor of one of those suppliers, if you're a competitor of one of those customers, or if the pricing of those arrangements are out of whack with market, the parties can often require those contracts to be adjusted as a condition to the approval of the change of control. Certainly when you're acquiring a company across border, you know, unlike the US, before you arrange for the acquisition of the company, you need to consult with the Works Council of both the target and if the acquirer is a European-based company, the acquirer's works council to make sure that adequate provision for the employees is given, and the acquisition doesn't change the character of the company such that it would likely cause it to change the terms and conditions of the labor. In some industries, intellectual property is critical, and the existence of litigation to enforce intellectual property rights is significant, and especially in whether it's electronics, computers, chips, life sciences, biotechnology. The number of lawsuits that associate the exploitation of those products is tremendous, and sometimes, depending on who the acquirer is, it may or may not generate a lawsuit by another party who believes that the acquirer is more able to pay a settlement than the company that's been acquired. Data privacy, information technology, certainly across border with the US and Europe. We have different regimes. You have the data privacy directive, the general, GDPR. We in the US do it by state. California has basically adopted something much more similar to the GDPR than the rest of the country. So that needs to be reviewed. And then if it's an industrial company, an environmental review needs to be conducted, both legally and structurally. Next slide, please. The key issue in agreement are, how is the price determined ultimately? Are there going to be any earnouts? And what is the obligation and the liability of the seller with respect to any breach of the representations and warranties or covenants in the agreement? So let's look at some of these. Purchase price, once you've established value, you've established that value based on a couple of assumptions. That cash level will be sufficient to run the company, but you run the company on a operating basis, that the indebtedness is of a given amount, that the working capital available, accounts receivable, inventory, accounts payable is of a certain amount, that the transaction expenses that will exist following closing for the professionals of the seller, how will they affect price? And are there payments that arise as a result of a change in control? And those are typically things like the indemnity or severance that's paid to employees if they're terminated following a change in control. And that's oftentimes, the executives of the company, the CEO who's terminated, or the chief financial officer. And then sometimes there's bonuses that are paid to some of the employees who for the successful completion of the deal. And to the extent that they vary from what has been assumed in the determination of the price, there are adjustments that go upwards and downwards based on that. Now, usually the way that works is the seller tells the buyer at closing or a couple days before closing, each of those amounts are as follows, and the price that's paid at closing is determined in that manner. The seller pays that amount, and then typically following closing has a number of days to confirm whether that's accurate or not. And it's often not accurate because it's the sellers is really only estimating what the receivables are or what the accounts payable are or the amount of cash that will be left at the actual closing. So to the extent that there are changes, the parties often agree to it because it makes sense and the buyer has made it a good case. And sometimes there's not. I remember not too long ago, we had a transaction that the parties paid $175 million for the company. And the buyer asserted that the working capital was incorrect by $125 million. So an enormous purchase price dispute. The basis for their argument was that the inventory was obsolete, and that inventory amounted to about $50 million, and the entirety of that inventory was obsolete, and it was obsolete for a very legitimate reason. It wasn't. It was obsolete because this company made products that were used in the telecommunications industry, and a lot of that inventory was in the second generation of telecommunications, as opposed to the third generation. Much like if you went from third generation to fourth generation, and there were some other things on inventory and other amounts. And we went before the arbitrator. We selected the arbitrator. Sorry, can you advance these slides? No, the other way. Okay. So we appointed an independent accountant. The accountant was neither the seller nor buyers. It was a third party. The agreement, much like an arbitration agreement, circumscribed the scope of the independent accountant's review. It allocated the expenses of the independent accountant. And the biggest question that arises in that, especially when they involve cross-border, is that accountant acting as an arbitrator, or is that accountant acting as an expert? And it's a critical distinction, because if it's acting as an arbitrator, the decision of that accountant is final and binding in the absence of those, 4 things that under the New York Convention would give a party the right to challenge an arbitration. And as I said before, those are very limited and rarely applied. If it's an expert determination, it means it's only contractual, and the one party or the other, or both for that matter, can argue that the expert exceeded its authority or didn't properly apply the agreement. So it is appealable to a court. It is appealable from the court to a higher court, and it's appealable from a higher court to a superior court. So the parties can often get into very serious arguments over whether it's an arbitration or an expert determination. And my strong recommendation is to make it a arbitration, so it is final and binding. And even though you're going to be stuck with its determination, and it's not always in your favor, at least it's final. And from the standpoint of a post-closing dispute, the parties can move on, especially if you're the seller, and basically live with the result. The next area of dispute, if you will, is in the area of earnouts. And again, I've been at this for 45 years. The earnouts, I can't remember an earnout in an agreement that was done for which there wasn't a dispute. And why is that? Well, the earnouts really are the method by which the parties bridge a gap in value. So if one party thinks the company is worth 100 million and the other party thinks the company is worth, call it 75 million, because it's unsure whether the revenue that's predicted in the future will occur or whether the new product will be launched and be successful, these earnouts can bridge that gap. And those financial metrics that are used are often described, or milestones, whether or not there's FDA approval and therefore commercialization, successful commercialization of the product, or that keep personnel continue for a period of time. Well, what kind of disputes can arise on that? That seems pretty empirical. And are those disputes going to be litigated or arbitrated? And again, that depends on what the provisions of the agreement. And how are those disputes going to be resolved under the agreement? Are you going to appoint a third party, like in the purchase price disputes, to resolve that? So the most common of earnout disputes really relate to a change in the business. The acquirer acquires the business. It wants to run the business as if it's its own, because it is its own. It wants to be sure that it can make other arrangements. It can do other acquisitions. It can do divestitures of some or all of that business, all of which can affect the ability to attain that earnout. For example, if there's 3 businesses in the company that are acquired, and the earnout is based on the earnings of the combined company, and the buyer decides it wants to sell one of the 3, that obviously impacts the company. If it wants to change directions, if it wants to acquire a third party, if it wants to integrate some of the business of the target into its own and exclude it from the ability of that business to earn that income, all of those affect the earnout. And there is a lot of negotiations in the purchase agreement over what the buyer can do with the business following closing that would affect the earnout. So there are several best practices that we generally do. And again, I am not a big fan of earnouts because, as I said, I don't remember a single one that didn't have a dispute. And so those things are structured on either a graduated or a cliff basis. And what's a cliff basis? Means you either earned it or you didn't. Well, that all or nothing approach really gives the buyer strong incentives to, quote, miss the target. Whereas in the graduated earnout, that earnout is earned out from a lower attainable level to the expected level when it would be 100% paid. And so while you might miss 100% of the earnout, at least the seller will get part of it. You need to make sure that you negotiate what happens if the buyer integrates the business into its own. How long does the earnout last? Aligning incentives so the buyer is as incented as the seller for you to earn the earnout. What happens if the company is sold or the division that was acquired is sold, or there's a material breach? Does it get accelerated? And certainly, does the buyer need to exercise a high degree of effort to permit the achievement of that earnout? Next slide, please. Indemnification, we talked about that, and that typically is only the case in private companies as opposed to public companies. While it's not unheard of in public companies, it's much more complicated when you have a diffuse group of sellers because of the technical requirements of escrows and the ability to explain to the public when they would get that additional money out of escrow, assuming that there's been no indemnification disputes. But indemnification does provide a buyer a basis to recover to the extent that there's a breach of a representation in the agreement, that there's some defect that causes liability, and it's a way to allocate risk. For the most part, it is the sole and exclusive remedy for monetary damages, subject to several exceptions. One, to the extent that a party doesn't perform its obligations, at least under Delaware, New York law, a party can obtain an order of a court or an arbitrator in the case of an arbitrated dispute that requires the non-performing party to perform its obligations, including closing of the transaction. If there's been fraud, that is usually excluded from the limitation of liability, and the aggrieved party can go after the other party for damages that are not limited. The purchase price adjustment is not part of the limitations on indemnification. And that is actually more important than it seems, because some parties try and put into the purchase price dispute that's not limited by a cap, disputes that would normally constitute a breach of a representation in warranty. Taxes are often part of the indemnification package, and So if a tax were to arise, and not just income tax, but any tax relating to a period that ended with the closing date, and this could be sales tax, this could be use tax, property tax, but often income tax that arises, that would be subject to indemnities. And then if there are specific items that the parties identify in the course of due diligence, that can be agreed to in a specific indemnity. Now, the quality of the indemnity is only as good as the source of recovery of that indemnity. So if you're buying a company from, a large international company that is, a AAA in debt, you can rely on the fact that you can recover from that entity. Or you can put the amount at risk from the seller in an escrow or a holdback that doesn't get paid until the time periods for the indemnification have lapsed. Much, much more common today than it was even 5 years ago is the existence of representation and warranty insurance, or what's more commonly referred to in Europe as warranty and indemnity insurance, where the liability of the seller is passed to an insurance company. And then to the extent that there are contingent payments, like an earnout, the ability to set off the obligation to pay those earnouts with the obligation of the seller to indemnify can be offset. Next slide, please. The scope of the indemnification usually covers breaches of the representations and warranties, breach of the covenants. For example, if the seller agreed not to compete or to deliver certain documents or undertake certain post-closing obligations, those would be subject to indemnification. I think, as I mentioned before, that sometimes specific items will be indemnified that are identified in the course of due diligence that aren't adequately addressed by the representations and warranties, or because they're known, wouldn't be covered by warranty and indemnity insurance. There can be specific carve-outs for them. And then pre-closing taxes. And then all of that survives for periods that are negotiated. General indemnities generally today survive for a year or 18 months. Indemnities for breach of what's called a fundamental rep, the existence, the authorization, the capitalization will survive for a longer period, 3 to 6 years typically. Survival for taxes, pre-closing taxes, is generally for the statute of limitations plus a short period after. And then to the extent that there are line items for particularly negotiated periods. What kind of damages, next slide, please. What kind of damages are generally recoverable under indemnifications? And this is important, especially where there's warranty and indemnity insurance, because let me step back for a second. Under European style agreement, which really often has its provenance out of the UK form, damages are generally measured in loss of value or essentially contract damages that says, I bought a company for $100 million. Because of the breach, the company is worth only 90. And sometimes that is offset by the good stuff. You know, there could be, you know, you could have not only gotten things that diminish value, you could have also gotten things that improve value. So the ability to prove that there's a loss depends on what is the effect of that claim breach on the overall value of the company. That's different in the US style agreement. In the US style agreement, if you tell me that there are no liabilities other than those on the balance sheet, and a liability turns up, and in my example, that $100 million company and a liability comes up, and even if the company's still worth $100 million or even more, that you're entitled to be indemnified for that liability that was said not to exist but existed. Or another example, if you said that the accounts receivable are collectible and the accounts receivable were $30 million and one of the clients didn't pay, that was included in that $30 million. Well, it's subject to indemnification. So those damages are direct damages. There was a rep, they were breached, and I'm entitled to be paid for that. And under the European form, you may or may not be, depending on what's its effect on the overall value of the company. Similarly, there's things called indirect damages. What's the consequence of that breach? For example, the party who didn't pay its accounts receivable, the direct damages is the value of that account receivable. But if that had been a long-time customer that's now no longer able to buy from you because it can't afford to pay, or it went bankrupt, or it disappeared, got acquired, or started buying from another party, that's a consequence of that breach. And that may or may not be, depending on the agreement, recoverable. Diminution of value, what's the effect on the overall value of the company? More like the European form. Lost profits as a result. Sometimes if a buyer said, I'm paying 9 times earnings for the company, and the earnings are decreased by $1 million, well, the effect on value is 9 times that, and that would be, to the extent that that was covered by the indemnity, would be part of the ability to recover. There's a concept, especially in agreements where the seller continues to be liable as opposed to the insurance carrier who takes its place, is the anti-sandbagging provision. Anti-sandbagging is really, what does it mean if the buyer knew or should have known that a representation was false, a representation wasn't accurate, but closed nevertheless? Under the typical Delaware form, if I tell you these, these are the representations and warranties, and I'm buying it on that basis, even if I knew or should have known that they're not true, I'm entitled to recover if the anti-sandbagging provision in the agreement or the effective knowledge on the agreement basically said it didn't matter what I knew, It only matters what you tell me as the seller. And again, you know, do you have the right to offset against an earnout or netting other recoveries or benefits? Do you have that obligation? Indemnification does have its limits because it's negotiated. There are what they call baskets, which meaning until the indemnity gets above a certain amount, there's no basis for the claim, and that avoids disputes over de minimis amounts. Those baskets are typically, call it about 1% of the purchase price, sometimes 0.5%. They're 1% when they so-called tip, meaning once you get over that amount, you're allowed to claim back to zero. When they don't tip, they act more like a deductible, and they're typically 0.5%. And so the first 0.5% of purchase price, you don't get to recover. And the amounts only above that, you're able. So it depends on whether the basket is tipping or not tipping. Sometimes in addition to a basket, there are mini baskets, meaning any claim, even to be considered whether it gets put into the basket, has to exceed a certain amount. And then there are caps. So typically today it's between 7 and 15% of the purchase price is the cap that a seller would be liable for, other than fundamental reps. And sometimes there are exclusions from those caps, like taxes, like covenants. Couple of comments. Let me stop before I get into this and just see whether there are any questions, Carlo, from the group.
Okay, I don't see any questions at the moment. I don't know whether there are any questions, but all this is extremely interesting. I'm taking a lot of notes because depending on what is the governing law, the buyer is entitled or not entitled, or entitled in a different way, to indemnifications. And I myself didn't realize there are all these differences and baskets and so on, and offset against netting. So this is very complex. I hope the lack of questions is not due to misunderstanding, but also because you're going through this very slowly and very clearly. So it's wonderfully clear, although it's very complicated. But I still don't see questions.
Yeah, and it's complicated because, you know, every agreement is a bit different. The parties all have different negotiating strengths, different understandings. Culturally, they come at it in different ways with different understandings. And all of those differences are really the source of what, if there is a dispute, of that dispute, because sometimes a party thinks, if I'm selling it for this ridiculously low amount, why should I have any liability post-closing? And of course, the buyer's thinking, I'm paying a king's ransom for this company that's in horrible shape, and I need to have all the remedies that I can. And you take that perspective plus the perspective of the European seller who thinks the basis for damages is diminution of value to the company. taken into account all the positive offsets, whereas the US buyer is thinking, I'm entitled to indemnification for a particular loss, irrespective of the benefits that I didn't bargain for that I got.
Yeah, I'd like to go back on your comment when you're looking at direct damages, because one would think, what difference could there be as regards direct damages between the US and the UK? But effectively, there is, if I've noted correctly, that the UK, you would look at the effects on the overall value of the company, whilst in the US you would not. But we're still talking about direct, not indirect. I thought the difference was in indirect, but I'm now learning that it's also a difference between Europe and the US in direct damages, if I've got my notes right.
Yes, you're correct. Yes.
Okay, so it's good that I pointed that back again. And thank you for going through the anti-sandbagging, because that's a very, very unusual clause if you're not into mergers and acquisitions.
Yeah.
It's good that you brought that up. This is the great learning.
And just to talk a little bit what we've done and what's developed, especially under agreements that are governed by Delaware law, again, not to overcomplicate this, is that you make the buyer say that I'm only relying on the representations and warranties that are in the agreement. And I'm not relying on, management presentations that predated that, forecasts that you've given us, or projections that you've given us, or things that are in the data room that, I could have seen. The only thing I'm relying on is are the representations and warranties in the agreement. That's very different again than the UK form, which is really the one that's most used across Europe, where in addition to the representations and warranties, everything that's in the data room is presumed known by the buyer and mitigates any damages. So even if the representations and warranties didn't cover something that could have been found in the data room, which is often, can be tens of thousands of documents, under the European form, the buyer is presumed to have relied on that document, whereas under the US version, typically a Delaware governed document, it doesn't matter if it's in bright lights and clear in the data room. If it's not in the representations and warranties, I'm allowed not to rely on it. And the only thing that I'm relying on is are those representations and warranties. And if I tell if the buyer says, that's all I'm relying on, and I didn't rely on anything else, it generally forecloses a claim of fraud after the transaction, that the things, there were other events, other externalities that existed, and was entitled to rely on them because you said that you didn't. And that's really a developing area of the law because of the limitations of liability and the caps and all the other restrictions. When buyers were started to make fraud claims because something was in the data room, because there were projections given, because, for a lot of other reasons, that sellers are now requiring buyers to say the only thing that they've relied on is what's in the reps and warranties. And at least under jurisprudence in Delaware, that has to be a statement from the buyer and not a statement from the seller.
So that might explain why UK solicitors assisting the seller throw a huge amount of documents in the data room, because by doing that, they're covering themselves, I guess, in the sense of what's there is presumed to be known. Is that the interpretation? That's UK interpretation.
Correct. So under the UK doctrine of fair disclosure, if it's in the data room, you're deemed to know it. In the US, it doesn't matter if it's in the data room, if it's not part of the representations, it's not part of the liability package.
Well, thank you. This is a great learning moment. Thank you very much for this.
Great. So turning to the next slide on kind of US issues that come into play on cross-border transactions. I mentioned earlier the Committee on Foreign Investment in the US and FIRMIA and Export Control Act are all critical things that need to be analyzed when contemplating the acquisition of a US company. And especially in the last administration, that was widely applied in a number of areas. And what is CFIUS? CFIUS is a interagency committee for responsible for vetting foreign direct investment into the U.S. So if a company, European, Asian, Chinese, whatever was to acquire a U.S. company, in most areas, it's a voluntary submission of a transaction to the CFIUS. And in some areas, it's a mandatory submission to get approval for that foreign investment. And frankly, Europe has met that requirement with its own. But where the transactions really involve technology, infrastructure, it is highly important that a CFIUS filing be made, and often cases required, and really to protect not only national security, but also the source of technology and infrastructure that people really do are concerned more and more that not only in the US, but also in Europe and in China and elsewhere, that the homegrown technology is kept in the US or in Europe, so that we retain kind of the national security associated with that, especially in the area of telecommunications. Similarly, the Export Control Act established an interagency process for identifying and controlling emergent and foundational technologies, so that artificial intelligence, development of the fifth generation telecommunications, all the foundational technologies to life sciences are rigorously controlled. And if a company were to come in and acquire it, the belief is that would affect national security, and the CFIUS could deny it both before or after the transaction. And interestingly, in the case of CFIUS, that doesn't apply only to US-based transactions. There have been transactions between a Chinese buyer and a German seller where a significant portion of the German seller's technology was imported into the US, and the CFIUS required a divestiture by the Chinese company of the German company, or the portion of the German company that supplied technology to the US. Likewise, a acquisition of a piece of real estate, which doesn't seem to have anything to do with national security, that was near a military base or a missile defense base, was required to be divested by the CFIUS because of national security concerns. The Bureau of Industry and Security, which is part of the Department of Commerce, has proposed advanced rulemaking, seeking guidance and identifying those emerging technologies, and they're developing further controls. So not only do you have the interagency CFIUS, but now you have the Bureau of Industry and Security, which really is charged with identifying those emerging technologies. And as I said before, the US isn't the only jurisdiction that controls it, and Europe's adopted the same, so has China, almost in a retaliatory basis. And I mentioned earlier that the FCPA has been a widely and broadly applied both extraterritorially, to U.S. citizens and companies to prohibit bribery of foreign government officials. And while the FCPA prohibits the payment of anything of value to a foreign official, so paying a customs agent or a foreign agency official money for the exercise of discretion, it doesn't prohibit a gratuity to a customs official who doesn't exercise discretion, who simply is an inspector who doesn't have discretion to approve or not to approve that if it otherwise complies. But what it doesn't apply to is the bribery of a non-governmental official. That's governed by other laws and certainly not permissible, but it is not covered by the FCPA. So bribing a purchasing agent to acquire your product is not governed by the FCPA. It is governed, however, by the British Anti-Bribery Act and some of the related acts that have been adopted in other jurisdictions. The FCPA, again, concerns potential liability for illicit conduct of its employees, foreign sales representative, foreign distributors, foreign subsidiaries. It governs the appropriateness of gifts and business entertainment and donations to government entity or use of a government entity as a foreign sales agent. And some of these things are very general, but a tangible example is a large bank in the US with significant activities that it desired to pursue in China, hired the sons and daughters of government officials to be interns or employees of that foreign company. Well, or that US company, either in China or in New York. Well, that was viewed as a inappropriate gratuity paid to or on behalf of a government official, and they were fined for that. Or using a intermediary to to facilitate a sale, and that's often in the Middle East. We find you hire an agent who's a prince or sultan or whatever for, and that official gets paid a unreasonable amount for the services that are rendered, and people can't hide behind that to say that no bribery was made, because presumably the so-called sultan or prince used some of that portion to pay a gratuity to a foreign official to approve a transaction. It comes into play in a couple of respects. One, to the extent that that payment isn't accounted for on the books and records of the company, can expose the company to an FCPA violation. So if you don't include it in your books and records as a bribe of the Saudi official as an expense, you're liable to a violation of the books and records provisions of the FCPA. And you're also liable for the bribery proportions of the FCPA, and it has large reach. Again, if the meeting occurs in the U.S., if the meeting uses a U.S. bank, or the bribery uses a U.S. bank to transfer the money, or there's telephone calls that occur in or out of the U.S. And an example of that is a foreign executive was on vacation in Miami. He organized a bribe of a foreign official from his vacation home, went back to his home country, came back to his vacation house, and was subsequently arrested for using the U.S. Telecommunications to effect that bribe that probably went through a U.S. bank. But on the other hand, just because the guy, was in France working with his colleagues to each bribe an Indonesian official into buying, U.S. made turbines, just because he was part of that didn't necessarily expose him to individual liability for violation of the FCPA. So it's not all encompassing, but it certainly is far reaching.
Yes, I think if I may jump into this, it's we must underline this issue of the extraterritoriality. I don't think that's perceived abroad. So the examples you've just made of transferring money through a US bank or phone calls from the US, and I see here in the slide you're mentioning foreign sales representatives or foreign distributor. The foreign distributor is a non-American corporate entity or individual, or maybe he's not an individual. So the far-reaching application of the SCPA is not really understood. So it's very good that you've underlined the extraterritoriality.
Yeah. And the most common example is the use of agents. So because the company doesn't want to be involved in the payment of a bribe. The company doesn't want to associate itself with kind of that, but pays an agent an unreasonably large, quote, commission. And that money comes from the US to the agent in a perfectly legitimate contract, but the agent uses a portion of his commission to pay a government official. That will expose the paying company liability for the FCPA, even though it occurred wholly outside the US, because it really didn't, because it was obvious that paying somebody a 20% commission on a product where the market would normally pay 7 or 10%, yields something that should have been evident, that and it's really something that requires extensive amount of due diligence. So, I mean, I think it's important for the audience to really to understand that, so much of commerce comes out of the US, and so many buyers and sellers of companies come from the US, that understanding the reach and really the cultural differences and the legal differences when dealing with the US. And I heard at the end of Giovanni's discussion, really the extent of the laws of the US has always made buying and selling a company in the US somewhat fearful, or really even doing business in the US has caused some fear. It really causes unnecessary concern, I think, in a lot of respect, because one, it's insurable, two, good diligence and good understanding and respect for the fact that the US is the largest market for many of the products that people want to sell, and the benefits of doing business in the US outweigh the risks if they're properly understood. I think should give a European buyer really comfort when coming to the US, and with the proper advice and the proper team can really manage those risks, so long as they're respected.
Thank you, Jim. This has been a wonderful presentation. I think we've incredibly benefited from your great experience, and you've gone into so much detail. Thank you also for the slides, the key terms of the LOI and key issues in a purchase agreement, going into much detail as concerns, for example, even earnouts. There's a very important aspects to be known if you're assisting a client who is maybe on this side of the Atlantic, selling to its assets or its business to a US acquirer. So I know it depends on the governing law, but there again, we need to know more about what exactly we're in for. So I think all these slides are extremely useful, and the way you've presented them with such a calm and swift manner, the best practices, the direct damages, the indemnifications. And yet, once again, I'd like to stress the importance of understanding what the FCPA is about and how it applies in an extraterritorial manner outside of the US. It's very important to be aware of all those. So I think we've covered with yourself and with Giovanni, we've covered so many aspects which are important. Is exactly what I was hoping and I'd asked you to do. And I must say, you have completed a wonderful 4 hours presentation between the two of you, because all the aspects we had listed as possible aspects focus have come out. So clearly we'll need to go back, every one of us, and go back and read and go more in depth on each of the slides of the two presentations. But this is very, very precious material for all of us. So what can I say? I'm most grateful on behalf of everyone here. I think this has been a wonderful afternoon, and I hope we'll have more time in the future, because definitely we need to spend more time on these issues. Every time we have a presentation, we understand we haven't done enough. But that is what pushes us forward. You know, we always need to be eager to learn more and more. There's never enough learning, and this is the UIA, continued legal education, or this is actually a specialization course. With today, we have reached the last of 14 modules of 12 hours each, totaling some 170, 180 hours, plus the people today, the participants have been attending UIA Paris seminars and webinars to complete the 200 hours. So I think this has been a great effort on your behalf. Thank you. And I think it's good to flag the UIA, because this is a rather unique course. It's the first international business law and international business contracts held in Italy under the UIA flag. It's an official specialization course. So it's very good that we're completing it with people speakers such as you. So thank you, Jim. Thank you, Giovanni.
Thank you.
And we hope to be able to benefit of your expertise in future continued education events for the UIA.
And Carlo, thank you for all you do with the UIA on really promoting the education and really understanding of laws outside each of our home countries. And really through the UIA, we've been able to build a network of resources that we can reach out to when we're dealing with laws of countries and jurisdictions with which we're not familiar. And to navigate the complexities of global business is really made a lot more simple through the resources of the UIA and people like yourself. So thank you.
Okay, thank you. So now we're getting videos back, so faces are back. People are now relaxing, and we are going to enjoy the evening. Thank you to everyone. And of course, we're going to have Brazil tomorrow. By the way, we start at 10 a.m. CET, which is 6 a.m. Brazilian time, with Eduardo. Eduardo Lorenzetti is going to keep us engaged on Focus Brazil with a colleague of his, Professor Vicente Bagnoli. So we're going to adjourn and meet again tomorrow at 10 a.m. Italian time. Thank you, everyone. Enjoy
Eduardo is a good friend, so don't miss Eduardo. Yeah. Right.
Okay. Thank you to everyone. Enjoy the Friday evening.
Bye.
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 Ciao a tutti.
Bye, thank you.
Ciao.
Arrivederci. Ciao a tutti, grazie.
Arrivederci, grazie.
Saluti a tutti.
Ciao.